Can you please look up this site?
See if we can figure out something.
Good morning, afternoon for those in the same time zone or similar time zone. Did I just get, for the first time ever, oh wow, would you look at that? This has never happened before. I just got a notification on my other account that I'm live. That has never happened. Morning, Steve. You were super early. Morning, Jen. Just got to feed my kids, take them to summer camp. Oh, nice. My phone isn't charging. And it didn't charge last night either. And then it did a little bit this morning. Oh, for goodness sake. Sorry. 1 minute. I have a new trial. It's old. It's not like happening right now. But I think that's the way that I like to do it because it's the easiest way for me to, 1 sec, sorry. Okay, now it's charging. It's the easiest way for me to know that other people won't be covering it or haven't already covered it. Because these are ones that I have stumbled on, haven't watched much of. Some of them I've bookmarked for members only lives, which I need to figure out when is the best time to do that. But this one is a road rage one. Did I put that in the thumbnail? I don't remember. Before we do that, present, share screen. Ta-da! I am so close now. Like, 291 subscribers away. Thank you, Steve. I'm in disbelief. Like, the growth has been insane. It is absolutely crazy. Am I right in saying that Recovery Addict's not going live today? Because I might be able to let this trial run. Only thing I need to figure out is audio. I'll figure it out. It is a 6 hour, not a 6 hour, 6 hour, followed by I think another 6 hour. Yeah, no, 6 and 8. So I've got $14 hours of trial. 1 sec. Right. Not sure. Okay, let's go. We're going to do this and we'll figure it out. I'm going to be in a call from 2:30. So I might not be able to redirect, but I can always just click over and end. All right, we're all going into this with about as much info as each other. I know nothing. You know nothing. Unless you've seen this. The results will be out there, but Everybody try avoid Googling it. I need to put myself in the bottom corner rather. Look at Epstein just showing up everywhere again. Why is he showing up so much? Oh. Okay, first things first. This is Judge Scott McAfee in Fulton County, Georgia.
Mr. Bridges, we pulled the plug. So we're looking at Thursday morning instead.
That's fine, Your Honor. I get the opportunity to watch you all this morning. So
Sure. We just wanted to get your heart rate up. Keep an eye on those emails though, yeah.
So they've got captions on, and I got captions on because I was worried that my disclaimer is going to cover theirs. If it gets annoying, just let me know. I didn't turn off.
Y'all can have a seat. We're standing for y'all.
President, Judge.
All right. Thank you, Deputy Scott. Welcome back, members of the jury. Thank you so much for being on time. I think some of you actually beat me into the office, and apologies for the somewhat delayed start. We thought someone was still running late, and we had to do an audit and make sure all of you were here. But now we are here, and we're ready to get started. And so the first thing we have to do, now that you are the lucky ones that are going to be with us this week, we have to give you another oath that formally makes this a sworn jury, and we can get started. So if you could, stand if you're able and raise your right hand again. You shall well and truly try the issue formed upon this bill of indictment between the state of Georgia and McKinley Johnson, who is charged with 7 offenses, including murder, felony murder, and the other offenses that were outlined to you before, and a true verdict give according to the evidence. So help you God. If so, say, I will. Thank you. Please be seated. All right, a few preliminary instructions again to give you a roadmap of what we expect in the days ahead. First thing is that there are no assigned seats in the jury box. You can sit anywhere you'd like during the trial. If you need anything while you're in the jury room, you can of course let Deputy Scott or one of the other deputies know. And as I had mentioned to you yesterday, please keep track of those juror stickers when you're out at lunch or whenever you're just even around the building, so that anyone associated with this case, with the exception of the courtroom staff, knows that they're not to talk to you whatsoever during this trial. You've all been provided with pens and notepads. A few thoughts on those. You may take notes, but you're not required to. So please do not let your note-taking distract you from paying full attention to the evidence and the witnesses. You may not share or discuss your notes with anyone until you start deliberating at the end of the case. Notes are not evidence. They are only memory aids. They are not more important than your own impressions or memory of what the evidence may have been. While you may consider another juror's notes to refresh your memory, you should rely on your own memory of the proceedings. You must leave your notes in the jury room except when you are here in the courtroom. And these notes are going to be destroyed at the end of deliberations. This is very important. We introduced you to the court reporter yesterday, but you will not get a transcript of any testimony in this case. So you have to remember what each witness says as they come to this witness stand in a way that's best for you, because all too often, once deliberations start, we get a request from the jury to say, can we get a transcript of witness so-and-so? We can't do that. And so each time a witness testifies, that's your one opportunity to pay attention, to make your impressions, and to remember what they say. So before we start, I'm going to cover some basic principles of criminal law, explain everyone's role, and describe how this trial is going to proceed. The defendant has pleaded not guilty to the indictment, and he denies every charge in it. This indictment and the defendant's plea of not guilty present the issue that you have been selected and sworn to decide. The indictment is the way the defendant is charged with committing crimes that violate the laws of Georgia. The charges in the indictment and the plea of not guilty are not evidence of guilt, and you may not conclude that the defendant is guilty based on the charges or the not guilty plea. The defendant is presumed to be innocent until he is proven guilty. He begins the trial with a presumption of innocence in his favor, and this presumption stays with him until it is overcome by the state with evidence that convinces you beyond a reasonable doubt that the defendant is guilty of the crimes charged. The defendant has no burden of proof at all, and the burden never shifts to the defendant to prove his innocence. My role is to determine the law that applies to this case, and then I'm going to instruct you on the law that must apply to the facts in reaching a verdict. I'm giving you some of those instructions now, but I'll give you much more detailed instructions at the end of the trial. You as the jury have a very important role. You must decide the facts of the case from the evidence presented, and then apply the law I give you to those facts. Evidence is how a fact is proved or disproved. Evidence can be either testimony or exhibits. Testimony is what you hear from the people who take the witness stand and swear to tell the truth. However, the questions the lawyers ask the witnesses are not evidence. And as the fact finder, you are the exclusive judge of a witness's credibility. And it is your duty to believe the witnesses whom you think are most believable and to determine what testimony you will believe. Exhibits are documents, photographs, and other physical items admitted during trial. The object of this trial is to discover the truth. And during the trial, I will admit evidence according to the rules of evidence. Those rules are designed to aid in discovering the truth by making sure you consider only the best and highest evidence. The lawyers are advocates for their sides, and they have a duty to represent their side to the best of their ability. They must follow the rules of law, trial procedure, and evidence during the trial. They may make motions or objections if they believe that any rule is not being followed. What the lawyers say in making or responding to objections is not evidence. I will admit or exclude evidence according to the rules as I understand them. If the lawyers make an objection and I overrule it, that means the evidence is admitted and you can consider it. On the other hand, if I sustain an objection, that means the evidence is excluded from the trial and you may not consider it. You should only consider the evidence and the testimony and the exhibits that are admitted. You should not assume or infer anything about evidence which I have excluded. If you happen to see or hear evidence that I end up excluding from the trial, you must disregard it entirely in your deliberations and in arriving at your verdict. None of my decisions and nothing I say during the trial are evidence. My decisions and remarks do not mean that I favor or lean to one side or another in this case. I'm only interested in seeing that this case is fairly tried based on the laws and Constitution of the state of Georgia and the Constitution of the United States. Sometimes I may need to deal with lawyers' motions or objections without you being here in the courtroom, so I'll excuse you to the jury room. We'll try to limit such interruptions, and we ask that you please be patient when they do happen. And all too often, that happens when we come back from lunch or sometimes first thing in the morning. You'll have been here right at 9 a.m., but something comes up that we need to address before we can bring you out. So just know that when you're in the jury room, more often than not, we're out here working on the case as well. So again, we ask for your continued patience throughout this process. Here's how a trial proceeds. First, the attorneys may give what are called opening statements. No attorney is required to make an opening statement, and opening statements are not evidence. They're simply an introduction to the evidence, a preview or outline of the expected evidence. The state goes first because they have the burden of proof. After openings, the evidence will be presented. And then at the close of the evidence, the attorneys may give closing arguments. That's where they discuss the law that applies to this case and how you should consider the law in light of the evidence. They may also point out evidence that they believe supports their position. What the lawyers say in closing arguments is not evidence. The goal of closing argument is to persuade you to decide the case in their favor. After closings is when I explain the specific law that applies to this case. Then I'll ask you to go to the jury room, deliberate, and reach your verdict. It's important that you pay close attention during this trial. If at any time you cannot hear or see any evidence or you're suffering from any discomfort that distracts you, please let me know, and we'll do what is needed to make sure you can hear and see the evidence and give it your undivided attention. If you need a break at any time, please raise your hand and let us know. You should consider this evidence with an open mind and not reach any final conclusions until the trial is over. Don't jump to conclusions until all the evidence is presented. To maintain the integrity of the jury system, I have to remind you that you must decide this case based only on the evidence admitted during the trial and the law as I explain it to you. You may not conduct any research on your own about this case or about any people or places mentioned during the trial. You may not visit any of the places mentioned in the evidence, and you may not refer to any books or documents that were not admitted during the trial. You can't use dictionaries or reference materials. You can't use Google or otherwise search the internet, websites, or blogs. And you can't use any other electronic media to get information about this case. Nor should you use any of those sources to get information about legal terms or the law. And I emphasize this instruction as much as I can, that anything that you know about this case has to come from this courtroom and this courtroom only. Otherwise, all the work that you're doing this week may be for nothing, and we jeopardize everything we've done this week. So remember, you're the ones that have been qualified as fair and impartial jurors deciding this case. No other influence should affect your decision. And so for that reason, you're not to discuss the case with anyone, and that includes family and friends, or let anyone discuss the case with you or around you. That means sharing anything electronically, email, texting, blogging, or any form of social media. Until actual deliberations begin, that means after you've heard all the evidence, after closing arguments, after I instruct you on the law, that's when you can discuss the case, and not before then. And that's when you do that. That even means amongst yourselves in the jury rooms at lunch today, for example. So with those instructions, we're now ready to begin opening statements. Mr. Lee?
Yeah.
Good morning, everybody.
Good morning.
Yeah, my name is Jeffrey Lee, I'm the lead prosecutor in this case of Georgia versus McKinley Johnson. Joined by my legal assistant, Mr. Fulton Wright, and Mr. Thomas Griner. I think I called him Joiner yesterday. That was a slip of the mind. John Joiner is the DJ. I used to listen to that. Got a picture up there of a campfire. I want to ask you just a few questions about it. Okay. If someone's camping in the woods and they set a fire, who's responsible for putting it out? Okay. If that fire gets out of control, let's say a tree catches on fire, what's that person's responsibility then? And let's say that same person, he puts wood on the fire, gas on the
I'm gonna
fire.
object. This is argumentative. It's not.
I don't think it's gotten there quite yet, Mr. Ryan. Overruled.
And he's putting gas on the fire. What does that say about that person's intent with regard to the force? Okay. That example is analogous to what we have here, okay? Because on February 21st, 2023, in your county, this defendant initiated a chain of violent events that escalated. And when it escalated, he did nothing to stop it. Instead, he participated in it, perpetuated it, and that led to the death of Mr. Richard Antoine and the aggravated assault of Mr. Wayman Lot. Now, this is a road rage case. Go back for me. The person in the skull cap, that's McKinley Johnson. There's high definition video. It's gonna look better than what you see there. But that person in the skull cap, that's McKinley Johnson. The man in the yellow shirt at the driver's wheel, that's Mr. Richard Antoine. Wayman Lot is sitting beside him. You can't see him here, but you'll see him when you see the surveillance video. The van had video inside the van, an interior video and an exterior video. Okay. That person holding the gun, that's Antonio Spear. Okay. Now, today, we're trying the case of state of Georgia versus McKinley Johnson. Okay. But we have to talk about Antonio Spear because Mr. Johnson and Antonio Spear They committed this crime together. They were working together. They were acting as a team with a shared goal, with a shared criminal intent of assaulting and terrorizing Mr. Richard Antoine and Mr. Wayman Lot. Now, in Georgia, we have a legal term for that, okay? It's called parties to crime. It's a law of accountability and choice. And basically what it says is that when two people commit a crime together, okay? And they either help in the commission of that crime or encourage the commission of that crime, then they are responsible for the actions of the other person. Okay, whatever one does, they all do. Okay, the evidence is going to be that Mr. McKinley Johnson, he didn't fire a gunshot. That's inconsequential. They were working as a team. They were in this together. They, whatever one does, they all do, and they share in what results. They share in the consequences because they started this together. So what happened? Mr. Antoine, Mr. Wayman Lot, they're working, okay? They work for Rogers Mechanical. They do HVAC and plumbing work, okay? And they're driving to the next job. And they're traveling on Flat Shoals Road, Flat Shoals Road in the city of South Fulton. And they come up on an intersection. Now, this is how it ended with Mr. Antoine getting shot in the neck. And this was the end result. Mr. Antoine died. So they're traveling down Flat Shoals Road. Mr. Antoine is driving. Mr. Lot is the front seat passenger. They're driving the left lane. There's a car in front of Mr. Antoine, so he gets over into the right. Okay? And when he does that, he slows down at the intersection, and he's looking behind him. Something caught his attention behind him, so he's not traveling through the light at a speed he's supposed to. He slowed drastically down. Okay. Mr. Johnson is traveling in a gray Dodge Charger that's actually owned by Miss Taisha Ponder, but Mr. Johnson is driving. Okay, I want y'all to remember that. He's driving, okay? Antonio Spear is the front seat passenger. Taisha Ponder and a friend of hers, they're riding in the back seat. So Mr. Johnson swerves to avoid hitting the van, okay, that Mr. Antoine's driving. And then he pulls to the side of the van, and Mr. Johnson and Mr. Spear, they start arguing with Mr. Antoine about, why would you stop at the light? Okay. And Mr. Antoine, you'll see he's smiling and apologizing. I'm sorry. Okay. But for whatever reason, that apology is not good enough for Mr. Johnson. So here we go. Mr. Johnson lights the flame. Okay. This whole thing gets started because of him. Everything that happens after this, if he just keeps on driving, none of this happens. but he doesn't keep on driving. What he does is he cuts his vehicle in front of the van, blocking Mr. Antoine. He gets out the van. Mr. Spear is closely behind him. Mr. Johnson gets to Mr. Antoine's window first, and he starts beating the crap out of him. Boom, boom, multiple times, just punch him, just punch him, just punch him. Okay, Mr. Lot, the passenger, he unbuckles his seatbelt. He's intending to help Mr. Antoine. But fire burns out of control because what happens is a gun gets introduced. Okay, this went from a senseless beating to a senseless, potentially deadly situation because a deadly weapon is now presented by Mr. Spear. So Mr. Spear approaches with the gun and he points it into the van. So now Mr. Antoine and Mr. Lot are being held at gunpoint. Okay. So now Mr. Lot, you know, he's not helping anybody now. He's like this, he got his hands up. Okay. Mr. Antoine is still getting the crap beat out of him. Johnson fans the flames because when that gun is produced and it's escalating, Mr. Johnson doesn't stop. He keeps going. He keeps beating. He keeps beating him, okay? And then Johnson, he takes a breath. He walks away, not that long, for about 3 seconds, okay? During those 3 seconds, Mr. Spear, he still has the gun, still holding them both at gunpoint, okay? And he actually starts trying to rob Mr. Antoine, you know, demanding money, okay? He throws gas on the fire. Mr. Johnson does, okay?
Check the poll, please.
So now, he comes back, Mr. Johnson, 3 seconds later, he comes back and he pushes Mr. Spear out of the way. And don't get it confused, okay? He's not, you know,
I'm gonna
pushing
object.
him out the
This
way.
is
Mr. Lee?
argumentative.
Sustained at this point. Members of the jury, with this instruction, the purpose of opening statement is to inform you of the nature of the case and an outline of the proof a party anticipates presenting, a preview of the evidence. I remind you that opening statements are not evidence. And it's with that instruction, Mr. Lee, you can continue.
Yes, Sean. So what you'll see on the video is Mr. Johnson pushes Mr. Spear out the way and immediately starts punching Mr. Johnson again. Punching Mr. Antoine again. Okay? Punch him multiple times. Okay? Now, so then when Mr. Johnson is finished punching him this second round of time, Mr. Spear immediately starts hitting Mr. Antoine with the gun. He's pistol whipping. Okay, over the head with the gun. Okay, Mr. Johnson is standing right there with him. Okay, that's what you're going to see in the video. That's what we expect the evidence to show. Mr. Johnson standing right there with him. In fact, when he's hitting him with the gun, Mr. Johnson still has his hands in the car towards Mr. Antoine's steering wheel. Okay, and then Mr. Johnson walks away. Okay, when he walks away, Mr. Antoine sees an opening. He tries to drive away. Mr. Spear fires a shot in the car and strikes Mr. Antoine. It actually strikes him in the shoulder, goes in and out of the shoulder and into his neck. And then he bleeds out. Okay? Now, while Mr. Antoine is bleeding out, okay? Johnson, him and Mr. Spear and the two ladies in the car, they drive away. None of them call 911. Okay, you're gonna hear from Marcus Traylor. He He's the custodian of records at the Fulton County 911 dispatch center where the calls come in that area. He's gonna say they received 2 calls, and not one of them was from Mr. Johnson or anyone in the car he was driving in. Okay? Taisha Ponder is her car. She spray paints the car, trying to disguise the car. She spray paints the car. All right. So here's how the investigation starts. Police respond. Detective Erica Allen, she's assigned as the lead detective. She interviews Mr. Lot. She learns that the van has surveillance video. She collects that. And there's license plate readers on flash shows as well. One of those license plate readers captures Miss Palmer's tag during the time of the incident. Now they have a tag number. They put out a lookout to other officers to be aware of that vehicle. She's pulled over on a later date, and she's interviewed, and she identifies Mr. Johnson and Mr. Spears as the people that were in the car with her. Okay. And Mr. Johnson and Mr. Spear, they're arrested on March 1st. Yeah, this happened February 21st. They stay gone to March 1st. Okay. And so based on Mr. Johnson and Mr. Spears' joint efforts, their teamwork, they were charged with these offenses: murder, felony murder, 3 counts of aggravated assault, 1 involving Mr. Wayman, 2 involving Mr. Antoine, battery and possession of a firearm during the commission of a felony. Again, they did this together. Parties to a crime. And when you're considering whether or not they're parties to a crime, I want you to consider what happened before this incident, during the incident, and after. Now, I'm going to sit down shortly. This won't be a long trial, okay? I may even put up all the witnesses today. But please don't let the length of this trial, it does not correlate in regard to its importance, okay? It's just that this isn't a big whodunit kind of case. So I ask that you pay close attention to it, listen to everything critically. And when all the evidence is presented, I'll come back before you and close an argument, and I'll ask you to render a verdict that speaks the truth. And that is that Mr. Johnson is guilty of every single thing he's charged with. Thank you very much.
Mr. Wright, does the defense intend to give an opening statement?
We will, Judge.
Whenever you're ready.
Your Honor, if it'll please the court, counsel for the state. Ladies and gentlemen. I'd like to start opening arguments by giving you some suggestions on your role as a jury. Start this case, if you can, by taking emotions, your passions, and sort of put those to the side. Put on your fact finder gear. You want to determine what happened, how it happened. It's easy when we have serious cases like this to get emotional. There is loss. It's a terrible situation for a family to lose someone this way. We know that. But your job is to determine the facts. And I think you sort of have an idea of what that's going to be. My client, Mr. Johnson, act as a party to the crime with the shooter in this case. That's essentially what it's going to come down to. Now, you saw little clips and you're going to see more. I suggest the before, during, after becomes very important. Before, you're going to hear that the reason these 4 people were together, 2 girls, the 2 guys, So they had just gotten off work. They were headed home, and unfortunately, traffic situation happened at this light. That was the spark. Doesn't all of a sudden a fire that was lit by Mr. Johnson, but a fire that was lit by people getting off work, tired. And all of a sudden, an accident almost happens. It wasn't just that the car had stopped at a green light in this intersection, but because of it, Mr. Johnson almost hit, driving someone else's car, almost hit that car. Had to actually swerve to avoid. So the facts in this case are going to show, yes, there was temper. There was anger. And my client got out the car intending in a 24-year-old mind going to have words or even put a little beat down on this guy. Because look what just happened. Look what you just caused. Why were you sitting in the middle of this intersection like this? So that wrong, the simple battery, admit that from the very beginning. That was his intent. But what you won't hear is not any evidence that there was discussion with Mr. Spear, that there was a plan to rob, or a plan involving a gun, even knowledge of a gun. Don't assume facts. The gun that Mr. Spear had was a small little weapon that apparently he had tucked in his pants somewhere, to the point where no one at work knew, no one in the car knew. And in fact, you'll see him getting out the car, reaching deep down into his pants to get a small weapon. You'll see on the video, you'll see him holding a very small caliber weapon, something that is not obviously visible to anybody. But what you're not going to hear is anyone saying, oh, Mr. Johnson, Mr. Spear, they said they were going to do this. They said they were going to shoot this guy. They said they were going to rob this guy. Nothing. All you have is a traffic almost accident, anger's flare. Mr. Johnson gets out. He goes over there by himself. He's not, oh, I got a guy with a gun, so I'm going to go over there with the guy with a gun. He goes over there by himself and starts having words with both the passenger and the driver, and then ultimately starts punching. And you'll see he's not Mike Tyson. He's not very good with the punches. You're going to see a lot of these punches are missing. Probably that's adding fuel to the fire. You're trying to punch someone that just almost got you in an accident, albeit wrong, but you're also missing. Unbeknownst to him, the other passenger in the car, Spear, gets out the car. Didn't ask Spear to get out the car. Wasn't planned with Spear to get out the car, but Spear gets out the car. But what's worse, Spear has a gun. And he brings a gun to what is already a wrong road rage fight, like we heard in jury selection. Road rage fights. But now all of a sudden a gun is being brought. And while the state characterized it, when you see the video, I think you'll see my client, after throwing punches, realizing all of a sudden there's a gun being pointed, pushes Spear away. Not, hey, come on, we're in this together. Hey, come on. No. We don't need that. What are you doing? This is I'm just putting like a young kid, unfortunately, thinks. I'm confronting this situation. Now, you're going to see the video, just as the state says, Mr. Johnson comes and goes, but so does Mr. Spear. At first, it seemed like Spear goes back to the car, and the gun and Spear have been de-escalated by Mr. Johnson. I would contend that is something you'll see that is inconsistent with being a team and having a team objective, but is consistent with someone saying, hey, I'm having this issue. We don't need that. But Spear comes back. And at that point, when Mr. Johnson realizes Spear is back, he stops punching again and he leaves. And when you see Mr. Spear shoot, he's by himself. My client's not helping him. My client's not helping him aim, pointing, saying, shoot this guy. My client is walking back to the car, and because this is such a small caliber weapon, the question you're going to look for is, does he or the other passengers even hear the gun go off? The state would love for you to assume they even knew that the shot was fired. But everyone gets in the car, they leave. And then eventually the investigation starts. This is why we have trials. Because different people can look at different things, come to different conclusions, but now your role is to look at the things presented to you and demand that there's actually evidence to support anything that you deduce or choose to determine as a fact. Evidence because someone at this chair said it. And they said it with personal knowledge, not hearsay. They're not guessing, they're not speculating. But what you're not going to hear is that before this car incident, there was some plan to go do some bad act. Let's go find somebody. Before, there's no evidence of a team, of a plan. During, there's no evidence of anything other than an almost accident. And yes, my client lost his temper. You're going to see that from the video. But you're going to see he's doing what a young kid who's lost his temper is doing. He's throwing punches, flailing away. He's not armed. He's not trying to escalate this. And then after, I expect you're going to see that he's always acknowledged. Hey, I was wrong for punching the guy. I get that. But shooting, killing, murder? That's Spear. That was Spear's role. That's what Spear is on the hook for. Not me. So what this case is about is they want to make this a team. And I'm suggesting to you, the defense is simply going to suggest this was not a team effort. This was a guy my client had only known for 1 or 2 months, gets out the car with a gun he didn't even know he had, and acts a complete fool and does something terrible. My client did some wrong, but he's not responsible for that. And you're not going to have any evidence where you're going to be able to say, hey, he knew that guy had a gun and he knew he was going to shoot him. He knew he was going to take this to that whole other level. Because that's the kind of evidence you're going to need for you to convict. I expect you're going to convict on battery. That's a strange thing I know in opening to concede it, but you know, it's the truth. But not murder, not felony murder. There's no felony that my client did or conspired with someone to do. And that's what this trial is going to be about. Hold people accountable for what they did not what the state wants to tell you they've done, but rather what you have evidence to support a verdict. So you know, hey, the right person is being held responsible for what they did. That's all the defense is going to ask you to do. And with that, I expect it day and a half, and I'll come back and I'll show you where, remember the roadmap I told you, roadmap the state told you. The before, during, after. Where's your evidence? Where's your evidence of an agreement? Where's your evidence of knowledge? And when it's not there, you're gonna say, I hate that this happened. But my duty as a juror is to follow the law, and therefore I must quit. Find him not guilty. Thank you.
State may call his first witness.
They call one.
Okay, before we do that, I'm about to crack on with focus time. And at 2:30, I'm going to be in a call, so I'm going to need you guys to behave. And mods, if you can't be here, please let me know. I can end and we can go to another time. Doesn't bother me. Let me catch up on messages. Hey, Misty. I'm so glad you feel safe. If you ever don't, just send me a message on Instagram. I'll deal with it. Good day. I was just on the line with Sydney yesterday. My family lives there. My brother, sister-in-law, and niece. And we were looking at flights, and they seem awfully cheap at the moment. So I don't know what's going on with the old Oz there. Misty, this is funny. So I have another YouTube account that I set up notifications for. Today was the first day ever in the history of me having this channel. This channel, I think I started in 2019. This was the first time ever that I've got a notification, ever. Lilith, I don't even know if I was listening now, to be honest. I heard this, though. He's not very good at punching. I didn't think I was not listening, but now I'm like, oh, wait, was I? Angie, do you think it would be one that we could rewatch together, or is there stuff that's likely to be flagged? If there's stuff that's likely to be a problem, we could potentially do it. So the reason why I'm being so hectic now is because until I surpass the 1,000, I need to be extra cautious. Just like keep my side 100% clean, etc. My neck is so stiff today. I need a new pillow, and I'm very picky with pillows. And no, this was for November, which is weird because I went to Sydney last year. I don't know. I have a whole Australia vlog. If you go to my videos, it's not in lives. I went, it was August or September time, and it was so freaking expensive. I have never felt so broke in my life as I did in Australia. Like, actually, Australia and Switzerland, both. Oh, good point, Steve. Okay. Angie, if you can let me know if you think it's okay. Because it'll be fresher in your mind than mine. It is also a possibility that I could edit out certain parts. So if there's like ideally with this one, I would have taken out some of the pictures. But I thought it would be faster to make a playlist called Potential Trials and just stick them all in there. And then, like, if I wanted to edit them, put them in a playlist called Court to Edit. And I didn't do it with this one. So I guess here we are. You're all going to have to behave seriously, though, because the mods shouldn't have to work on a holiday. Evie, it's not a holiday there, though, right? Okay. Happy Independence Day, Americans. Happy Freedom Day. I pledge allegiance to the flag, United States of America, and to the republic for which it stands, one nation. Not a lot right now makes sense to me. I watched Cinderella Story way too many times, and that's why I only know that part until it goes to not a lot right now makes sense to me. Waiting for you is like waiting for rain in this drought. Useless and disappointing. Like, how do I remember these lines, but I don't remember a phone number, or I don't remember what time I took my tablet, or let's get back to court. You guys are kind of tempting me to go to pause this. No. Let's not. Also today is Vaughn and my anniversary, so the joke has always been like Independence Day, we lost our independence. Don't worry, we're very independent, but it was funny because 4th of July. And we started dating. We became official when I was DJing, and one of the songs at that moment was Katy Perry Firework. I just remember it being like 4th of July, and then we were like, oh, that's our anniversary. Thank you. 9 years. 9 years. Okay. Guys, I can't do Daryl Brooks until I know if it's safe. Is this one interesting or is it boring so far? You have 7 minutes to make a decision. Let's also see who has the trial, because if it's people who just strike for funsies. Fox is pretty good at understanding, like, listen, I'm not a Fox News kind of girl. I'm very much a objective news kind of person, but they don't strike. They understand copyright 107. How far back is it? Gosh, it must be way back. Love a channel that does playlists properly. I've got it. 62 videos. None of them in order. Are there? Or did they do day 5, day 6, day 7, day 9, day 11? Wait, this is a mess. Their playlist is a mess. Seems fun, like defense has a good argument. Happy codependency day. Yeah, it's mostly just that by the end of the day, he doesn't feel like peopling at all because he has a lot of calls for his job. I generally don't have many calls because I work better, not like solo, but like context switching is hard. Okay, so we're going to stick on at this one, and then I will try and figure out, Angie, if you have a playlist that you're watching. I actually just need to start adding my Instagram thing to the whole thingy. You can send it to me on Insta. If I take some time, please understand that I'm not an Instagram person that much. And your message may land up in requests. Because at the moment, I go in, check my mods are alive, and then Lilith, unfortunately, they're the strike happy ones. They don't understand. Even lawyer, is like, they don't understand the legal. So annoying. Because I am allowed to, like, literally, as you can see scrolling at the bottom, I'm allowed to. I only see that one playlist and it's so messy. Day 13, day 12. I might have to. Yeah, I see theirs is. Ideally, if I can get one of the foxes in a playlist, that'll be best. Okay, guys, I'm going to turn off my camera. I'm going to be listening for a bit and then working. Please be kind to my mods. Mods, if you set up a buy me a coffee thing. Did I share the link before? Oh, you can go. There's a link to buy me a coffee in my description. If you set up your own one, let me know and drop it in chat. And nobody's under any obligation, by the way, to either set it up or to send the mods coffee. But obviously, it would be appreciated if they're doing it for me.
Oh, Wayman Lot.
Oops, wrong one. Pause.
Yeah, I don't think I did before, but I just invoked the rule.
All right. To all the attorneys and anyone present in the gallery, if you are a witness in this case or have been subpoenaed in this case, you're expected to remain outside of the courtroom, except when you are personally called to testify. And for counsel, I'd instruct you to tell your witnesses that they're not to discuss the case with other witnesses until the evidence is concluded or until they've been excused from their appearance. And I'll ask the parties to assist me with enforcing the rule of sequestration here.
Raise your right hand. You swear affirm that the testimony shall help you. Good. You may proceed. Please state your full name and spell it for the court.
My name is Wayman Lot. Spell it WYMANLOTT.
Mr. Lot, good morning.
Good morning.
Mr. Lot, where do you work?
Rogers Mechanical.
And how long have you worked there?
Since for about a year, since last Halloween.
Okay. And were you what does that company do?
We do HVAC. We service HVAC and AC systems.
Did you know someone by the name of Richard Antoine?
Yes, I work with him.
Did you work with him back on February 21st, 2023?
Yes.
Did he do the same kind of work that you did?
Yes.
Now, do you read? I'm taking you back to February 21st, 2023. Okay.
Mhm.
Do you recall an incident where Mr. Antoine was shot?
Yes.
Okay. Were you aware that there was video of that incident?
Yes.
Okay. And may I approach the witness, John?
You may.
Showing you what's been shown to counsel and marked as Stakes Exhibit 3. I want you to take a moment and look at the front and back of that envelope. And I want to ask you if you recognize that.
Yes.
Okay. How do you recognize it?
Y'all brought it to me and I watched it.
Okay. Did you mark on that?
Yeah, and I signed it. Yeah, I signed my name, my initials right here.
Okay. And what exactly is on this CD?
The shooting of Richard
Wait,
Antoine.
hold up.
Um,
Objection?
My objection is it's not been authenticated and going into the subject matter of its contents without at least first authenticating and getting it admitted, it starts to essentially play it before it's a cart before the horse in terms of admission.
Sure. No, I think the question is just what is on it, and if he's speaking at it at a high level and not going into detail, I think that's the only way you can authenticate something. So overruled on that point, Mr. Lee.
And so your last answer, what's on the CD?
The shooting of Rich Antoine.
Okay, and did it? And just in case I forgot to ask, did you witness the shooting of Mr. Antoine?
Yes,
Okay. And what's on this CD? Does that accurately reflect what you witnessed on February 21st, 2023?
yes,
Does anything appear to be altered in any way?
no,
At this time, the state seeks to admit State's Exhibit 3 into evidence.
Objection?
Objection, it's not been properly authenticated. There's been no testimony as to his duties, his ability to maintain the video equipment, that it's recorded, that it's in fact the recording, the authenticated, true and correct copy. He may say, hey, I've seen stuff on it and it may seem, like it captures stuff to me, but it's still not an actual authentication of this video of how it was recorded, that it was accurately recorded, that it's not been tampered, altered, deleted, elongated. Any of that kind of information has been established to authenticate it.
Okay. All right. Well, the testimony from the witness that I just heard is that he was present during the events depicted, and that in his opinion, it was a fair and accurate copy. If you'd like to voir dire him on these points, you can, but otherwise, I think that the authentication has been established.
If I briefly, Judge.
Sure.
No problem. Good morning, sir.
you want.
If I could, a few questions as it goes to the video recording equipment in your vehicle.
Mhm.
Are you responsible for the maintenance of that equipment?
No, the company is.
Okay. Do you have any role in making sure that whatever's recorded is in fact a complete copy of the recording?
No,
Deputy Scott, if you could escort that person out of the courtroom. Or there's-
Are you?
We don't have just a moment, Mr. Wright. All right. Mr. Wright.
So I think we just established you're not responsible for how the equipment records different things, correct?
no, yes, I'm not.
And that is done by someone at the company.
Yes,
All right. Now, while I know you've seen what's on that particular videotape, have you watched it from beginning to end and compared it to what is beginning to end from an original copy at the company?
no,
Okay. Can you state, and again, I know I'm asking questions, but can you state whether or not anything has been omitted, deleted, changed, added, if multiple cameras were used to generate the video? Do you have any knowledge of that?
I know we got a camera on the outside, but I don't have no knowledge of that. We got one inside and outside.
And were you aware whether there were not cameras inside and outside?
Yes,
As to how that exhibit number 3 was made, do you know whether footage was taken from different cameras?
no, I just know it wasn't taken from the back because we got a camera in the back that showed the back. Everything was taken from that front camera, the front one that caught them on tape.
Okay. And from where that starts, do you have any personal knowledge as to whether that's the actual beginning of the recording?
What you mean?
Meaning, is it recording nonstop when you're
Yes.
in the vehicle?
So when we turn the key, the camera come on.
Okay. Well, on number 3, are you seeing it come on when the vehicle actually gets turned on? Or is it just seem to start at a certain point?
It just started at a certain point.
Okay. So that means,
But it starts, but they watch it all the time, but they don't really. It's always recording, but they don't watch the video now unless something happens or you get into an accident.
okay. But as to that exhibit number 3, I think you said
Your
it's,
Honor, I'm gonna voice an objection at this point. I'll allow counsel to go as far as I can, but the statute is clear that there are 2 ways to authenticate video.
I think I understand your argument, Mr. Lee. Mr. Wright, I think we're getting beyond just whether Exhibit 3 has been authenticated. And so you may have other points to make on cross, but as it relates to Exhibit 3 and Exhibit 3 itself and what's on it, do you stand on the argument of your original objection?
I'll still stand that I just don't think it's been authenticated by someone in control of the equipment, in charge, and by his testimony, it's not a complete copy. And therefore, I would object to its submission.
All right. I'll overrule the objection. I think it's been established that the object is what it purports to be, and those arguments go to the weight that the jury is to give it, not its admissibility. So, Mr. Lee, back to you. Exhibit 3 is admitted over objection.
Permission to publish?
You may.
Doing it, so I don't know why that is. We play videos in here all the time, and I'm using the same process I always use. I don't know if that's related to recent issues or not, but I just asked for a moment to try to get this video done.
All right. Let's give it another minute. Try the other laptop if we need to, but if we can't get another minute, we'll take 5.
And Mr. Lott, while that's playing, the top screen, what is that top screen showing?
Inside our van.
Okay. And the person behind the steering wheel, who is that?
That's Richard Anton.
Okay. And the person seated next to him in the red hat, who is that?
That's me.
Do you remember where you all were headed that day?
We was trying to find a supply house so we could go get more filters for the job we was on.
And Your Honor, there's about 8 minutes of video. I'm gonna skip it to the incident with the court's permission, if there isn't any objection.
No objection.
Just note the time marker you're skipping to for the record.
So we're currently at 1 minute, 15 seconds and skip it. Skip. All right, right there. We're at 6 minutes, 55 seconds, yeah. And you can stop right here. All right. Now, Mr. Antoine, I want to play I want to replay this video, but I want to play the top screen only, okay? And then we'll ask you some questions.
Okay.
Well. So, pause. Do you remember what's going on here?
Yes.
What is Mr. Antoine doing?
Mr. Lee, for the purposes of the record, each time you pause it, let's note the time marker.
Oh, apologies, John.
If you're doing, I assume you're doing a frame by frame kind of question and answer.
Yes, yes. And for the record, I'm playing from the CD. It's marked interior 1. The total length of the video is about 1 minute long.
This is a subcomponent of Exhibit 3.
Yes, young. And I've paused it at 15 seconds. Okay. What's going on here?
That's when they put up on the side of us. Rolling the window down, and Richard he rolled the window down to see what they were saying, and they was yelling stuff, man. He was basically just saying sorry. That's why he was waving his hand like that.
And let me back up a little bit, because I forgot to ask you. When you were approaching that intersection of Flat Shoals and Mallory Road, what happened? What was the road incident that happened that started all of this?
And it wasn't no road incidents. We We pulled up, we was trying to make a turn on, I think it was Mallory, and we couldn't turn because there was a car in front of us. So when the light turned and we went around the side of the car, but then when the light turned green again, that car started moving. So we started moving. I told him, I said, well, you might as well keep going because you can't turn right now because it was cars behind us. So we went straight. And that's when they came from behind us.
Okay, so let me make sure I understand. So Flat Shows Road, it's like a 2-lane road, is that right?
Yes,
Okay. And you all wanted to go left,
yes.
but you were unable to go left because there was a car
That had stopped or
that
something.
stopped, stopped in front of you.
Yeah.
So, Mr. Antoine, does he stay in the left lane or does he go to some other lane?
He stayed behind them for a few, it wasn't long, but then he went on the side of the car. Like he went on the right side of the car.
So he transitioned from the left lane to the right lane?
Yeah, to go around the car that was stopped.
Okay. So what happens when he goes from the left lane to the right lane?
I didn't know what was going on behind the truck.
Okay. But is he driving at a normal pace through the green light or is he slowed down?
It was normal.
So so he drives through the green light, and then what do you remember happening after that?
I remember we rode probably a few yards and the car came up on the side of us because I was on my phone and he said, hey man, I wonder what these guys want. And he rolled the window down and that's when they were saying with the I don't want to use no bad, I don't want to cuss, but
Whatever you remember them.
they were saying, what the fuck y'all doing? Stopping at a green light, oh, pussy ass niggas. And they were saying stuff like that. And then Richie was like, I'm sorry. And one of the dudes said, both of them was talking, but the passenger said, you think we playing with you? And then that's when the driver cut us off and they jumped out.
Cut you off. When they're arguing, and Mr. Antoine is saying, I'm sorry, what are you saying, if anything?
I'm not saying nothing.
Okay. I'm resuming from 15 seconds. State's Exhibit 3, Interior 1. Now pause. Now, what's happening here?
The driver ran around to the truck. He started punching Richard and the other guy. I guess when I took my seatbelt off, that's when he pulled the gun out.
Okay. So you led into my next question. We see that you take your seatbelt off. Why did you do that?
Cause I can't tell you why I did it. Was probably going to try to go help Mr. Richard, but I didn't want to be sitting in that van just like that where he had that, like, you know what I mean? Because I didn't know what was about to go down. So I was trying to defend myself or possibly defend Richard so we could get up out of there.
Okay. So, but we see from the video, you stayed in the car.
Yes.
Why did you stay in the car?
Because he had the gun.
So you saw the gun?
Yes.
Okay. Clear. Pause. Do you remember what's happening here?
At
And I
that,
paused it, I'm sorry, I paused it at 33 seconds. State's Exhibit 3, Interior 1 at 33 seconds.
at that point, the shooter was trying to rob us. Telling us, give us, like he was saying, give me your shit, give me your, but what you got. But Richard was saying he ain't had nothing.
Okay. And were you saying anything?
No, I didn't say, I wasn't, I was just looking at the guy with the gun.
Okay. Clear. Now, did you see a, black object fly from that gun?
I seen something, it came across his neck. I seen, so I don't know what it was. I don't know if it was the bullet, like the skin, his skin or what.
When the second time, when, Mr. Johnson pushes, this is after they're trying to rob you and, the driver comes back.
Mhm.
Okay,
Objection to the form of the question, facts not in evidence.
I think the question referenced a robbery, Mr. Lee, so I'll ask you to rephrase the question.
okay. You testified earlier that, that moment where the driver walks away, when we were at 33 minutes into, to 33 seconds into the video, that, Mr. Spear was trying to, or the person with the gun was attempting to rob you because he was saying things like, give me the money, words to that effect, right?
Yes.
Okay. My question concerns, when the driver comes, back. Okay? When the driver comes back, do you hear him saying anything to the person with the gun saying, hey, come
Objection
on?
leading.
Let's stop the question right there. Do you hear, you can rephrase it.
When the driver, comes back, do you hear him saying anything to Mr. Spear?
No.
Okay. Did it appear from what you observed that,
Objection calls for speculation.
He hasn't finished the question there. Mr. Lee, what's the question?
did it appear from what you observed that the driver was, trying to, stop Mr. Spear?
No. No.
Or excuse me, the shooter? Okay. And before I forget to ask, the person who you identified as the driver in the video, do you recognize him anywhere in court today?
Right there.
Okay, if you could, just, point him out and describe something he's wearing.
Black tie.
And, you're pointing at the defense counsel, the defense table?
Yes.
Okay. Please let the record reflect that the witness has identified Mr. Johnson as the driver.
The record will so reflect.
Now, after, Mr. Antoine Richard is shot, what happens next?
After he got shot, everything went quiet, and I asked him, I said, did he shoot you? And he didn't say nothing. He still was like calm, so that's why I act the way I act, because I didn't realize how bad it was. But then he touched his neck, and I seen blood. Then he put the car in, like he just put it in park, and he was just sitting there. And I asked him again, I said, he shot you? And then when I seen the blood, when I went around to the driver's side, I seen the blood shooting out of his neck while I was on that's when I went and grabbed something out the van and tried to put it over his neck while I was on the phone with 911.
And, so you kind of led into my next question. You called 911?
Yes.
Like, just have a moment, y'all. I want to go back to the moment that you saw the gun. Okay, you testified earlier that you had took your seatbelt off with thoughts of defending yourself or Mr. Richard.
Mhm.
When you saw the gun, how did that make you feel?
Fear for my life.
Why did you fear for your life?
Because when he put that gun on and the look on his face, like he had a crazy look on his face. I didn't know if he was high or what. So I didn't know if he was gonna shoot me. I didn't know what he was gonna do.
Okay. And when you put your arms up, why did you do that?
Just letting him know that I ain't have no weapon or that just basically trying to let him know I wasn't no threat to him at that time.
And when you called 911, how long did it take them to respond to you, think?
How long it took for the cops to get there?
Or whoever got there first?
I think I think they got there at the same time, but I think the whole phone call was something like, I think it was like a 4 or 5 minutes to 911 call.
And something I did. When Mr. Antoine was shot, I'm going back, I'm sorry.
Okay.
When Mr. Antoine was shot, did you hear the gunshot?
Yes.
How did that make you feel?
I was just shocked. Both of us were shocked.
So when 911 arrived, did you go to the hospital with Mr. Antoine?
No.
Okay.
When the cops and everything pulled up, I just walked away because I didn't want to see it no more because he basically died right. He died right there. So I didn't want to see it no more. So I just walked away.
And prior to the you called 911, correct?
Yes.
Did you receive any instructions on how to help Mr. Antoine?
Yes.
And did you attempt to do that?
Yeah, I tried to. I did everything that I could.
All right. When did you learn that he died?
I knew he was dead when they pulled off.
And did anybody confirm it with you, or you?
I asked the police, but they wouldn't tell me. But then the company, my boss came and he took me back to get in my van, and then somebody called him, but he still didn't tell me, but I could tell by the way he responded that they said he had passed away.
I don't have any more questions for you at this time.
Right.
Good morning again.
Morning.
Just a few follow-up questions based on some of your earlier statements. I know you said at some point you saw the shooter had a gun inside of the car. And that caused you, so almost instinctively, I guess, to raise your hands hoping that, hey, I'm not a threat, hoping not to be shot.
Yeah, because I didn't have.
Did he actually point the weapon at you, or was it looked mostly like it was on the driver?
Nah, he pointed at me first.
Okay, so it was at you first, then
Then he put
at
it
some
on
point
him.
on the driver.
Yes.
Okay. The second individual, the driver of the vehicle, you never saw him with a gun, did you?
No, I didn't know what he had.
And I think at the time when the guy with the gun was starting to ask questions as if he was going to start trying to rob you, he, at that point in time, he was alone, correct?
Yes.
Okay. And at the time that the shot gets fired, he was also, I guess the car had started to pull off, but he was sort of alone, slightly behind the car. Is that a fair statement?
No, he was standing, they were standing right beside, like, basically, like, he came back and started hitting him. And then that's when he shot him. So they weren't alone. He was standing kind of by him.
All right, so he was in the vicinity of the
Yes,
shooter.
yes,
A fair statement.
yes.
Okay. And were they back by, I guess, where the other car was, or were they, I'm just trying to.
No,
orient.
they was back by our truck. Their car was in front of our truck, and they was
Okay.
back by the window.
They were sort of in the back.
They were standing by the driver's side window.
Okay. And I think you said the driver of the vehicle I guess was already back there, and then the shooter ends up going back that way and then shoots. Is that when the shooter, right before he shoots, at some point he goes from the window sort of back, I guess as the car's pulling forward?
Yeah, that's how because after he started hitting Richard again, after he hit him with the gun, that's when he took his foot off the brake or whatever, and that's when he shot him.
Okay. And I think you said you didn't hear the driver saying anything. At that point in time, again, you didn't hear the driver saying anything. His role sounds like mostly he was punching, he was assaulting, Richard, but you didn't hear him saying anything with the shooter about robbery or anything else.
No.
Thank you, sir.
Any redirect?
Mr. Wright asked you a question about you not seeing the driver with the gun.
Yes.
And your response was, I didn't know what he had.
Yeah, I didn't know what he had because the way they ran, how they was acting, anybody that act like that, they gotta have a weapon or they gotta be high on something because there was no reason for them to do what they did.
Did Mr. Johnson, when Mr. Spear is pointing the gun at you, did Mr. Johnson do anything to comfort you?
No.
Did you observe anything about Mr. Johnson's demeanor, actions, words that suggested to you that, hey, everything's gonna be okay?
Judge, that calls for speculation.
I think you can rephrase it, Mr. Lee.
Well, I'll move on from that question. When after the person with the gun is trying to rob you and Mr. Johnson comes back, did Mr. Johnson do anything to comfort you?
No.
During the whole incident, the whole interaction, did you ever feel that everything's gonna be okay?
No.
How did you feel?
I was shocked. I was scared for my life.
I don't have any other further. I don't have any other. questions.
Recross on any of those points, Mr. Wright?
No, Your Honor.
All right, can this witness be excused, Mr. Lee?
Yes, he had asked to be able to remain in the courtroom. He is a listed victim in the case.
Okay, thank you, Mr. Lott. You can step down. Anyone in the jury need a brief break? We'll see. No, we'll move on to the next witness. State may call us next witness.
Okay. The state calls Taisha Ponder.
Raise your right hand, please. Do you swear affirm to the committee? Would you please state and spell your full name for the court?
Taisha Ponder, Teisha, Ponder, Ponder.
And Ms. Ponder, do you know McKinley Johnson?
Not that well.
Huh?
Not that well.
Okay. Do you know him?
Yes.
Do you know him by any other name?
MK.
Do you recognize McKinley Johnson, the person you know as MK? Do you see him in the courtroom?
Yes.
Can you point him out and describe something he's wearing? What is he wearing?
A blue and gray shirt, a tie,
Color's the tie.
black.
Does that the record reflect that the witness has identified Mr. Johnson?
The record will so reflect.
Okay. Do you know someone named Antonio Spears?
Yes.
Okay. And how long had you known him?
A month.
How long had you known Mr. Johnson?
A month.
How did y'all meet?
At work.
Where were you working?
At a warehouse in Union City.
Okay. Now I want to direct your attention to February 21st, 2023. Do you recall a incident involving Mr. Johnson, Mr. Spear, and a man driving a work van?
Yes, sir.
Now, on February 21st, 2023, did you have a car?
Yes, sir.
What kind of car did you have?
A silver Dodge Charger.
And I want to talk about the incident, okay? When did you first see the work van?
As we were driving up, it was still sitting at the stop on red light.
Okay, you remember what street y'all was on?
I know we was on flat shows.
Okay. So what happened after that? After you saw the vehicle stopped at the red light, the van stopped at the red light, what happened next?
It was still sitting at the green light.
Okay, so the light turned green?
The light turned green.
Okay, and then what happened after that?
He sat there for like 5 minutes. By us driving down, Johnson, he was driving my car. So he swerved into another car, but he didn't hit no car. And the car just still sat there. When we asked him why he do that, why he was still sitting at the light, thing he did with us was smile.
Okay, so when you say when we asked him, you're referring to the person that was driving the van?
Yes.
Okay. And the question was asked to the driver in the van, why you do that?
Yes,
Okay. And you said we, who all was asking them that?
just MK and TJ.
Okay. Was there someone else in the car besides, MK, TJ and you?
Yeah, my
Who else was
friend.
in the car?
My friend.
Okay. And where was she sitting?
In the back with me.
And you had mentioned, MK was driving, is that correct?
Yes,
Okay, where was, Mr. Spears sitting?
on the passenger side,
On the front seat passenger or the rear passenger?
on the rear passenger, on the passenger side, next to the driver,
Okay. In the front or the back?
in the front.
Okay. So pull up alongside Mr. Johnson and Mr. Spear. They're saying, hey, why you do that? The driver of the van, had you ever met him before? Did you even know who the driver of the van was?
No, sir.
Okay. So the driver of the van smiles.
Yes, sir.
What happens next?
Then he pulls off slow. We pull off behind him. And then I guess Johnson was kind of mad. So he pulled over in front of the truck. Johnson jumped out. Then Spears jumped out. But Johnson jumped out to fight. Spears jumped out with his gun.
When did you first see Spears' gun?
When he got out the car.
Okay. And at some point, did you get out the car?
Yes.
Now, did you see the man in the van get shot?
No.
Okay. So at some point, you all leave the van.
Yes.
Okay. Right?
Yes, sir.
Okay. And do you at some point learn that the man in the van had been shot?
Yes. When Spears get in the car, he tell us that he think he shot the man.
Okay. Now, when you heard that, was there any discussion between anyone in the car about calling 911?
No.
Did anyone in the car call 911?
No.
Now, at some point, you spray painted your car.
Yes.
Why did you do that?
Because I had my friend telling me to do it, and I had Spears telling me to do it, and I was scared.
Okay. So, were you also charged in this indictment?
Yes.
What were you charged with?
Tippling with evidence.
Say that again, I'm sorry.
Tippling with evidence.
Tampering with evidence? And you resolved your case, is that correct?
Yes, sir.
Okay. And you received a five-year probated sentence, correct?
Yes, sir.
I don't have any other questions.
Good morning.
Good morning.
I think you said that day you had been working at a warehouse,
Yes.
I think over in Union City.
Yes, sir.
And at some point, y'all leave the warehouse. It's you, a friend of yours, or a friend of one of them.
No, that's the warehouse that we met. That's where we was working at.
Gotcha.
Mr. Johnson was driving my car
Okay.
to take me to work. But when we got there, me and my friend didn't have to work.
Okay.
So I asked Johnson, can he go get me an oil change while I was at work?
Okay.
So we all was just gonna ride together.
Okay. So, and I guess that's part of it. Him driving your car was just a matter of essentially y'all were friends of sorts and he's helping you out.
Yes.
Okay. And at some point, when this situation happens, he was driving the car, correct?
Yes,
Okay. Spears is in the passenger front seat,
yes,
and you and the other passenger was a female?
yes,
Okay. Now, at some point, a situation, I guess, happens at the stoplight or at some intersection between that work vehicle and y'all's car.
yes.
And I think you said Johnson got pretty upset behind it.
Yeah, just a little mad, yes.
And at first, when or I guess the two of them in the front asked, what's going on, you said the person smiled but didn't really say anything.
Yeah,
And then at some point, Johnson gets out the car because he wants to fight.
he got out the car, asked the man again, and then he just started swinging the car. Only thing the man was doing was just smiling. That's all he was doing.
And all you saw Johnson doing was just throwing punches.
That's it.
Prior to Johnson getting out the car, did you see him talking to Spears about, let's do this, let's do that, or anything?
No,
Okay. Prior to Johnson getting out of the car, did Spears ever say, hey, I got a gun, I'll deal with this guy?
no.
Okay. So you said Johnson gets out the car first.
Mm-hmm.
Now, does Spears get out immediately, or at some point, is there a little bit of a delay by the time for him to get out?
He got out right after Johnson got out.
Okay, so he's getting out. It's pretty much once he sees Johnson get out, he's getting out.
Mm-hmm.
Okay. When Spears gets out, do you see him get anything in his pants, or, in other words, do you ever see a gun on Spears?
No, I ain't see the gun until I saw him pointing the gun at the man.
Okay. So the whole time you're in the car before this situation happened, did Spears ever say, hey, I got a gun?
No,
Did you ever see a gun?
no.
Okay. So Spears gets out, you still don't immediately see the gun, but at some point you see him put the gun on the man.
Yes,
Okay. Now, you saw Johnson punching at the man, correct?
yes.
Did Johnson just stay there punching, or did he sort of punch, walk away, punch, come back and punch some more? What did you see? I don't want to lead you.
He was there punching for a minute. Then he turned back around. He was going back to the car, then came back, hit him one more time, then went back to the car.
Okay. And then you also said you saw Spears go up to the man.
Yeah, Spears was there at the same time that he was punching the man.
Okay. And when you saw Johnson going back and forth, did it seem like, I guess they had their own issues between Spears had his issue, but Johnson has his own issue?
No, I think Spears was just doing that just to show off.
Okay. So you think Spears was,
Speculation.
I'll ask you a different question.
All right, sustain.
Spears, either way, you saw Spears interacting with the man all on doing his thing.
Yes,
Okay. Now, you got out the car at some point. Did you say that? Okay. I'm sorry. You had gotten out the car at some point.
yes.
Okay. And while you're out the car, I'm trying to get the jury an idea of when you're out the car versus when things are happening on the video. When you're out the car, is that when some of the punching is happening?
Yeah,
Okay. When you're out the car, is that when you see Spears put a gun on the guy?
yes.
Were you out the car? Well, at some point, the guy in the car starts to drive off or drive forward. Did you see that?
Yeah.
Okay. At that point in time, did you see the gun get fired?
No,
Okay. Did you hear the gun?
no.
Okay. So what is going through your mind at that point when it's all, that car is starting to take off, what do you do next?
We get in the car and pull off.
Okay. And again, did you hear any gunshot when this had happened?
No,
Okay. When Spears and Johnson and everyone's back in the car,
Mhm.
you driving off, was there ever discussion about, well, did anyone say, hey, I heard a gunshot?
no, Spears said, cause he said, bro, I think I shot him.
All right, so Spears announced to everybody. But prior to him announcing that, you didn't know that a gun had been shot.
No,
Oh, I'm sorry. Okay. Now, at that point, once he said that, did it freak you out?
yeah, also Johnson, cause he started snapping on him.
So Johnson started snapping on Spears.
Yes,
So to be clear, as soon as he learned that Spears said, hey, I think I shot him, that's when Johnson started snapping on Spears.
yes.
Where did y'all go from there?
I dropped them.
Once you left that scene,
I dropped them off and then I went home.
okay, who did you drop off first?
They both went to Spears' house.
Okay. And then you went home?
Me and my friend went to my house.
Okay. And I think you said it was Spears and your friend, or was it a different friend that suggested, hey, you might want to paint your car?
Yes,
In other words, when you said that, it wasn't Johnson that said that, it was Spears and another friend.
I was up. My friend was in the car with me, and Spears and him, by him being at Spears' house, we all was there on the phone together. But the only people said I should paint my car was my friend and Spears.
Okay. And at that point, was Johnson still pissed off at Spears for all this happening?
Yes,
At no point prior to the incident, during the incident, or after the incident, did you ever see Mr. Johnson with a weapon? Is that correct?
no, I never seen him with the weapon.
Okay. Prior to the incident, at the incident, or after the incident, did you ever hear Mr. Johnson talking about wanting to rob anyone?
No, only thing he did was play his songs on the radio.
Thank you.
Redirect.
Briefly. Mr. Wright asked you about where you were in relation to the, asked you where you was when you got out the car, correct? You remember that?
Yes.
All right, I'm gonna republish State's Exhibit 3, and what's the title? Go back to the screen. It's titled Process Video Forward Exterior 1, okay? Ms. Boyce? Yes, please. I can't see. Oh, Mr. Wright's unable to share the screen right now. Ms. Borges has to allow that capability for him to be able to do it.
All right, so Mr. Wright is trying to share his screen. And does he need to be a co-host again?
Yeah.
Okay. Stand by.
Now, the person that just stepped out the rear seat, who was that?
Come on, in the front or in the back?
Right now, smoking a cigarette.
Me.
Okay, that's you. Okay, so you were standing there, correct?
Mm-hmm.
You weren't standing next to, you can stop. You wasn't standing next to, Mr. Spear and Mr. Johnson while Mr. Johnson was punching the drop.
I wasn't like close to them, but Spears was right here and Johnson was next to Spears.
Okay. Right, you weren't right next to them, but you were close by,
Mm-hmm.
and you were able to see the gun.
Yeah, but I wasn't paying attention to the gun.
Okay. But you saw it? Just want to make clear, you saw the gun, that's all I'm asking you right now.
Yes.
Okay. Now, you all get back in the car. And when Spear gets back in the car, he says, I think I shot, okay? And Mr. Johnson and Mr. Spear is talking about that, correct?
Johnson is yelling at Spears.
Okay, he's yelling at Spears about what happened.
Mm-hmm.
Okay. But there was not a discussion about, hey, let's call 911 for this man.
No.
Okay. And you stated that at some point you were all on the phone talking about what happened. Was that accurate?
We was all on the phone talking about what happened.
About when the idea came to
About painting my car?
paint the car.
Yes.
Okay. So you're on the phone, Mr. Spears on the phone, your friend is on the phone, Mr. Johnson is on the phone.
My friend is with me.
Okay, your friend is with you, and Mr. Johnson is on the phone.
Johnson is with Spears.
Okay. And so Mr. Spears and your friend suggest spray painting the car.
Yes.
Okay. And Mr. Johnson, intervene and say, no, don't do that.
No.
He doesn't say that. And the spray painting of the car, how did you do that?
I went and got some spray paint from the store, and me and my friend sat outside and sprayed it.
And all of that was to hide what happened that day, correct?
That, and we both were scared.
Scared of what?
Spears.
Were you threatened?
Not until after the case.
I'm talking about before the at any time from the time that the shooting happened
No.
to the time that you spray painted the car, you was not threatened?
No.
And I'm gonna go back. This was why did you decide to get out the car?
I don't know.
And just so the record is clear, when I ask you that, I'm referring to when the shooting occurred. Why did you decide to get out the car then?
I don't know.
Okay. And so you stated that you were threatened after the case.
Mm-hmm.
Who threatened you?
I was getting threatened by the Spears people.
Okay. You ever get any threats from Mr. Johnson?
Mm.
Is that a no?
No.
Say no.
I'm sorry,
Okay.
no.
I don't have any other questions.
Recross.
No recross, Judge.
And this supposed to be excused, Mr. Lee?
Yes, John.
Yes, sir.
All right, thank you, Ms. Ponder.
And may we approach?
All right, members of the jury, we've been going just about 2 hours now, so we're going to take about a 10-minute break. We'll come back, and I think we'll be able to fit in one more witness before we take our hour lunch break. Thank you.
Rise to the jury.
All right, let's be in recess till about 11:25. We'll do it.
Yeah, 11:25.
Okay, we'll see you then.
I'm sorry. That's not 15 minutes. Can I have 30?
Is this for a witness coming or personal?
This is for a person.
Okay, check it, 11:30.
He said come back 11:09.
A record producer.
So now come on, remain seated.
We are back on the record. Are we ready to bring back the jury, Mr. Lee?
Yes, Your Honor.
Okay, why don't we go ahead and have your first witness come on in.
Marcus Traylor.
Anything we need to take up, Mr. Wright?
No, Your Honor.
Okay. And as that witness comes on in, we'll bring in the jury. Deputy Scott? Mm-hmm. Okay, that's fine. Mr. Traylor, just feel free to have a seat and we'll be right with you.
All rise for the jurors. President Custer, Judge.
Thank you, Deputy Scott. Statement call its next witness.
State called Marcus Traylor.
Raise your right hand for me. These 12 forms of the day's testimony you should give a court will be the truth, nothing but the truth to help you. You may be seated. Would you please state and spell your full name for the court?
Marcus Traylor, Marcustraylor.
And good morning, Mr. Traylor.
Good morning.
Mr. Traylor, how are you employed?
With Fulton County Emergency Services 911.
And what are your duties there?
Custodian of 911 records.
Okay. And what does a custodian of 911 records do?
Produce the 911 tapes for emergency calls.
Okay.
And what does the Fulton County 911 Communication Center do?
We take those calls and we dispatch the proper response units.
And when a 911 call comes into your center, is there a record produced of that call?
Yes,
Okay. And are those 911 calls themselves recorded?
yes,
And is there also a do you know what a CAD report is?
yes.
What's a CAD report?
It's a computer-aided dispatch report. It's a transcript of a 911 call.
And when the 911 calls come into the center, are they recorded automatically?
Yes,
And are these calls kept in the regular course of business of the Fulton County 911 Communication Center?
yes, they are.
And is it the regular business practice of the Fulton County 911 Center to keep and maintain these records?
Yes,
Okay. And I'm showing the witness what's been marked as State Exhibit 1 and State's Exhibit 2. May I approach y'all?
Yeah.
Showing you what's been marked as State's Exhibit 1 and State's Exhibit 2. We're going to talk about State's Exhibit 1 first. Do you recognize State's Exhibit 1?
yes.
What is it?
It's a CD of 911 calls.
How do you recognize it?
Has my initials.
And is that a fair and accurate recording of a call that was placed on February 21st, 2023 on Flash Hills Road?
Yes, it is.
And State Exhibit 2, what is State Exhibit 2?
It's a CAD report.
And is that the report you was referencing earlier that's a transcript of the 911 call?
Yes, it is.
And when you say transcript, what do you mean by transcript?
It's the notes that the operator types that the caller states when they call 911.
And does it also record the time that the 911 call came in?
Yes,
And who responded to that call?
South Fulton PD.
At this time, Your Honor, the state seeks to admit State's Exhibit 1 and 2 evidence.
No objection.
Admitted without objection.
Permission to publish.
You may.
I'll do it. Hopefully it'll work.
Fulton County 911. What is the address of the emergency?
Right here on Flat Hills Road at Mallory Road, there was an incident. A car pulled over and got out. Two guys got out the car and started punching the man in the car. And then I heard one shot. Another car said that the guy got shot in his neck. They don't know if he's okay. But I did get it on video, but it kind of took me up. So yeah, the guy is right there on Flat Hills and Mallory Road. All I know is there's two gentlemen. We were all driving up the street. They cut the guy off, swerved so he couldn't move. Got out the car and started punching the man, and then the man was just like holding his hands up. And that's all I seen. All I seen was this one guy pull out a gun, and I heard the shot as I was driving off, but the other guy was punching him.
Okay. Are you still there? Have you left?
And I'm pausing
State's Exhibit 1 is the 911 call -1. I paused it at 55 seconds. So that the record is clear, Mr. Trailer, did you hear the caller state she heard the gunshot?
I would have to, not that I recall.
I'm gonna object. This question is simply asking a witness to repeat what a piece of evidence already is. It speaks for itself. He has no personal knowledge of it. He's literally a custodian. So I would just object to him repeating back as duplicitous and
Is there a follow-up question after this one, Mr. Lee?
No, yeah, I can withdraw the question. It's admitted.
Okay, all right, fair enough, then sustain.
They got to do me. I just called up.
So you left?
Yes, I left. I didn't have nothing to do with it. I was riding by.
I understand. I'm just asking you so we could give help to the person who got shot. What's the description of the subject? What type of vehicle were they in?
It's like a white. It's a white truck. It's like a work truck.
Okay. Did you see a tag number?
You're talking about for the suspect? They was in a Dodge Charger, a gray Dodge Charger.
Okay. The person who was shot was in a white work truck?
Yes, it was in a white work truck, yeah.
Did you see the tag number of the Charger?
Hold on. I'm driving at the moment, but if you can get someone to call me back, I can get it. I just have the whole incident on video. I don't know if I can get the tag number, but I do have the whole incident on video.
Okay. What's your name?
I got y'all ain't gonna tell nobody who I am, right?
No, ma'am. This is for the officer when they have to call you back.
Oh, Danielle.
What's your callback number?
678-468-8635.
Okay. All right, ma'am. We're getting help there.
All right.
All right. Bye-bye.
Your Honor, at this time, I'm playing the rest of State's Exhibit 1, which is the second 911 call. It's denoted 911-2.
Fulton County 911. What is the address of the emergency?
Hey, somebody just shot my guy I work with.
Okay, what's the address?
I don't even know where we at.
Okay, sir, I have to have the address to send help to him. So what's the name of the business?
We on Mallory Road.
What's the name of the business, sir?
No, we on the road. We on the side of the road.
Okay, Mallory, and what's the closest cross street?
Man, come here, man.
Sir, are you near Flat Shows?
Huh?
Are you near Flat Shows?
I don't even know where we at. We out here working. Is Flat Shows around here? Is Flat Shows around here? Yeah, I'm on Flat Shows right now.
Okay, what's your name?
My name is Wayman Lot. Valerie and Flat Shows.
Okay, give me your name.
My name is Wayman Lot. Hurry up, he bleeding real bad.
Okay, sir, I'm starting people to the location. Give me your phone number.
My number is, I don't even know, I'm calling from my work phone.
Okay, 1 second for me. Are you with the patient now?
Yes.
Okay, hold on 1 second for me.
Please hurry up.
Sir, we've already started we've already started help, but I am going to have to ask you some questions. These questions are not delaying anything, okay? How old is he?
He's like 40 something. He's 40 something.
All right, is he awake?
Yeah, he awake.
Is he breathing?
Yes, he's breathing.
All right, 1 second for me. When did this happen, sir?
It happened just now.
Okay, is the assailant still nearby?
No, it was a gray like Dodge, a gray Dodge Charger with front end damage.
Okay, 1 second. Gray Dodge Charger with front end damage?
Yes. Ricky, stay up, Ricky.
1 second for me, sir. I'm getting all this information in. Is there any serious bleeding?
Yes, he's bleeding real bad.
Okay. Is he responding normally, sir?
Ricky. No.
Okay. 1 second for me here. What part of the body was injured?
He shot in the neck.
Okay.
Yeah, Richie.
Is there more than one wound?
No, it's just one wound. No, it's one wound.
Okay, so listen, I'm sending the paramedics to help you now. Stay on the line, and I'll tell you exactly what to do next. Listen, sir, listen to me. Listen to me. Is the blood spurting or pouring out?
It's spurting, but I got my hand on it.
Okay, so listen, I need you to place 2 fingers on the skin just below the wound and close to where the blood is coming out. Try to stay.
I got my hand right here, right there now.
Okay, try to stay on the skin and out of the wound itself. Press down firmly until the bleeding slows down or stops, and let me know how it's going.
Okay. He's still bleeding, but he bled out a lot.
Okay. 1 second for me. If it keeps bleeding, unfortunately, you're probably not pressing hard enough. Remember, keep firm, steady pressure on the wound, okay? You can try repositioning your fingers a little closer to where the blood is coming out. And like I said, make sure that you are below the wound on the side closest to his body.
Okay.
Now, sir, I've already got units en route. Did you see what way the gray Charger went? Go ahead.
It went north. Oh shit, man. We right here on Mallory. It just went in front of us. Man, oh man, I don't even know because I'm not from out here. We just out here working. We in a large mechanic and stuff.
You said they went north. They went north on Mallory, sir.
Huh?
The gray Charger went north on Mallory.
Yes.
Okay. Could you by any chance?
I'm sorry, on Blackfield.
Okay, so he's not responding?
No. Stay up, Richard.
Listen. Hold on 1 second for me. All right, you still have your fingers right there, correct?
Yes.
Okay. Is he still breathing?
Yes, he's breathing.
Okay, 1 second for me. Okay, 1 second for me here.
Oh man.
And you guys are on Mallory Road. Are you near a work truck or where you guys are?
Standing at my work truck right now. He got shot inside my work truck.
Okay. Your work, what kind of work? Is it like a white truck? What kind of truck?
Yes.
All right, I got several units en route, sir, so they should be there shortly. I just need you to keep those fingers applied on the wound or directly. Okay.
Oh shit, man. I'm okay. Oh man, come on. Richard. Talk to me, Richard.
He's still breathing. Okay. Has the bleeding? I know he's a lot of blood, but is it kind of? I mean, with you putting your fingers right there, is it helping a little bit or not?
It's stop.
Okay, that's good. Okay, just still keep it right there though.
Oh shit, man.
Do you know what led up to the?
We stopped at the red light and he stopped at the car stopped in front of him and he stopped and they got mad and got out the car and shot him.
Okay.
Oh man. No, he's not talking. Richard, breathe, Richard.
They're en route. The police, they're all en route.
Here they come.
Let me know when they get out there, okay? Keep your fingers right there, though, sir. It's still important for you to keep your fingers right there.
And Mr. Trailer, were you asked to pull or download all calls associated with the incident we just listened to?
Yes.
Okay, and did you do that?
Yes.
And were you recently asked last week to double check to see if there were any more calls related to this incident?
Yes.
And did you do that?
Yes.
Okay. Outside of the 2 calls we just heard, was there any other 911 calls associated with this incident?
No.
And so we're clear, we're referring to the incident that occurred at Flat Shoals Road and Mallory Road on February 21st, 2023.
That's correct.
That was the incident you was asked to pull the 911 calls from, correct?
That's correct.
Okay. I don't have any further questions.
Any cross?
I have no questions.
Can this witness be excused, Mr. Lee?
Yes, Your Honor.
All right, thank you, Mr. Trailer.
Thank you.
All right, members of the jury, I think we've reached the point where we need to take our afternoon lunch break. And so the time is 11:48. We'll break for 1 hour. I would ask that you be back here in the jury room ready to go at 12:50. And as I mentioned, you can leave the building if you'd like to, or if you brought your lunch, you can stay here if you need to, if you'd like to. 2 things I'm going to tell you every time we break is that make sure and please abide by the instructions that you're not to discuss this case with anyone, including yourselves, and that you're not to conduct any research about this case whatsoever. All right, thank you. All right, before we break, Mr. Lee, do you think I can get a preview of the afternoon?
Yes, Your Honor. We will start up with Detective Allen, and then that will follow by Dr. Hebert, the medical examiner, and we would most likely witness.
Okay, so potentially only 2 more witnesses from the state. And so, Mr. Wright, I would just note that it appears that we would likely be turning it over to you before the end of the day and having some questions for you and your client. So I'd ask that you'd be ready when we reach that point. Okay, and if if both sides happen to rest today, that could happen. We'll send the jury home at that point and then have our charge conference if there's still time left in the day. All right, we'll be in recess until 12:50 unless there's anything else.
No, Your Honor.
All right.
No, Your Honor.
Thank you.
Same applies for this.
Yes, ma'am.
Thank you. But I'm gonna help learn through. I'll go on to.
So Jeffrey, I'm gonna with you, and you can leave the car here if you want, or we can take it.
Yeah. Think about the conviction. I'm trying.
Yeah, let me think about it.
I'm
Remember there was something about all that.
Oh, no,
For Judge Robinson, that.
Trying to deal with this troll, I'm not.
Something. You do that.
all right.
If it's the document. You make you go chase down a certified copy of what it's something that will We all know what it is. Let me get lost.
It's actually due, if we stipulate, it can be used for a statement.
The only thing, he filed a motion to withdraw his plea on time.
What's up?
It hasn't been ruled.
Andre.
Put that in there, but if we must, but it's connected right now. Anyway, but just let me know.
Andre.
So, Jeffrey, you want to keep this here? Yes. I'll keep Jack up here.
Andre.
Doors are locked, so.
They are locked.
When are we supposed to?
At least, I'll open up the door about at least 12:35. Once we back at 12:50.
I'll be.
Yeah, yeah.
All right.
Good, see you in a minute. All right, then.
Locked already?
Yeah, I did.
Great.
Check on the final Adam and use that to see at 12:50. Check on the 27 Yeah, that's all. Snap already.
I didn't hear it. I know I heard that.
Conference, actually, maybe get too loud, you may use the conference phone.
Yeah, I didn't hear,
So Mr. Bridges' phone went off.
yeah, that's what about?
It must have just been recorded.
Cause at first I heard it, it's like somebody was talking. I don't know if he was watching a video or what it was.
He was like the guy that's on Tonight Show, or whatever that show. Williams, his name was Woods,
Mhm.
Roy Woods, the
Mhm.
comedian.
Who, it's the.
Mr. Bridges, yeah,
Okay.
like, it can be related. Yeah. Two seconds. Call will come to order, remain seated.
Can you do an audit, deputy? How many we got? We got everyone? Okay. All right, Mr. Lee, how we looking? You ready to get started? We missing some of your team?
We are, but I mean, if the court's inclined to wait for him, we can, but if, I know how you are, I'm here.
Well, I am what I am. Let's go on the record. And unless we're already on the record. And you can have your next witness slowly make their way in. That'll buy you a minute. As that witness makes their way in, Mr. Wright, anything we need to take up before bringing back the jury?
No, Your Honor.
Okay. Where'd my pen go? Lost a pen.
There may be one thing, I'm sorry.
They're not coming in.
Okay, so just kind of alert you to the court, we may have to discuss, we looked into that issue, you talked about, stipulation to the.
Either I would submit a certified copy of the co-defendant conviction, or we could just do a stipulation. I had approached the state to see would they consider either or to tender, because I think I can just tender a certified copy
Well,
without even really needing a witness, or
sure.
by stipulation.
Well, I think there might be some issues there. Mr. Lee, would the state be intending to introduce the certified disposition of the co-defendant in his case in chief for any reason?
No, Your Honor.
All right. So if the defendant tried to put it in his case in chief, I assume he has a certified copy, or if he doesn't, the authentication isn't the issue here. But would the state have another objection to its admissibility?
Yes, it's a general relevance objection. Mr. Grinder is going to argue that out to the court in more detail when we address it. I just wanted to
Sure.
flag it early.
No, I appreciate the flag because I do see that as an issue. So, Mr. Wright, I think there might be, I guess there wouldn't be hearsay issues if it's the foundation is certified, but I think you would have to overcome a relevance objection if Mr. Spears isn't going to be a witness.
And there's no intent to make him a witness. However, because he has been referenced in several capacities, his role in this has been referenced. To me, I think a rule of completion argument would be, well, if the jury wants to know, well, what happened with the co-defendant that was part of this indictment, the other person we're hearing in all respects in all these actions, then to complete the story, it's, well, he's done his plea. And that's all it would be. It would just be tendering a certified copy of.
And not the sentence?
Well, I guess it would be ultimately the sentence.
Right. Well, I'll reserve that so that Mr. Griner can be here to argue it. But my initial impression is that that's going to be an uphill battle. The jury instruction is fairly explicit, saying that the guilt of co-defendants is not something you're to consider. You're solely to focus on Mr. Johnson. And that's what we have to work through as we discuss the issue, which at this point, I would say, because it's an open question, that either through the detective or anyone else, if you're planning to raise that on cross, let's bring it up outside of the presence of the jury if that was your intent. Okay. Thank you, Mr. Wright. Anything else we want to flag?
We submitted supplemental jury charges, requesting charges on conspiracy. I copied the email to Mr. Wright, so that's another.
Great. Mr. Wright, you were able to receive those?
Yeah, I did receive it, and I figured at the charge conference we would hash all that stuff out.
Absolutely. We're going to incorporate that into our rough draft, which will have all of them, and then we'll whittle that down in the charge conference. Did you plan to submit any supplementals, Mr. Wright?
At this point, no, Judge.
Understood. Okay. Anything else then, Mr. Lee?
No, yeah.
Honest is down, so.
Right. And either through email or a hard copy is what we're going to have to be doing from here on out. So I was just handed by Mr. Griner a copy of their supplemental request to charge. All right. With that, if we could bring in the jury.
Round for the jurors. Judge, the president, conflict,
Thank you, Deputy Scott. All right, welcome back, members of the jury. I hope everyone found success in the search for lunch, and we're ready to dive back into it if there are no issues we need to take up. And seeing none, Mr. Lee, the state may call us next witness.
State calls Detective Erica Allen.
Raise your right hand, please. Swear affirm to the testimony you should give a court, do the truth, the whole truth, nothing but the truth, so help you.
Yes, sir, I do.
Could you please state and spell your full name to the court?
It's Detective Erica, Erica Allen, Allen.
And Detective Allen, how are you employed?
I'm employed with the City of South Fulton Police Department.
And what are your duties?
I'm a criminal detective for Major Crimes Unit.
And were you employed in that capacity on February 21st, 2023?
Yes, I was.
And are you post-certified?
Yes.
And were you post-certified on February 21st, 2023 as well?
Yes, sir, I was.
Okay. I want to direct your attention to February 21st, 2023. Were you assigned as the lead detective involved in the shooting death of Richard Antoine?
Yes, I was.
Okay. And where did this incident occur?
It occurred at the intersection of Flat Shoals Road and Mallory Road in South Fulton.
Okay. And what county is that located in?
Fulton County.
Now, did you respond to the scene that day?
Yes, sir, I did.
Okay. Please tell the jury what you observed and what actions you took as a result of your observation.
Okay. So initially I was called out approximately 11:30 to the scene. Originally the incident occurred at approximately 11 a.m. on Tuesday, February 21st. Upon my arrival, Mr. Antoine had already been transported to Grady Hospital by EMS. To my knowledge, he was conscious alert while they got there. They transported him. Mr. Lot was on scene and the primary responding officer was on scene. I spoke to both of them. Mr. Lot provided me that there was a gray Charger that was involved that the suspects fled in. At that time, we used LPR readers to try to locate said vehicle.
Okay, let me stop you right there.
Correct.
What's an LPR reader?
It's a license plate reader.
What does it do?
It tracks vehicles by camera in the area.
And where was this license plate reader located?
They're throughout the city, but this one was on Flat Shoals Road.
Okay. And so when I stopped you, were you saying that you were looking into the license plate readers at this point?
Correct. We were checking the cameras in the area.
Okay, and did you find anything significant?
We did.
Yeah. What did you find?
We found a vehicle that fit that description, which was a gray Charger with front end damage traveling eastbound on Flat Shoals Road.
And were you able to get a tag number for that vehicle?
We were not at the time.
Okay. So what did you do?
We proceeded to continue to check the cameras periodically to see if we could further locate the vehicle, which we did pick up again. We had a tag at that point, and the vehicle was located on February 23rd in Union City.
Okay. And was there anybody, did you speak to anyone as a result of that vehicle being located on February 23rd?
Correct. Yes, we did.
Who did you speak with?
I spoke with Taisha Ponder and Miss White Carey.
Okay. And did Miss Ponder admit to being present during the shooting on February 21st,
Yes, she did.
2023, involving Mr. Antoine? She did.
She did.
Okay. And did she identify the people who were in her car?
She did.
Okay. And was one of the people she identified, well, who did she say was in her car?
She identified TJ, which we identified as Antonio Spears. And then she identified a male as Q, but when we showed her a picture of the subject, she identified him as McKinley Johnson. And then herself and Coroner White Carey.
Okay. And did you subsequently take out an arrest warrant or an arrest warrant for Mr. Johnson?
Not at the time.
Okay. What did you do next?
We went to his, when we interviewed Ms. Ponder, she stated that they all worked together at the mayor's warehouse in Union City. We attempted to locate the subjects there. We were not able to locate them. So I obtained search warrants for their residence on March 1st.
Okay. And did you locate Mr. Johnson on March 1st?
I did.
And where did you locate him at?
In Union City at his residence.
Did you locate Mr. Spear
I did.
on March 1st?
March 1st
And where did you locate Mr. Spear?
at his residence in Riverdale.
Okay, so two separate residences.
Correct. 2 separate counties, 2 separate residents.
And without telling the jury anything Mr. Johnson may have said,
Mhm.
did you in fact interview him?
I did.
Okay. Did you also interview Mr. Spear?
Yes.
And you stated that they were arrested on March 1st, 2023.
That's correct.
Okay. Between February 21st, 2023 and up until the day you interviewed them, did you receive any information indicating that Mr. Johnson wanted to turn himself in and speak to you?
No.
Or that he had any information about what happened?
No.
Okay. And do you recognize Mr. Johnson in the courtroom today?
I do.
Can you point him out and describe something he's wearing?
There's a gentleman sitting to the left at this table to my left. He's wearing a dark colored tie and a button-up shirt, collared shirt.
Please let the record reflect that the witness has identified Mr. Johnson.
The record will so reflect.
I don't have any other questions.
Good afternoon.
Good afternoon.
I think you said that you were able to find Mr. Johnson at his residence, correct?
Correct.
And at that point, did you take him into custody?
Yes.
Okay. And once you took him into custody, you read him Miranda.
When we got to the station.
Okay. And for the jury, Miranda's when you advise someone that, hey, if you want to talk to us, let's talk about your rights and right to remain silent and other things. And you make sure that they're apprised of that.
That's correct.
Very basic summary of what Miranda is.
Correct.
And once you did that, he did speak to you.
Yes, he did.
Okay. And he told you what happened.
Objection? You're saying.
Any exception?
Into what was said, but if he asked if he had spoken, I'm just saying, did he speak to you? And I'll keep it.
And that's a yes or no question?
I'm sorry. Yes, that.
All right.
Just being, because
Understood, Mr. Lee.
this question, was he told you.
Right. I think that's a fair point. So it's sustained on those grounds.
He answered all the questions you asked him.
Yes.
Okay. And you asked him about this incident.
Yes.
Okay. You asked him about the persons involved in the incident.
Yes.
You asked him about the person who was thought to be the shooter in the incident.
Yes,
You asked him about the females that were in the car, correct?
correct.
So in other words, you fully talked to him and asked him questions about things regarding your investigation.
Yes,
Okay. And maybe about 30, 40 minutes or so, would you say that interview lasted?
approximately.
Okay. And he seemed, well, let me ask you, did he seem upset based on everything that had happened?
Objection, calls for hearsay, and it's also speculative as far as what his mental state was.
Mr. Wright, I think you need to preface the question with what this observation would be based on, and maybe confine it to admissible evidence.
I will build it up. You were sitting at a table with him, correct?
Correct.
And you had a chance to, along with asking him questions, you could observe him while you were asking him questions, could you not?
Yes,
He, based on your observations of him, and I don't want you to tell me anything he said,
Mhm.
but based on your observations of him, did he seem very animated to you about the situation?
very animated
Or emotional? I mean, I'm sure, maybe it was a strange word, but
to a degree.
okay. After that interview, did you ever try to have a second interview with him?
I did not.
And you interviewed Ms. Ponder as part of this case, correct?
Correct.
You also interviewed Mr. Spears, correct?
Correct.
As part of your investigation, you determined that, well, did you determine that a gun had been used?
Yes.
Okay. Did you ever find that gun?
No.
Okay. As part or as lead detective, only one gun, as far as your investigation indicated to you, was ever used.
Yes, to my knowledge.
Okay. And only one gun was ever described by any witness in this case.
Yes.
As part of your investigation, no one ever said, hey, prior to the incident happening, so-and-so or a group of people were talking about trying to commit some sort of crime. Objection, hearsay.
Any response to that, Mr. Wright?
I withdraw and ask it differently.
All right, sustained.
Nowhere in your evidence as the lead investigator did you become aware of conversations or plans to commit crimes prior to the incident.
No, I did not.
What caliber weapon, as part of this lead detective, did you ever determine what caliber weapon was used?
Believed to be a 22.
And for the jury, a 22 is considered a small caliber handgun.
That is correct.
In fact, a 22 is often very small.
Correct.
Generally, a 22 can fit in your pocket or otherwise be secreted on your person pretty easy. Is that a fair statement?
Yes.
And as part of your investigation, after talking to different people, going to the crime scene, looking at everything that you looked at, you determined that Mr. Spears was thought to be a person with a handgun.
That's correct.
One of the names you gave me, the second female, there was Miss Ponder, but it was it White Carrie?
White Carrie, yes, sir.
Did she ever get interviewed or come in and talk to?
It was interviewed. She was interviewed.
Okay. And again, to be sure, without telling me anything Mr. Johnson said, he was willing to talk to you and answer all your questions.
Yes.
Nothing further.
Redirect.
Okay.
Mr. Wright asked you questions about the caliber of gun that was used in this case. Probably that. Okay. And you answered that it was a AR-22, right? Okay. And did you ultimately retrieve surveillance video in this case?
Yes, I did.
How did you go about doing that?
I was notified by Mr. Lot that there was cameras in the vehicle. Rogers Mechanical, which is the company that owned the vehicle and the company that Mr. Lot and Mr. Ant work for, provided me with that video through a Dropbox to my email.
And while we're on the subject of video, I'm gonna go back, but while we're on the subject of video, did you also learn of a person named Danielle who possibly has some?
I did.
Okay. How did you learn of that information?
She was also a 911 caller and it was in the CAD notes.
And did you reach out to Miss Danielle?
I did.
Did you attempt to retrieve the video?
I did. I reached out. I reached out multiple times, yes.
Okay. And were you able to do that?
I was not. She stated that she was too in fear to speak with me. She didn't want her name, but she had video on her cell phone is what she stated.
Okay. And while you were researching 911 calls, did you come across any 911 calls that were placed by Mr. Johnson?
No.
Or by any of the other people you interviewed in this case outside of Wayman Lot?
No.
I'm gonna republish State's Exhibit 3, Interior 1.
Yana, can we approach? Yes.
So there was questions about the 22 and how small it is, okay?
Right.
I want you to observe State's Exhibit 3. It's already been admitted, but this is the video that you retrieved from Rogers Mechanical,
Yes.
and you watched it?
Yes.
Okay. Go ahead and play it.
Your Honor, if we could stop it. For my objection. I understand the court's ruling, but I also didn't anticipate the state's going to play the entire video to get to that point.
It's only a minute long. I mean, I can skip it.
I would just renew it to just ask that they go to the point that they want to make, not showing the entirety.
All right, I understand your point, Mr. Wright. I think Mr. Lee has just offered to go to the point, and so I'll consider it a moot point.
And, Detective Adam, I'm gonna publish State's Exhibit 23. And if you're able to see a handgun, just inform us when you're able to see it, okay? And this is. Do you see the image on the screen now?
I do.
Okay. What do you see here?
I see the weapon in the right hand.
And go ahead and play it.
Just for the record, same objection, but
Overruled.
And what did you observe there at about the 42nd second mark?
He steps back and then he comes back with the firearm again. And then he hits him in the head and it's,
Judge, now I'm objecting. Now it's cumulative because it's beyond just trying to make a point about a weapon. And now it's just getting another witness who is narrating what she's seeing, but doesn't have personal knowledge of, and would again object.
Okay, Mr. Lee, you stop the video at that point. You can continue with your questioning at this point.
Give me 1 second. That's where I was gonna end it. I actually don't have any other questions, y'all.
All right, Mr. Wright, any recross?
No other questions, Judge.
Mr. Lee, can this witness be excused?
Yes, John.
All right.
Recall.
Okay, thank you, Detective Allen.
thank you, sir.
All right, state may call its next witness.
Dr. Heber. I don't know.
Okay, I'll send.
And Mr. Lee, have any members in the gallery been warned about the nature of this testimony?
I'm not sure.
Why don't we do that now? Okay.
Yes. May be seated. Could you please state or spell your full name for the record?
It's Colin Hebert, Hebert. First name Colin.
Okay. And Mr. Hey, Bear, how are you employed?
I'm the Deputy Chief Medical Examiner at the Fulton County Medical Examiner's Office.
And how long have you been employed with that office?
About a year and a half.
And what is your occupation?
I'm a forensic pathologist or medical examiner there, and a deputy chief. So I supervise the other doctors and train forensic pathology fellows who are finished pathology residency, and they do a subspecialty in forensic pathology before they can become a medical examiner.
And are you a duly licensed physician?
Yes.
And what states are you licensed in?
California and Georgia.
And how long have you been licensed to practice as a forensic psychologist? Oh, excuse me, for forensic
Pathologist.
pathologist.
It's about 9 years.
And what training has you, well, before I ask that, what is forensic pathology?
Forensic pathology is I kind of mentioned, is a subspecialty of pathology. So pathology is when the subject of pathology is studying disease mostly. Most pathologists we're physicians who choose a residency after medical school. We choose a residency in pathology. So we mostly look at biopsies of living people and diagnose disease. We work in the laboratory sections of the hospital, so you don't really interact as a patient with a pathologist. Part of pathology also is autopsies, so post-mortem examinations to determine the cause of death. And the subspecialty of forensic pathology is a medical legal autopsy of someone who dies violently or suddenly or unexpectedly. So that's my main job now, is to perform autopsies of people who die mostly violently or drug accidents, drug overdoses, car accidents, shootings, hangings, or those who don't have any medical history, or young children who die unexpectedly. So that's the main duties.
And how many autopsies would you say you've performed?
Almost 2,900.
And are you on staff or affiliated with any universities or academic institutions?
The Fulton County Medical Examiner's Office has academic affiliation, so I'm an adjunct professor for Emory and Morehouse School of Medicine.
Are you a member of any specialized medical or scientific groups?
Yes, the College of American Pathologists and the National Association of Medical Examiners.
And have you testified in court before?
Yes.
How many times would you say you have done that?
76.
And have you testified in Fulton County before?
Yes.
How many times would you say you have done that?
I believe it's 11.
And in your experience as a medical examiner performing autopsies, how many of those autopsies would you say involve gunshot wounds?
About 20%.
At this time, Your Honor, the state moves to admit Dr. Hebert as an expert in the field of forensic pathology.
No objection.
State may proceed.
I want to direct your attention to February 23rd, 2023. Did you have occasion to perform an autopsy on Mr. Richard Antoine?
Yes.
Okay. And do you recall where specifically you performed this autopsy?
It was at the Fulton County Medical Examiner's Office.
And did you memorialize your observations and conclusions by writing a report?
Yes.
Did you also memorialize your observations by taking photographs?
Yes.
The ones that don't have stickers on, I'm not going to admit. Sorry.
Yeah, the only one I have to this one.
Okay, then we'll yeah, we can. I'm gonna seek to amend it, and we can argue.
Approach on it.
You want to approach on it now?
Yeah.
Okay. Yeah, may we approach?
If you're not.
Thank you. I'm gonna approach Your Honor, if I may, with what's previously been marked as State's Exhibit 5 through 10. Excuse me, 5 through 11. And Dr. Aber, if you could, please, review those, look up when you're ready and tell me if you recognize it.
Okay, yep.
And what are they?
Those are copies of the autopsy photos for Mr. Antoine.
And this was the autopsy that you performed?
Yes,
You were present when these photographs were taken?
correct.
Do they accurately reflect your observations during the autopsy you performed on Mr. Richard Antoine?
Yes,
Do they appear to be altered in any way?
no,
Now, at this time, the state seeks to admit 5 through 11 into evidence. And the one in question is,
All right, well, subject to the limitations in place with agreement of both parties, is there any objection to the admission of all of these exhibits?
No objection.
All right, they're admitted without objection. That is what was that?
5.
5, excuse me. 5 through 12?
11.
11, got it.
And I'm now approaching with State's Exhibit number 4. Dr. Aber, take a second, flip to those pages and look up when you're done.
okay,
Do you recognize State's Exhibit 4?
yes.
What is it?
That's a copy of Mr. Antoine's autopsy report.
And that's the report that you authored.
Yes,
Is it a fair and accurate copy of the report you authored?
it appears to be, yeah.
And does it appear to be altered in any way?
No,
Your Honor, at this time, the state seeks to admit State's Exhibit 4 into it.
No objection.
Admitted.
And Your Honor, this is the time that I would begin to publish.
You can start doing that and I'll meet you there.
And okay.
Yeah, I know. Skip it. Yeah. That's why. You skip that.
Okay. So, looking at Stakes Exhibit 5, what are we looking at?
That's just a photo of the decedent's bag tag where it has his case number and name. And that's basically at the date that the case was called in or he was recovered from the scene. And it's basically just an identifying number.
Okay. And Stakes Exhibit 6.
This is usually a series of 2 photographs we take that we call as received or as is photographs. So when we unzip the bag straight from where they came from, maybe the hospital or straight from the scene, we unzip the bag and then that's it. Before we take off any clothing or medical equipment, we just take a picture of how the body's received.
And Stakes Exhibit 7.
And this is a standard identification photograph that we take of everyone who receives an exam. So
presented from the autopsy are able to conclusively show all those elements and further lessen the probative value of 10 on its own. So that's where I was with that under 403. At this point, I believe it would be appropriate to ask Mr. Wright if you have any motions.
I do. I have a motion for directed verdict.
All right, any argument?
Yes, Your Honor. Your Honor, this case really,
Okay. And as a result of your autopsy, were you able to determine cause of death?
yes,
And what was the cause of death?
gunshot wound of neck.
Okay. And were you able to determine the manner of death?
Yes,
And what was the manner of death?
homicide.
Mhm. Those are all my questions. Thank you very much.
Any cross?
I have no questions.
This witness be excused, Mr. Lee.
Yes, Your Honor.
Thank you, doctor.
Thanks.
State may call its next witness.
Your Honor, this time the state rests.
All right, members of the jury, there are a number of things that we have to do outside of your presence once the state rests. So I'd ask you to step in the back and we'll be with you as soon as we're done. Thank you.
All right, for the jury.
Okay, so a couple of housekeeping things first as it relates to State's Exhibit 10. Let me just complete the record here. I was able to locate Albury versus the state, a 2022 Georgia Supreme Court opinion, 314 Georgia 459, which breaks down that since the adoption of the now not so new evidence code, but the previous distinction between pre and post incision photos isn't really what guides. Instead, it's your classic 403 analysis. And in terms of the probative value, I think the state is correct to note that it does further show the manner of death and the location of the bullet, but that probative value in my mind is minimal when compared to the graphic nature of it, and especially when considering that there is the other exhibits and photos presented from the autopsy are able to conclusively show all those elements and further lessen the probative value of 10 on its own. So that's where I was with that under 403. At this point, I believe it would be appropriate to ask Mr. Wright if you have any motions.
I do. I have a motion for directed verdict.
All right, any argument?
Yes, Your Honor. Your Honor, this case really, all the counts really go, except for battery, which we've all but conceded in our opening statement. So my argument here, it goes to everything but battery. The state's theory of the case and the evidence presented really is looking at it from a party to the crime analysis. They sort of said in their opening, which I think is true, we look at before, during, after. Are there indicators, aiding, abetting, encouraging, counseling, participating, things of that nature, which would lay the foundation for a jury to consider party to the crime? Well, the evidence right now is undisputed that there's no evidence that my client knew that Mr. Spears had a gun. He has no knowledge of that, as in nobody, whether other witnesses or any evidence in this case, has established that even circumstantially, that he had any knowledge of a gun. Two, there's nothing that's come into this case about him encouraging, aiding, counseling, doing anything, any discussion about a gun, about robbery, about any criminal act with Mr. Spears. So we don't have anything on the front end. So when we talk about the murder, the aggravated assaults, we're essentially talking about something that's relating to a gun that my client, based on the evidence in this case, had no knowledge before. It wasn't until that gun comes out at the scene, and I would point the court to Hogan v. State, 336, Georgia Appellate, 471. It's a 2016 case. In that case, the defendant went with his grandfather to a location, but did not know grandfather had a gun. Well, when they get to the location, grandfather ultimately pulls the gun out, uses the gun. There's even some language which talks about the defendant saying something after that shot that could be construed as somehow encouraging, but it says, the shot's already been done. It's after the fact. That's not what we're talking about when we talk about party to the crime, somehow encouraging, aiding, abetting. A lot of times in these cases, we see a defendant who has provided a weapon, provided ammunition, has encouraged someone to bring a weapon. We don't have any of those things. And ultimately, we have even a witness in the case saying, hey, I was with them. I didn't know that he had a gun. And she also provided evidence that said my client started yelling at Mr. Spears immediately after the shooting as to, why did you do that? You know, and I think her testimony, I'll just characterize it. It was fussing him out about what just happened. Well, that is, I think, right on point with the fact pattern we have in Hogan, which is essentially saying, if he didn't know this individual had a gun, the individual uses the gun, we can't afterwards make assumptions or otherwise say, well, he must have been a party to it. The state in its opening suggested and asked a couple questions about maybe an armed robbery. But again, there's no conversation, no evidence of a meeting of the minds. Just like the supplemental charge talks about conspiracy. Well, in order to have a meeting of the minds, an agreement for conspiracy, there has to be some evidence. We don't have any evidence that Mr. Spears and Mr. Johnson conspired to do anything prior to leaving work or even when they get into this car situation. The evidence, again, in the light most favorable to the state, is that Mr. Johnson gets out of his car, or the car, starts going over to the victim, starts punching. Mr. Spears gets out the other side, he goes. And he ultimately at some point pulls a gun, which right now it's undisputed. That's the first time there's any knowledge of a gun. Him using a gun, and in the Hogan decision, they even talk about the defendant could not possibly have known whether or not his grandfather was going to use a gun to say that he was somehow a party to it. So ultimately, Spears uses this gun and creates the murder. Well, since you can't say that my client was a party to it on the front end, he wasn't a party to ag assault or anything to do with the gun, there was no armed robbery or anything else, then the murder fails. The felony murder fails. The aggravated assaults, which are essentially different species of ag assault, the pistol whip, the apprehension, and then the actual shooting, I think is sort of how, and then there's the ag assault on the passenger. So I think that's what covers all the ag assaults, but it all goes back to the gun. And what evidence is there in the record in this case that my client had prior knowledge of a gun? The answer is none. That he encouraged, provided, did anything about the gun? None. So he can't now be a party to the crime, to these series of felonies that all rely on the gun. Technically, we don't even have evidence of what gun, what caliber bullets. We didn't have forensic experts and things of that nature, just from a technical standpoint. But, you know, just sort of, again, making the case, do we simply say, even though we don't know, we don't have evidence of knowledge, we don't have evidence of conspiring, we don't have evidence of encouraging, we don't have any of that, as the state sort of tried to make in their opening with scenes of the fire. Oh, well, he started the fire. Well, that's not starting a fire or creating a situation where there's an argument or something that turns into a fight. Doesn't say, you're now a party to the crime. The state would simplify the law that way, but that's not what our law says. There has to be that step, that participation, him deciding he's going to lose his temper, albeit dumb and illegal, and battery, doesn't say that, hey, I'm now on the hook for a guy who had a gun that I didn't know about, that I didn't know would be out there at the same car and be out there trying to be a fool, even assuming, as the states tried to intimate, he's now trying to do an armed robbery. Point is, he'd have no knowledge of that. And he's now being said, oh, well, if we intimate that some of these things are happening, we're going to say he must have known about it. Well, okay, well, what evidence? There is none. So all the counts, Judge, that really go to needing that link of knowledge, encouragement, counseling, aiding, and abetting, all of that, I'm suggesting to the court, should fail. And the only thing I think that's left in this indictment is the battery. Even from a circumstantial evidence case, I think there still have to be indicators that go to these specific points. And if there's not, which there isn't, this case fails. So for that reason, Judge, I would ask for directed verdict on the murder, felony murder, all the ag assaults, the possession of a firearm during commission of felony, because again, one, I guess I'd even add, he never had a firearm. There's no testimony he ever possessed it. You know, a lot of those cases, they have the firearm before and they give it to a co-defendant who then uses it. We don't have any of that. If anything, we have the exact opposite, that he's cussing out this individual because of the gun and because everyone was surprised by the gun. So I strongly encourage the court to grant a directed verdict based on the authority set forth in Hogan v. State. I think as to those felony counts, he's entitled to a directed verdict.
We do this, Mr. Lee. Can you play that 1 minute clip? Just the interactions one more time for me? I know we'd probably see it again during closing, but it's important for the purposes of this argument. Okay, Mr. Lee, your argument.
Viewing the evidence in the light most favorable to the prosecution, we'd ask the court to deny the defense motion for a directed verdict. We believe there is sufficient evidence on all the counts for it to go back to the jury. This argument that there was no evidence that Mr. Johnson knew that there was a gun ignores what Your Honor just saw. And what Your Honor just saw in the video was Mr. Johnson and Mr. Spear standing side by side while Mr. Spear is pointing a gun into the car of Mr. Antoine, Mr. Life. And then he comes back second time, 3 seconds later, after the gun is still being pointed at him, and comes back again and points this gun. There are other witnesses who saw the gun. Mr. Lott indicated that he saw it. Miss Ponder, who wasn't standing as close as Mr. Johnson and Mr. Spear, saw the gun. The 911 caller from Danielle, I'm driving by this guy pointing the gun. So everybody saw the gun. And we can see it clearly in the video. So as far as the aggravated assaults cases, charges, excuse me, with regard to
do you have you ever found a case or some language to the effect of, and similar to the malice murder charge, where it will say that malice can be formed in an instant? Do you have anything like that that's comparable to the formation of a conspiracy?
Believe I want to say I've read it before. I will. I know we're going to break at some point in the company, but I don't want to commit to that. But I do want an opportunity to look at it.
What about you believe you've proven all the elements in this case? What do we have to show venue?
Detective Allen. I asked her what county this incident occurred in. She said Fulton.
All right.
With regard to this argument of encouraging, there's nothing in the statute that says encouragement has to be verbal. Okay. I believe if you consider this incident in its context, the fact that it started with a perceived road mishap by Mr. Antoine that led to a verbal argument between Mr. Antoine and both Mr. Johnson and Mr. Spear, that Mr. Johnson, who's driving the car, cuts him off, that they both get out the car and respond violently, that there is a time. This whole thing happens with in about a minute and 11 seconds, I think. But there is time for Mr. Johnson to discourage these actions if he wanted to. He actually left and came back, and he doesn't come back. I know that the defense want to argue, oh, he was trying to diffuse the situation. That's a jury issue for them to decide. When they look at that video, do they really think he pushed him out the way because he didn't want want any more violence to come to Mr. Antoine? No, because he's pummeling them again. So when Mr. Spear is beating him over the head with the gun, the aggravated assault that count that relates to that, Mr. Johnson, excuse me, is standing right there and still has his hand in the car. So it's the state's position that we have presented sufficient evidence in this case such that it should be decided by a jury. We would ask the court to deny the state's motion. Excuse me, the defense's motion. And before I sit down, if you had any questions, Your Honor.
No, Mr. Lee. So I'm trying to look very, very carefully at, you know, the party to a crime charges and the traditional conspiracy crime charges. And I think, Mr. Wright, you would have a very compelling argument here if it were not for that maybe 6-second portion right there where the gun comes out. It is prominently displayed, and construing all inferences in favor of the state at this phase, I think a jury could find that Mr. Johnson was able to see that there was a gun through the window at that point in time. And what we then see in those just, again, very short time frame is that Mr. Johnson comes back to the window and resumes striking the alleged victim in this case. And even if it's just for those 5 seconds, it's my understanding of party to a crime where when we're talking about whether someone has intentionally encouraged someone or helped in the commission of a crime, that there's no requirement of how long that has to have happened, and that it's similar to the forming of malice. It can happen in an instant. And so if the jury believes that that's enough time and that was a joining of the conspiracy, or that was a help or encouragement, that's a factual determination they can make. I think legally that at a bare minimum that return to the window with the gun out allows the case to get past a directed verdict. And I'm looking at the case the Hoagland case you've cited, and it's based on, you know, they talk about Ratana, I think, as well. And I'm not seeing the facts equal up in that regard, where in Hoagland, it looks like they couldn't point to anything at all that the defendant had ever even seen a gun or knew that a gun was at the scene. Here we've got, at least at a minimum, again, a 5-second window where I think a jury could infer that he saw a gun and yet resumed the assault. And so for that reason, I don't believe a directed verdict would be appropriate on these counts. And I'll deny the motion.
Sure.
All right. Mr. Wright, is Mr. Johnson prepared to get into a colloquy with the court about his right to testify?
I have one brief moment, Judge. He's the court. And my client is ready for the colloquy, and he's going to invoke his right to remain silent.
Okay, well, let's go through it. So, Mr. Johnson, I have a few questions for you, sir. And if at any point you need to ask your counsel for follow-up, feel free to do that. All right, so Mr. Johnson, do you understand you have a right to testify? And if you want to testify, then no one can prevent you from doing so.
Yes, sir.
And do you understand that no one can make or compel you to testify? That is, you have a right not to testify if you do not want to. Do you understand that?
Yes, sir.
Do you also understand that not you, but your lawyer, excuse me, do you understand that not your lawyer, but you personally are the one who decides whether you will testify or not?
Yes, sir.
If you do not testify, then upon proper request, the court will instruct the jury that your decision cannot be used against you. Do you understand that?
Yes, sir.
You understand if you choose to testify, you'll be examined both by your counsel and cross-examined by the state.
Yes, sir.
Do you feel you need any additional time to think about whether you want to testify or not?
No, sir.
And do you personally want to testify or not?
No, sir.
All right, well, I find the defendant has decided not to testify with a complete understanding of his rights. Mr. Wright, are we ready to come in and formally rest on the record? We have other evidence you wanted to present.
No, we intend to rest, Judge.
And so the issue with the prior conviction or the other conviction
Oh.
is resolved?
Ooh. And if I can confer with the state real quick. Did y'all look into that?
Yeah, there's,
Um,
Conviction of the co-defendant. So that's the only thing tender. So at this point, I'd say we'll just rest. All right.
okay. Your Honor, we're just going to rest.
Okay. All right, so the plan will be to bring the jury back in. The defense will formally rest for the record. I don't think the state would then be entitled to rebuttal of any kind. And so then we would proceed immediately into the charge conference. We still have 3 working hours today. I thought as a charge conference may take 30 to 40 minutes, maybe less. So I would think at a minimum, the state would do its first opening. We'll do a break to get your PowerPoint in order if you need to, but that first opening on the law and that sort of thing, I think we have time to get to that today. You let me know, how much time you might need to prepare for that. Or perhaps you were thinking you were just going to waive your opening closing altogether. I don't know.
No, I do intend to give a open and closing argument. It'll be the state's preference to start fresh tomorrow since we have to carry over into tomorrow likely anyway. I will tell you, I'm not gonna take on 2 hours of closing, and it's not gonna be any different than other times that I close before, Your Honor, so.
Okay. Well, Mr. Wright?
And I was just gonna say, if I was in the situation, I would want to start tomorrow also. So
All right.
obviously, professional courtesy, I have no objection.
Well, I don't want to make it appear like I'm penalizing either side for being efficient. So we'll do that then. So I'll bring in the jury and we'll send them home for the day.
Yes, Judge.
Okay. Counsel, or if one of y'all or both could approach, I've got a verdict form in our request to charge consolidated.
Closings tomorrow. I should try to have it ready today.
all right, yours. You're the president, counsel.
All right. Thank you, Deputy Scott. So members of the jury, as you heard before the break, at this time, the state has rested and presented their case in chief. So at this point in the trial, we would turn it over to the defense and give them the opportunity to present evidence if they would like to. However, as I instructed you at the outset of this trial, the defense has absolutely no burden at all. It doesn't have to present any evidence if they don't want to, because the burden and the presumption always rests with the state. So, Mr. Wright, defense have any evidence to present today?
Your Honor, respectfully, we believe at this time we will simply rest.
Okay. All right. So, members of the jury, the evidence is closed in this case. And the next thing that would happen would be closing arguments. And because we are very much ahead of schedule, and there's actually still another thing that we have to do outside of your presence in order to prepare for closing arguments, we think it best at this point to break for the day. And so I would ask y'all to be back tomorrow at 9:30. And at that point, once we're all here, we will go right into closing arguments. What we're going to I want to check usually for, since we anticipate you having the case and beginning your deliberations, I want to confirm before you leave, we usually try to provide lunch for deliberations. And so let me check before you leave that we're going to be able to do that. And we can still place that order. If so, we'll let you know. But for now, we'll break for the day, 9:30 tomorrow morning. And again, the thing I would tell you every time is do not conduct any research about this case whatsoever. The only thing you're going to learn about this case happens right here in this courtroom. And don't talk about this case with anyone at all, including any family members when you get home, or even amongst yourselves on the way out to the elevator. So with that, thank you so much. We'll see you tomorrow morning. And I'll be right back.
Really quick.
What these are the jury charges. Most of these are set by law. That's why when you see these numbers, that's what we just basically call pattern.
Deputy Scott,
Engraved
we're off the record here.
suspicions.
If you could tell the jury that
This is one that
is
I
the IT
request.
outage, it's unlikely that we'll be able to get them lunch. We're going to still try, but I would say that's not guaranteed. Right? Okay, so they should bring their own lunch, just in case if that's what they were planning. Okay, we are on the record and back with the charge conference now. I've handed both parties a consolidated version of all the charges in this case, or at least all the requests from both sides. And I'm going to mark a copy of this consolidated version as Court's Exhibit 1, and I'll tender that for the record. Maybe an easier thing to start off would be I've also handed a proposed verdict form to all the parties. Any concerns or objections with using this as our verdict form?
None from the defense.
None from state.
Okay. Also, I keep putting off the charges, but just because I have it in front of me, when we're talking about what exhibits go back, again, since there's only a handful here, I think we can address that now and without too much difficulty. But I wanted to flag, and I don't. In a situation like this where we're dealing with a surveillance video without sound, my understanding of the case law is that actually can go back to the jury and wouldn't be a violation of the continuing witness rule. But the question becomes, how then do they play it? And so unless the state has some kind of device that's wiped free of any other program or Wi-Fi connection, they're just gonna have to come back out and watch it as many times as they want to. I'd anticipate that this is gonna be one that they're gonna watch a couple times. And so I'll just put that to the state and the defense if we want to allow them just to have total kind of independence there, with the exhibit. I think they have a right to it, but only if certain provisions are made. So with that, Mr. Lee, any thoughts?
At one point, we had a computer like that. That's not the case anymore, so we just don't have them.
All right. Well, if we don't have one, then that settles it. So otherwise, I guess for the purposes of the record, Mr. Lee, what exhibits do you think ought to go back? We have 1 through 11 that have been tendered and admitted.
All of them do, yes, I believe they all go back there.
Well, we know 10 wouldn't because we said we weren't going to publish 10.
Right.
And
The CAD report.
the CAD report, what's your thought on that?
I think that would be a continuing witness rule. I think if they ask to see it, it's one thing, but because there are narrative notes in that report, I would ask that not go back with the jury.
Okay, we'll take a look at that. And in terms of the actual, we have the discs, or maybe, do we have it on a disc or a flash drive? The 911 call and the surveillance video states exhibit 1 and 3?
On a disc.
Okay, and I know sometimes we'll just send the disc back, and then that, I guess, flags for them. If they want to watch it, they'll ask us, right? So we'll just send the disc back. So really, it sounds like the only issue here, all of them go back except for 10 and possibly 2, and we can just address 2 in the morning if you want.
Yes, that's
Okay, unless the state has a position now on the CAD report.
not right now. I'd like a moment to look at it.
Okay. All right. So moving to the charges. I've got the document that I tendered as Courts Exhibit 1 is labeled, is paginated 1 through 58 with 1 charge per page. And I'll just kind of run through these and stop as, if anyone can feel free to stop me if there's some things to talk about, or but I'll just go through them until I hear from the parties. Beginning with indictment accusation. And I should also note for the record and for counsel, Mr. Wright, that the plan is to consolidate all of these, eliminate the headings, and provide the jury with a copy of the charges. Just FYI. Okay. All right. So page 1, standard charge, pattern charge that I would give. Same with page 2. Presumption of innocence is the pattern charge that I would give. Page 5, there's grave suspicion. Hearing no objection, I'll give that as a pattern charge. Page 6, again, jury judges of law and facts. Pattern charge that I'll give. Page 7, evidence. There's some parentheses that I think we can knock out here. So on page 7, I would strike or the equivalent, such as depositions. I don't think there were actually any stipulations that were eventually made today, so I would strike that parentheses. And I didn't take judicial notice of anything, so I'd strike that as well. Moving on to page 8, because there were no stipulations, I'd strike that charge in its entirety. Page 9, we have the full direct and circumstantial evidence pattern charge, which we'll give. Page 11, credibility of witnesses. The pattern charge, I don't see any amendments to it. Page 12, we had our 1 expert witness, pattern charge that I'll give. On page 13, we get to a witness attacked. We didn't hear about any felony convictions or character for untruthfulness or crime of dishonesty. Do we believe that this should be included for the bias aspect of it? What would this apply to, Mr. Lee or Mr. Wright? My only thought is Ms. Ponder.
Oh, I was maybe thinking the first witness.
Right, that too.
Well,
Okay.
he's a defendant witness, but maybe they might evaluate this with him, but also Ponder. So I guess
Okay.
leave it in with just the bias.
Just the
section,
bias.
yeah.
Okay, so we'll leave it in and it'll end at witnesses bias towards a party. Any other thoughts, Mr. Lee?
If any of the witnesses were attacked at all. That's my.
Well, this, I guess it doesn't really say that when you read the language of the charge, it just talks about credibility or believability and bias as an aspect of that. I don't know if Mr. Wright intends to focus on that in his closing at all, but it doesn't seem like there needs to be a formal attack on those fronts to.
It has to be a challenge, I guess. It says challenge the credibility or believability. And I don't think any witness was challenged on anything that they.
Where does it say challenge?
In the first
Top
paragraph,
paragraph.
in determining the credibility of the witnesses and any testimony by them in court, you may consider where.
Evidence offered to challenge. Okay.
I
All
don't-
right. What do you
I don't
think, Mr. Wright?
believe anything was challenged. That is true. So,
What do you think? In or out?
I would say that we could probably safely keep it out.
Okay, then without objection, we will strike page 13, witness attacked. To that end, I believe page 14 falls in line with that and also comes out, which is witness supported. Same with witness impeached. Again, maybe Ms. Ponder or Mr. Lot those would be the ones we're talking about. Do we think a witness was impeached in this case?
I don't believe so.
Yes. As far as we would keep it in with regard to Miss Ponder, I believe the video contradicts some of what she heard, as well as the 911 call about not hearing a gunshot and so we would have that stay for that reason. Even though she wasn't impeached by
Sure, but the
evidence.
evidence itself. Okay. Any thoughts, Mr. Wright?
I'm not sure how the 911 call, because someone else claims to have heard a shot. If it'd be different if the 911 call, you could hear the shot. But just because someone else hears a shot doesn't automatically impeach another witness who said, I didn't hear a shot.
It doesn't automatically. This is more saying that a witness can be impeached. And so if there's something somewhere in the record that could disprove the facts they testified to, I think it invokes this charge. And that's something that I think is argued in closing, whether you should believe her or not. I think I would leave it in on those grounds.
Understood.
Okay, moving to page 16. There were prior statements referenced, but were the substance of those prior statements ever admitted? I don't think so. So we'll strike 16, page 16. Page 17, standard charge on single witness, that I'll give. Page 18. We have defendant's choice not to testify. Not testify. Okay, and I'll give the full charge there on page 18. Okay, and then from here we have the pattern charges. If a statement of the defendant was introduced, one was not. So I would think we're going to fly through these next ones, and I would strike page 19, statement of the defendant, strike voluntariness on page 20, strike circumstances on page 21, strike burden of proof as to page 22, strike constitutional rights on page 23, strike corroboration on page 24. And then we get to limiting instructions on page 25.
I don't think there were any.
Again, none come to mind either. So I would strike page 25 on limiting instructions. Page 26, there are no 404Bs here or other acts, so we'll strike that. Prior convictions, none were admitted, striking page 28. Identification, do we need that, Mr. Wright?
I don't think so. I mean, there's been 3 in-court identifications and we've never made an issue. So no, I withdraw.
All right, we will strike page 29 and 30, which is identification burden of proof. And then we get to definition of a crime. So page 31 looks like the pattern charge, which I'll give. Page 32 brings us to intent. I don't see any need to change anything in there, so we'll give that. Page 33, no presumption of criminal intent. And I'll include the parentheses or the absence of it. Takes us to page 34, presumptions and inferences. Seems to be the pattern charge that applies, so I'll give that. That takes us to page 35, parties to a crime. Do we need to more narrowly tailor this? Or are there certain aspects of this we don't think are, that there's slight evidence of?
Yes, I would say the advises, hires, counsel, procures. I don't believe that applies, but help and encourages does.
I guess I would almost want to keep it all just so I can
That's probably the safer.
clear to them.
Safer course, what that means and how you compare it. So I think that's probably the better thing to do. So we'll just keep page 35, parties to a crime in its entirety. That takes us to page 36, knowledge. I'll keep the parenthesis and was not a conspirator in it. Otherwise, I believe it is a pattern charge and would stay in. I believe after that point, we would generally include the conspiracy charges, but I'm trying to see where those are in here. I know those were the supplemental requests, so.
Separate document, Your Honor.
Sorry?
Separate document, Your Honor.
I know that. I just, I'm wondering if it made it into our consolidated version, so we'll take a look at that. We'll keep going and see if maybe it's hidden in here somewhere. So I'm on page 37, malice murder. And I guess I'll include the parentheses without justification, even though that's really not raised as a defense here, but I'll still include it. The remainder of it is the standard pattern charge. Page 39, we have motive, standard pattern charge that I'll give. We turn to page 40, we have felony murder. The sole count of felony murder in this indictment is predicated upon aggravated assault. Then we have causation in felony murder. And I think we should add something here just to make sure it's very clear that the felony murder is predicated on count 3. And so on page 41, the causation, I think I would add, he caused the death of another person by committing the felony of aggravated assault as alleged in count 3, just to distinguish it between the other aggravated assaults. Any other thoughts there?
No objection from the defense.
All right, Mr. Lee, anything to add?
No, yeah.
Okay. Then we distinguish between the aggravated assaults and the charges. We have aggravated assault with a deadly weapon. But then count 4, let's see, count 5 is where we have an aggravated assault just with an offensive weapon. So that's different than aggravated assault with a deadly weapon. And so I think we need to add in that additional version of aggravated assault. Find that pattern charge.
I think it's still 221 or 22021. It's just a parenthesis issue.
Okay. Let me locate it. Okay, so I think what we need to do here to more narrowly tailor aggravated assault is, as Mr. Lee mentioned, I think we add, or just we'll do it from the top. For aggravated assault, the state must prove that the defendant, 1, assaulted another person, and then 2, with a deadly weapon. And maybe we do it this way, with a deadly weapon, and then in parentheses, as alleged in counts 3 and 4. And then we could say, or with an offensive weapon as alleged in counts 5, just to very much delineate that there are 2 different types of aggravated assault. And we'll go over this again, and I'll be printing this out to show you the updated copy to make sure we're okay with it. Any thoughts there, Mr. Wright?
No objection, Judge.
And then we would add in that second sentence, or the sentence following. However, or excuse me. We have the, however, since with the final line, which is an offensive weapon is any object that is likely to cause or actually does cause death or serious bodily injury if used against someone. We have, following that, firearm is a deadly weapon. Yeah, and I think that would satisfy it. Okay, so we'll have that consolidated and we'll go back over that again. But page 42, essentially we're adding in the with an offensive weapon as one of the elements, but having it as an or. So maybe it's 2A with a deadly weapon or B with an offensive weapon. Okay.
Then, I believe the other parentheses, committed in that place of person in reasonable apprehension of receiving a fear, because that's how we indicted it. I don't have the indictment because I gave it to the court.
Okay. All right. Well, we want to be very careful about this. So count 3 is unlawfully committing an assault by shooting him with same being a deadly weapon. So count 3 is your standard deadly weapon. Count 4 commits an assault aiming a firearm, placing him in reasonable apprehension of receiving a violent injury. Okay. So I think they actually charged it 3 different ways. Okay, well, actually, is what you were saying is the final sentence here, the however sentence, that is fine in the pattern charge and covers the charging language?
Yes, I just believe that both parentheses apply because specifically the attempt to cause violent injury to person applies to as count 3 aggravated assault, and then the committed an act that place of person in reasonable apprehension of fear of receiving immediate bodily injury applies to count 4, and but applies to count 4. I think only because that's
Okay. So, Mr. Wright, do you believe that is there any additional delineation we need to do in terms of what aspects of this apply to counts 3 and 4 and 5? I mean, they're all kind of indicted a little differently, but it seems the pattern now points us to what applies to what.
I think we're good, Judge.
Okay. All right. Well, we'll take another pass at that one when it's in the consolidated version. Page 43 is this pattern charge on firearm as a deadly weapon. Page 44, possession of a firearm during the commission of a felony. It tracks the indictment. And I don't see any changes there. Page 45, we have the pattern charge for battery. As indicted, it does reference visible bodily harm. So I think we would strike causes substantial physical harm and just say a person commits the offense of battery when that person intentionally causes visible bodily harm to another. The term visible bodily harm means bodily harm capable of being perceived, and then the remainder is the pattern charge. Is that accurate? Mr. Lee, what do you think? It's not indicted as substantial physical harm.
Yes, they have track the indictments.
I think it's
Okay.
fine, Judge.
And we would also ask for a lesser included simple battery.
No objection from us.
Okay. Then we will add the pattern charge for simple battery as well. We'll include that in the consolidated version. Page 46, we have multiple defendants. I'll just strike out, or yeah, I'll keep in the parentheses or all. Well, actually, there's only 2 defendants here, so we don't need the or all, do we?
But it started with 3.
Oh, that's a good point. My mistake. Okay, so we'll keep in the or all. You determine them separately. Page 47.
You made it in, you know. So.
Yes. Because we have prosecution.
Okay, it's a pattern charge. It's a multiple co-defendant case. I think it applies.
Yeah.
We'll have it in. Now we turn to the conspiracy charges. I know those are numbered as 2.02 and onward. I'm wondering if it would make more sense just organizationally to have these follow the party to a crime and
I think so.
so the next 3 charges then 48, 49, and 50 that all relate to conspiracy. We'll have those follow party to a crime, and then from there it goes into the actual offenses. Any objections or concerns with that, Mr. Wright?
I guess my questions, I don't have the indictment right in front of me, but is conspiracy a charged count in the indictment?
It is
or
not.
Is it like, if it's like party to the crime, then it almost seems duplicitous to put that there. I mean, because they're essentially it almost seems like one in the same per se.
There's a lot of overlap, and I think that's the subject of some law review articles that we can all enjoy in our free time. But I think the case law shows there's a distinction between the two in certain circumstances. And as I understand it, it doesn't have to be charged to be included and asked for and argued. And both of them cover separate theories of law. But I'll hear from the state if you want to add in on that, if you have something at your fingertips that addresses Mr. Wright's concerns.
Oh, yeah, I mean.
Hi, guys. Do you want to skip this part? Good to keep watching. How's it been going? Everybody been good? Looks like it. Angie loves the addition of the South African flag. Hey, Sim. Haven't seen you in a bit. There's also still, how many hours of this did I say? I think I said there's 6 hours. Has YouTube changed things again? They've changed things, guys. They've changed the appearance. Oh, they've made it look horrible. Everything's so small. There is another 8 hours of this. So there's 1 hour left of this one, and then 8 hours of day 2. My meds haven't worn off. I still have writing to do. But I just finished the call, so I thought I'd pop in, see what's happening, see if we should be skipping. I need to go into focus, so I don't mind if it's relatively boring, but I don't want you guys to get bored. I'll leave it playing for now and wait for a vote.
I mean, I believe it comes in, there's case law that says it doesn't have to be. I don't have anything to add other than what you just said, John.
Okay.
And just, I'll make a record. My only concern is the third part of the conspiracy charge, which talks about presence, companionship. Those are things which, if read too close to the party to the crime, it almost seems like it expands the analysis. Or if too close, it could expand what parties to the crime is saying, because that seems like that's creating more category.
Mm-hmm.
So I guess, I don't know, I would ask the court to keep them apart. Because I just hate if a jury blends them together, thinking like, even my first thought was they're pretty much the same.
Sure.
But if I blend them together, I'm not understanding there are some differences.
Okay. Well, I think we can keep them separate then. And then Mr. Wright, it can be up to you in your closing to work through each of those and emphasize that they're separate, and if neither of them apply, how so? So that's fine.
Right, so here we are, day 2. That's their blocking, not me. Mine just rolled out like literally within the last few minutes. It must have been, even because I was on YouTube in another tab. For those who are new, my job is writing for a few YouTube channels that subtle flex all add up to about 1 million subscribers between the 3.
Judge McAfee,
Sir.
38 was just like let in the door.
Okay. All right, Deputy Scott, feel free to bring him in. Of proof, they have the ability to open and conclude closing arguments. And so at this time, I'll ask the state if they are ready to proceed.
We are, Your Honor. We would like to open and conclude.
All right, Mr. Lee, the floor is yours.
Thank you. Good morning, everybody. All right, just wanted to start by thanking you all for being here and being patient with us. There's some technical issues in the beginning, but I just want to thank you on behalf of myself, co-counsel and my team, family, Mr. Antoine. So what I'm gonna do first is discuss the law. And then I may give some real life examples, because I know you all aren't lawyers, so I try to relate it to something that may help you understand. The judge is gonna give you the law, that's the law that you will follow. I was just mentioning about technical issues. So, I'm gonna start by talking about your duty. Your mission is a truth-seeking mission. You were selected because you can be honest and impartial. That's what we're asking for. Honest, impartial jurors who are honestly seeking the truth. A criminal trial is not about a search for doubt. You're not searching for doubt. You're evaluating the evidence to try to make a honest and truthful decision about what happened that day. Okay? It's not a search for doubt. If there is a doubt, that doubt will find you. And then no matter how much you deliberate and go over evidence, you just can't get past it. Okay? That's basically what a reasonable doubt is. Okay? It's not a vague or arbitrary doubt. It's a doubt based on common sense and reason. I liken that to, say you go to the grocery store, okay? You get your favorite brand of cereal. My son likes Cinnamon Toast Crunch. So when I go to the line and I get the box, I can't look inside the box to see what's inside, but based on my common sense and experience, I can say beyond a reasonable doubt that there's Cinnamon Toast Crunch inside the box based on how many times I went and got Cinnamon Toast Crunch. Now, is it possible that, the manufacturer made some kind of mistake and there's Cheerios in the box? Yes, it's possible. All things are possible, but it is reasonable in light of my experience. I'm still following. And the defendant enters upon this case with a presumption of innocence, and that presumption remains with him. And until it is overcome by the state with sufficient evidence to convince you beyond a reasonable doubt that he's guilty. And the burden of proof rests with the state. We proudly accept that burden. It never shifts over to the defendant. Evidence can be direct, circumstantial, or both. Direct evidence is evidence that can be seen, heard, taste, something that's perceived through the human senses. So when Mr. Lot testified and said, this is what happened, this is what I saw, this is what I heard them saying, that's direct evidence. Okay, he's talking about something he saw. Okay.
Circumstantial evidence is proof of facts or circumstances by direct evidence from which you may infer other related or connected facts that are justified and reasonable in light of your experience. So, example of circumstantial evidence we often heard in law school was, imagine you go to sleep at night and it was a clear night. There's nothing on the ground. You wake up and there's snow on the ground. And there's footprints across your lawn. Now you were asleep when it was snowing, so you didn't actually see the snow hit the ground, but based on your common sense and experience, you can infer from what you see now that it snowed last night and someone walked across your lawn. That's an example of circumstantial evidence. The testimony of a single witness, if believed, is sufficient to establish a fact. Corroboration of a witness is not required, provided that you find their testimony to be sufficient. You are to decide all questions of witness credibility. And in making that decision, you can consider the witness's manner in testifying, their means and opportunity for knowing the facts about which they testify, their interest or lack of interest in the case, the probability or improbability of their testimony, and their personal credibility as you observe it. That's why we have witnesses get on the stand and speak in court, so that you can look at them and gauge whether or not you believe them. And it's up to you to decide whether or not you believe some of what they say, all of what they say, or none of what they say. It's okay. If there was a witness who testified and you didn't believe everything they said, that's okay. But it's also okay to believe some of it, or all of it. All issues of credibility are up to you. Good fact find. Now, parties to a crime. I'm gonna spend some time on this one. Every person concerned in the commission of a crime is a party to it, and they can be prosecuted and convicted for the commission of that crime. Whatever one does, they all do. That's the law in Georgia. I got caught up. All right. Now, a person is a party to the crime when they directly commit the crime, they intentionally help in the commission of that crime, or they intentionally encourage another to commit the crime. There are some other examples, but those are the ones that I feel apply in this situation. And when we're talking about encouragement, it doesn't have to be verbal. Okay, there's nothing in the law that the judge gives you that's going to say you have to encourage someone verbally. There has to be some kind of verbal encouragement. Like, good job, come on. You don't have to have that. There are situations in our everyday lives where we receive non-verbal encouragement. I'm gonna give you an example of that. When I was 10 years old, Jimmy Carter had the Atlanta Project. I don't know if some of y'all remember that, but I participated in a photography program where we went around and took pictures, and then we were asked at the end to write a story about one of the pictures we took. Okay, so I took a picture of a birdhouse, and I wrote a story about a bird family whose house was being repossessed by the VIRS. Okay, and I had voices and all that, and I messed around and won. Okay, so because I won, everybody from Metro Atlanta, the winners, had to go to this this auditorium and speak at this banquet, okay? And we had to give our speech out loud. And I didn't want to do it. I'm like, Mom, please, I don't want to go. I stuttered at the time, but you know, she wasn't having it, so she, you don't go do it. So I get up on stage. I spend the first like 10 seconds just you know, looking at everybody. It had to be at least 100 people there. All right. And I never spoke in front of this many people. And so I look at my mom, I find her, and she smiles and nods. That's it. She smiled and nodded. And that encouraged me to give my speech. And so I got comfortable. I started doing the voices and everything. And people started, you know, laughing and clapping as if they, you know, were enjoying what I was talking about. No one yelled out, "Hey, Jeffrey, you're doing a good job." But it was encouraging. That's an example of nonverbal encouragement when you consider the context. Now, if I'm at the grocery store next week and somebody walks up to me and that might be weird, okay? Because that's out of context, okay? But when you consider the context, or let me just say this, consider the context in this situation, okay? Consider what we had in this case, okay? Consider everything that this defendant did that day and ask yourself, was he providing encouragement and help to Mr. Spear? And vice versa, okay? They were doing this together. You're also going to get an instruction on conspiracy. And conspiracy is just a fancy word for an agreement. An agreement to do an unlawful act. And then the existence of a conspiracy can be established by proofs of acts and conduct. Again, it doesn't have to be verbal. It doesn't have to say, hey, you know, let's agree to beat this man up. Doesn't have to be that. When you consider the context and the act of one conspirator applies to all if it advances the object of the conspiracy. Here, their object was to assault and terrorize Mr. Lot and Mr. Richard Antoine. That was the object of their plan. That's what they set out to do. And again, it doesn't have to be verbal. Give you an example of a nonverbal agreement, okay? I like sports, okay? So I'm gonna give you two sports analogies. Let's say basketball, okay? There's a 2-on-1 fast break. They're running down the court. LeBron James and whoever he plays with now. LeBron James throws up a lob without saying a word. The other guy grabs it and dunks it, okay? Their mission is to win the game. And they didn't have to agree beforehand, okay? They knew what they were doing on that fast break. No words had to be spoken. You know, it wasn't necessary for them to run down the court and LeBron James say, hey, I'm getting ready to throw the ball up. And when I do, I want you to go up, grab it, and dunk it. And then the other guy say, okay, I'll do that. All right, here it comes. You don't have to have that, okay? You can have a non-verbal agreement. They happen all the time. And in this case, this defendant shared a shared goal, a shared criminal intent with Mr. Spear to assault and terrorize Wayman Lot. Their mission was to cause pain and fear. That was their mission. And we'll talk more about it when I get back up. I just want to go, just give me the broad strokes of the law right now. Got it? Intent is an essential element of any crime, and it must be proven beyond reasonable doubt. Criminal intent is not the intent to violate the law, but means simply the intent to commit the act that is prohibited. It's not the intention to when we're talking about aggravated assault. Whether he shot with the intention to actually shoot him or scare him, that's not what we're talking. It's the act that's prohibited. The act of shooting in the first place. If he intended to do that, that's where your criminal intent comes from. And intent can be shown by purposely doing the act, and it also can be inferred from proven facts and acts and conduct. We got acts and conduct again. You can infer intent based on the circumstances as a whole. Words, conduct, and demeanor, and motive should be considered. Why did they get out the car that day? They got out the car to fight. What did they intend to do? They fought. And so this is the indictment. Mr. Johnson, the defendant, is charged with murder, felony murder, 3 counts of aggravated assault, battery, possession of firearm during the commission of a felony, directly and as a party to a crime. A person commits murder when that person unlawfully, with malice aforethought, malice afterthought, causes the death of another human being. That's what the state has to prove for murder, that he unlawfully, with malice afterthought, caused the death of another human being. And again, we're talking about parties to a crime. Okay? And legal malice, when we talk about malice, it's not necessarily ill will or hatred. We don't have to prove that this defendant hated Mr. Antoine, okay? It's just the deliberate intention to kill. And that can be either expressed or implied. And express malice, and malice can be done in an instant. You can form malice just like that. You don't have to, be thinking about it for a long time and before you decide to kill somebody in order for it to be malice murder. It happens just like that. Okay, I didn't realize that was going to be that small. But express malice is the deliberate intention to unlawfully take the life of another human being, which is shown by external circumstances capable of proof. So express malice in this case, if you're thinking about when Mr. Antoine was actually shot, if you believe that Spear shot Mr. Antoine on purpose, that's an example of express malice. And it can also be implied, and this is the big one. I'm going to talk about this when I get up to, when there is no considerable provocation. Okay, when there is no considerable provocation, and all the circumstances of the killing show an abandoned and malignant heart. Okay, that's how you can have implied malice. And again, you want to consider the circumstances before, during, and after. And I believe when we're talking about implied malice, this question that I bolded is going to be an important one for you to answer. What set them off? Why did they get out the car? Okay. Again, I talked about this when I was talking about malice. We don't have to prove premeditation. That they planned this beforehand. Don't have to prove motive. I believe we proved it here, but we don't have to prove motive. This was the road rage incident. This man was killed because they got mad. Now, for felony murder, the difference between felony murder and murder is you don't have to have malice. All that's required is you are in the commission of a felony, and during that commission of a felony, somebody died. That's it. So when they're committing, so if you find that these defendants, together as parties to a crime, committed aggravated assault, when Mr. Antoine was shot in his neck, and that caused the death of Mr. Antoine, if you find that they're guilty of aggravated assault, he's also guilty of felony murder. We don't have to go through the extra step of deciding, well, was the killing intended or not, okay? Because the felony was intended. Our law recognizes that there are certain inherently dangerous felonies that when you commit them and someone dies, you should be held responsible for that. So in the indictment, we charge aggravated assault a couple of different ways. In count 3, that involves Richard Antoine. That involves when he was actually shot, okay? And so a person commits the offense of aggravated assault when he assaults someone with a deadly weapon. Those are the elements. And in Georgia, the handgun is a deadly weapon as a matter of law, okay? He was shot with a gun. All right. Go back one. And for count 3, we don't actually have to prove we don't have to prove actual injury. We just have to prove that they attempted one. But here you actually have one because he was shot. Okay. Now, a person also commits aggravated assault when he assaults someone with a deadly weapon. Go back one more. And places the victim in reasonable apprehension of receiving a violent injury. That's another way you can commit aggravated assault. Okay, that's what an assault is. It's placing somebody in fear of receiving an immediate violent injury. Okay, and so when we're talking about the aggravated assault alleged against Mr. Lot, referred to his testimony. The gun was pointed at him. He was assaulted with the handgun. The handgun was pointed at him. Okay, and he was scared for his life. Okay, he was shot. He didn't know what was going on. Remember, I asked him why you take your seatbelt off. I can't remember exactly what I was thinking at that moment. There was a lot going on. I was going to defend myself. I probably was going to help Mr. Antoine too. This is something he's scared. Okay, he was in fear of immediately receiving a violent injury. He was in reasonable apprehension. He had reasons to believe that he was going to receive a violent injury because these guys just accosted him for no good reason and started pointing guns at him. Okay, that's aggravated assault as it pertains to Mr. Lot. In count 5, this aggravated assault involves when Mr. Spear was beating on him with the handgun while Mr. Johnson's holding on to the steering wheel. Okay. We charged it as aggravated assault with an offensive weapon because in this count, the gun wasn't used in the manner that it's supposed to be used. It wasn't used to shoot. It was used to beat on him. Okay. And an offensive weapon is an object that's likely to cause serious death or bodily injury. Beating on somebody with a metal gun is likely to cause serious bodily injury and death. Okay. If you believe that, then he's also guilty of aggravated assault. Battery, that's when you essentially cause visible bodily harm to another. So this is count 6. This is the counts where Mr. Johnson's punching on Mr. Antoine. Okay. Now, visible body injury is important for battery, and we didn't really get too far into that. Focus was mainly on felonies. But so if you don't find that there was visible bodily harm, that and that's something you can see, like a busted lip or a swollen face as a result of the punches, then you can convict on the lesser included offense of simple battery. Okay. And a person commits the offense of simple battery when he makes physical contact of an insulting or provoking nature. Okay.
or he intentionally causes physical harm to another. I mean, I don't really, he was punching on him, okay? And if you find that that punching is physical contact of an assaulting or provoking nature, then he's guilty of that. Possession of firearm during the commission of a felony, again, this is part to a crime, doesn't matter who held the firearm, okay? If he has on his person or within arm's reach during commission or an attempt to commit a felony, a handgun, a firearm, then he's guilty of possession of a firearm during the commission of a felony. Murder, felony murder, aggravated assault, those are felonies in Georgia. So I'm gonna sit down, okay? And Mr. Wright is gonna have an opportunity to speak to you. I ask that you pay attention to him as well. But when I get up, that'll be my opportunity to speak. Thank you.
I was going to share screen, but looks like I'm disabled as a co-host.
You're not co-host at the moment? All right, what's your username?
Attorney D. Wright.
All right, hold tight for just a second. Can you try that one more time?
Still showing me disabled. Okay. Then go back into it. Okay, yeah, she's still out.
No, do you think you can take a look?
She still hasn't blocked. He still hasn't blocked.
Hey, Judge, he is a co-host.
Not sure how to. Yeah, you can grab it, but I'm not possessive of my own feeling. Oops. Okay. Yeah.
What's that number 08?
Oh,
082830.
yes, sir. Sorry, I'll say something. Now, in bonds. Ask her. I've said. Just my.
Let's have them. Yeah. You can do it. Can you tell him the ambulance has a cause again? No, he's on. He's at it. Okay. Hold on. There we go.
Thank you.
And just so I know, what was the impediment there?
Basically I had to reboot it again and then they added as a co-host. So
Okay. All right, Mr. Wright, whenever you're ready.
Just might shift a few things around. Please the court. Counsel, ladies and gentlemen, good morning. First, let me thank you. This is not easy stuff. One, you're stopping what you're doing in your lives, but hopefully you're seeing now how important this duty is to serve as a juror, to make these tough decisions. And these are tough decisions. It's tough to watch, tough to review. You have families on both sides. I often say in these kind of cases, there's no winner. It's just trying to at least get to the truth and making sure that there's a just verdict in this case. So by nothing that I've said, am I trying to convey, trying to win, or do anything disrespectful to the family who's lost a son. I'm simply trying to get you to see the facts and get to the truth. And if you get to the truth, then your verdict's gonna be just fine. Because you know it's the right verdict because it's based on that truth. And now is where I say, remember I said, take your emotions, your passions, put that aside. Just be a fact finder. Maybe something in your past, something you saw in this trial. Let the emotions be the emotions, but let your logic find your way to facts. So in this case, I suggested to you in opening, and I say to you now, the case against my client, McKinley Johnson, is all about, is he a party to the crime? He's not a shooter. He never had a gun. You don't have one person that ever said they ever saw him with a gun. They didn't see him with a gun on this video, at the shooting, or at any other time. And I'm going to suggest to you as we go through some of these witnesses, as we're listening to these witnesses, we started to see, there we go. This all is about a traffic incident. Well, guess what? When the two young ladies and the two gentlemen, Spears and my client, when they were at work, they had no idea there was going to be a traffic situation. Any suggestion that an agreement, some evil plot was discussed at work, was discussed in advance of a car, in advance of a traffic incident, is speculation, and it's really ridiculous because there's just no way. They left work wherever they were going without a care in the world. There was no evil plot. Dr. Evil wasn't sitting at their lunch table saying, hey, let's go do something. The point being is they just drove. So the before part of this case, Jake said before, during, after, before part says, what do we know? They knew each other for 1 month. There was no long-term relationships. There was no dastardly plots done in the past. You know, they knew each other for a month. They worked together. They did some things together because, hey, trying to help, I think it was an oil change or something of that nature. Ms. Ponder told you. But they weren't close buddies. They weren't allies. They weren't partners in crime. I suggest that slate before says clean. There's just nothing there that should suggest to you some bad doing by any of these individuals. But there is one important fact. Ms. Ponder told you. She never saw Spears with a gun. None of them did. No one had any idea that Spears carried a gun, had a gun. So again, any idea the state suggested to you that somehow before all this happens, there's some malice or some malicious thinking, that's just not supported by evidence. So the before category falls in favor of my client because there's nothing there to suggest wrongdoing. There's no agreement, no conversation, no nothing. So then leading up to the traffic, what else did Mr. Ponder say? They weren't talking in the car. Hey, let's go rob some guys. Hey, let's go hit somebody and get into a road rage. No, there was no conversation. What you have is, I guess whatever small talk, but nothing. So a suggestion that somehow while they're driving, there's some evil thought, that again is speculation, and it's just not evidence. But then an incident happens. Apparently, some trouble was happening where not sure about making a turn, got into a little fray, which happens in traffic. But ultimately, my client who's driving the car almost collides and crashes with the other vehicle. Now, all of a sudden, I would suggest to you, that's the beginning. That's where everything starts. A suggestion that somehow we can impute things from before this time, I would suggest is wrong. What I also suggest is when the clock starts, we're now at 0. It's from this point forward that we start saying, okay, who knew what? Who did what? From this point forward to figure out, are they complicit? Are they aiding? Are they doing something? Or did they have their own agendas? Well, at this point in time, we know the victim has, as we have seen, and you can play the video. I encourage you to play it as much as you need, is waving at the car that's almost had a collision. Luckily, it did not. There's clearly some confusion. Well, while he is of good temperament, he had no wrongdoing in this. He's half of the situation. All the folks in the car, well, they're pissed off. And what did Ms. Ponder tell you? That Mr. Johnson, my client, was pissed. I think her words were he wanted to go beat his ass. That's a young-minded thing, wrong thing, inappropriate. But wanting to go fight him, that's one thing. That's a specific intent. An intent to want to fight somebody is not an intent to want to shoot somebody. It's not an intent to want to do something else. It's an intent for battery. Now, what starts to happen next? Well, my client gets out of the car by himself. He doesn't get out of the car, saying, hey, I don't know you have a gun, but just in case you have a gun, why don't you come on and come with me? No, he's mad. He just gets out the car to go deal with the other driver. There's no conversation. You have no evidence whatsoever that any discussion was ever had between my client and Mr. Spears when my client exits the car. And he goes over to the other vehicle and he begins, albeit stupid, to start punching him. And from the beginning, we've acknowledged to you, stupid. He's fighting this other driver, punching at him all by himself. So exits by himself, without discussion, without agreement, goes to the side, starts punching by himself. This has nothing to do with Spears. Nothing to do with anyone. This was all just about my client at this point. Well, what starts to happen? Well, at some point, while my client is already fighting, Spears gets out the car. I showed you this together so you could sort of see, and you can see it on the video where, Spears is just now exiting the car. It's shortly thereafter. Again, we're talking about seconds. So, but the important point is they get out of the car separately, without an agreement, without a discussion. Guess what? This ain't a game where we're showing up because we're on the same team and we're going to score and I'm going to give you some alley-oops. This is, I almost crashed. My client's pissed off. He gets out the car. He's dealing with this. Spears, all on his own, decides to get out the car. Now, oops. So, this is where you're continuing to see. We now know Spears is getting out the car. My client is still punching and having at, where his dumb rage, young rage, but he's by himself and he's unarmed. He's not, yes, he's acting stupid and foolish, but he's not trying to do anything with weapons or anything else. He's not calling for any assistance or help. Now, Once again, if you watch the time ticker, he's still all by himself. Spears has not made it over to where they are. He's not waiting on Spears. He's not motioning. He's acting a fool. And then finally Spears arrives. That's where you can start to see Spears has walked up there with a gun. Not because my client asked him, not because they had any agreement. Spears apparently had something else on his mind. What the state wants you to do is say, hey, I want you to convict Johnson because he should have been able to read Spears' mind, should have known somehow that he had a gun, should have known he would have got out the car, came to the car with a gun, and escalated this to a gun case. Well, folks, you have to make your decision on evidence, not speculation, not suspicion, not wants. Okay, what evidence do we have? We don't have any of that. All we know is all of a sudden this other guy has come up to this window with a gun. Now, this is another. I'm showing you the good and the bad. Well, my guy is punching. Johnson is fully involved in this. And at some point, I suggest he's going to notice Spears has come up to the window also, and Spears has a gun. Maybe not after the first or second punch, but at some point, it's a reasonable inference to say, damn, this guy just got a gun. Well, the reason that's a reasonable inference is because, again, showing that my client's still facing the victim, punching at the victim, at some point, he starts to notice that this fool has a gun. And what does he do? He walks away from it. His first instinct is, well, hey, I wanted to fight the guy. I wanted to hit him. But I didn't bring a gun. I didn't bring a weapon. I wasn't trying to do this. And his first instinct is he walked away. Well, how do you know? The video shows you he stepped away. Then he thought about it. And what's he do? He comes back. Now, mind you, and you may have to watch close at this. He comes back, I suggest to you, because, oh, heck no, this ain't going down like this. This wasn't about a gun. This wasn't about this series. He comes back and he starts to pull at Spears. You can see his hand right here, starting to pull at Spears. Why? He's trying to pull him away. He didn't intend for this to be a gun. There was no agreement about a gun. And again, same thing, just showing. He's trying to get hold of him, trying to pull him away. And guess what? When he couldn't pull him away, he then says, I can't pull him away. So then he pushes into him and knocks him. If this is the car window, he takes him away from the window where he's now behind. The gun is no longer able to be pointed through the window at either victim. That's my client doing something now. If they had an agreement to use a gun and rob or some foolishness like that, that sure seems to go against using a gun and using a gun to rob or using a gun to assault. You're knocking the guy with the gun out the way. It doesn't make any sense. But my client knocks him out the way, and while he's there, keeping him at bay, possibly pacifying Spears, continues to throw a couple punches, but then does what? He walks away. Almost maybe sending a message, hey, see now Spears has been pushed all the way back. He's no longer able to point that weapon. My client is now taking over the so-called assault with what? Nothing but punches. But these two aren't working together. They're not working in concert. Then, these next two photos, what I want you to see. My client thinks, hey, I've got the foolishness away. I've thrown a couple punches, so hopefully this fool is satisfied. Walk away. And what you see is you look through the window is my client walking away, his back completely turned. As in, this is over, this is done. This doesn't need to continue. There's no more, no mas. Well, if we weren't sure, the next you see him even at this moment, Spears is either just shot or about to shoot. So at the time that Spears has decided he's going to shoot, my client is not just not right up there, but his back is turned. He's not participating. And one would argue if participating, the Spears means knocking him away. That isn't teamwork. That's more, using the state's analogy, like LeBron stealing the ball from one of his own players and passing it to the other team.
Well, hi. I guess at least that happened now at the end of my day and not while I was in the background. So I didn't even know StreamYard had gone down. So I don't know how long it was gone for. I need to go forward from this because I was listening to it on YouTube on my earphones. Oh yeah, this is true. This is true. And also he moaned like nonstop yesterday about having to work and freedom and blah, blah, blah. And then didn't even come. Okay, cool. So I'm going to go forward a teeny bit.
Away, his back completely turned. As in, this is over. This is done. This doesn't need to continue. There's no more, no mas. Well, if we weren't sure, the next you see him even farther. And what do you see? His back is completely turned. He's completely walking away. But at this moment, Spears is either just shot or about to shoot. So at the time that Spears has decided he's going to shoot, my client is not just not right up there, but his back is turned. He's not participating. And one would argue if participating, the Spears means knocking him away. That isn't teamwork. That's more, using the state's analogy, like LeBron stealing the ball from one of his own players and passing it to the other team. The point being is there's no acting in concert. So the things that I think when you think about before, your evidence is that Johnson only knew Spears for 1 month before this happens. These aren't boys, they ain't old, grew up together, banged together, any of that kind of stuff. There's no evidence to suggest it. Well, my client was driving the car. Why? Remember what Ponder told you? Because, hey, he was doing me a favor, helped me. I think it was an oil change, something of that nature. They had just got off work. There's no possible way to know about a traffic situation that hasn't happened yet In other words, there couldn't have been any agreement, any knowledge of anything. But what else did you hear from Ponder? Nobody knew Spears was carrying a gun. Nobody. You have no evidence whatsoever. How can a person reach an agreement with someone, oh, we're going to do some crime with a gun, but I don't even know you have a gun? It's the cart before the horse. It doesn't make sense. In other words, there's just no evidence of it. Well, what about during? Well, Ponder said when all this was happening, there was no discussion in the car. The two of them, she said she didn't hear anyone saying, oh, well, yeah, let's go shoot him. Let's go put a gun on him. She said, oh, no, Johnson was pissed off and wanted to go there and fight. But that was it. The traffic incident, it just spontaneously occurred. There was no discussion about any crime. Johnson only wanted to fight. Nothing about a gun, and nobody in the car knew about Spears' guns, nor did, according to Ponder, did Johnson ever ask Spears for his assistance. Hey man, come on out with me so we can do this. No. Hey, I know you got a gun in your pocket I'm not supposed to know, so come on. No. No discussion. So my client leaves the vehicle first, unarmed. You know from the video he's punching. You saw that Spears leaves second. Spears arrives. And when he arrives, you'll notice from the video my client, once he's realizes what's going on, steps away, but then comes back and knocks him away. Knocks him out of immediate purview or immediate area of being able to put that gun on these two victims. And his back is turned. He's thinking it's over. They're walking away and no one hears a gunshot. I believe Ponder told you she didn't hear it. It was a little 22. But remember, they're outside, traffic, road traffic, cars going in and out, just the noise, and it came a little 22. They don't hear it. Remember what she told you? Spears told us later that he had shot someone. He thinks he shot the dude. She didn't tell you she heard it, but where was she at? Remember, she got out the car. She was smoking a cigarette, standing in the back of her car. So this idea that, oh, well, they're just acting like they couldn't have heard it. Well, she's right there. She doesn't have any reason to lie. Was she impeached? Did anything come out that said, oh, she's lying? She told you, hey, guess what? After, let's go to after. No one had heard the shot, but after they leave, after they've driven sometime, she said Spears started talking at that point. That thinks he shot the victim. And what did she tell you? Johnson started fussing him out, yelling at him. Does that sound like a teammate? Does that sound like, oh, we were in this together? You did what I agreed for you to do? No. That sounds like someone that says, what the hell? Why did you do that? I'm sure the words were more colorful. She told you that. And she told you, well, hey, we were all afraid of Spears. Spears the one that was threatening Ponder. Spears was the one talking about paint that car. Now, I don't paint cars, but I thought, you going to get cans of spray paint and paint a car? That one, I didn't think that was very reasoned. But two, can you even paint a car with just, point being is, it doesn't sound like it makes sense. But again, you got somebody that you're scared of telling you to do something. I guess you're figuring out a way to do it. She didn't say she was scared of Johnson. She said scared of Spears. Johnson never threatened her. Not because I'm telling you, but because she told you that. Johnson never colluded with Spears about hiding evidence about the painting of the car. She told you that. And Johnson gave, again, we don't know what was said, you don't hear it, but when the detective was up here, you know at least that she got with him, she interviewed him, and she told you fully. She interviewed him, asked all the questions, and he gave a full interview and account. Point being, that doesn't sound like a teammate. That don't sound like someone that's trying to say, oh, I got my buddy's back. We were going to do this. And then afterwards, I'm going to cover for him. No. The state is trying to convince you that there is some sort of an agreement. Because one, they have to, because it's clearly my client did not do any of these things. So they know, okay, there's no direct evidence. There has to be, well, a party to the crime theory. Well, did he directly commit it? No, we already know that, right? Well, did he help? Did he help Spears get a gun in his pocket? Did he help Spears get out the car? Did he ask Spears to get out the car? Did he say, hey, Spears, well, I'm doing my thing. Why don't you go put a gun on this guy and do something to him? You have no evidence. Let's say someone in the jury, you just feel, you know, you're right. There's no evidence, but I bet you, no, we don't speculate. The law says you have to make your decision based on evidence, not speculation. So even if you're unsure, you think, hey, it's something else. No. What is the evidence that gets you there? What's the evidence that supports that conclusion? In each one of these categories, you have no evidence of being advised, encouraged. Counsel said a very nice story of his past, how someone might encourage you. There's no clapping. There's no that boy, you know, do it again. There's no encouraging at all. If encouraging means I'm going to pull you away or push you away, and then when I realize, damn fool, you actually shot somebody, I start fussing you out in the car. That's the exact opposite of encouragement. It just is. So, started getting ahead, but I just started to go ahead and mark them all out because none of these apply. And this is really what it comes down to. So the state is going to say, well, maybe he's not party to the crime, but I got a word for you, conspiracy. Well, let's not get caught up in legalese. Conspiracy still at its core requires what? An agreement. They had to conspire to do what? Some act, some illegal act. Well, if you don't have any evidence whatsoever of a conversation, of a verbal agreement, hey, let's go rob somebody. Hey, let's go commit arson. Let's go do something. So we already can just wipe that out. So then the state says, well, sometimes you can prove a conspiracy by the actions that you observe. Action of one guy going up punching, another guy comes up separately with a gun. The actions of a guy stepping away, then coming back to pull and then push the guy with the gun out the way. That ain't teamwork. That's not, oh, we have a common goal of a conspiracy. So then the state will say, well, if you're in a conspiracy, then no matter what happens, even if you didn't intend it, you're on the hook. How can there be a conspiracy when you didn't intend for there to be any gun activity? You didn't ask anybody to step out the car with you, for you, do anything. How can that possibly be an agreement? So that means if I'm in the car with somebody, since we're going to analogies, and they order a Big Mac, I don't like McDonald's. I don't want nothing from McDonald's. But does that mean that all of a sudden I'm going to be guilty of ordering a Big Mac because I'm with someone that did a Big Mac? Mere presence is not sufficient. Mere association is not sufficient. Grave suspicion is not sufficient. You can't say there's a conspiracy because he was with him. What did he do? What you see my client do is, yeah, he punches the guy. From the very start, I said, you know what, that one, I think you know the correct word. Not true enough. You didn't see a lot of injuries. You didn't connect maybe as much as you would have thought. So the difference between battery and simple battery may be something y'all discuss. Either or. But nothing to do with the gun. Nothing to do with malice murder. And nothing to do with aggravated assault. And if you weren't a part of aggravated assault, now mind you, remember, aggravated assault, 3 different ways. Well, someone hitting someone with a gun. The client never had a gun. He didn't hit no one or help no one hit someone with a gun. 2, pointing a gun. Well, he never had a gun to point, and he had nothing to do with Spears. If anything, he tried to constantly get Spears out of there. So point is, not guilty of malice murder. He's not the one for malice murder. Because the judge will also tell you, every person involved in something, you got to decide what each one should be held accountable for. Just because one may be doesn't mean the other, or vice versa. So the state's argument generally is saying, hey, if one is guilty of something, they're all guilty. And I'm generalizing it, but it's essentially what they're asking you to do. And I'm saying, no, you have to judge each person by what they did on evidence that is before you. And if the evidence isn't before you, you know what? The hard thing to say, your duty is to acquit. Your duty is to say, you know, I may feel one way, but there's no evidence of an agreement. There's no evidence of an agreement before, and evidence of an agreement during, or evidence of an agreement after. Therefore, my duty is to acquit. This ain't that person. He's not the shooter. He's not someone who aided or abetted. He's someone that, realizing he had a bad situation all of a sudden, tried to stop things from escalating. That is the exact opposite of conspiring for something to happen. So, if you bear with me, I talked a little bit about duty. Sometimes we do something because it's the right thing to do, it's the legal thing to do. Even if we're not all that happy with it, but that's reasonable suspicion. Reasonable suspicion is sort of that standard where you say, you know, I feel like there might be, or something's there, but if you're not convinced to the point where you feel comfortable making a decision, something maybe one of the most important financial decisions, important social decisions, family decisions. If you're not at that level of comfort, I would suggest that reasonable suspicion has not been met. And for some, you may say, well, we didn't hear from the clients, right? Remember what our law says. And all the things I think that's so important right now is that we remember the rule of law has to come first. Once we lose the rule of law, society crumbles. We must hold people accountable, but we hold the rule of law in assessing their accountability. And we presume them innocent when they start this trial. We do not, as part of our American jurisprudence, require that they testify. If they feel that they can remain silent, they can be assessed and judged by the jury based on the evidence in the case. Or best way to say it, the lack of evidence in this case, the lack of evidence of an agreement, of a conspiracy, any of that. Then we have to, or rather, I encourage y'all as citizens and as jurors to say, you know what? I hate that this happened. I hate that someone has lost their life, a family has lost someone. But the rule of law must prevail. And where there's no evidence, we can't convict. Regardless of what we suspect, feel, surmise, we must acquit. We must acquit. So ladies and gentlemen, again, thank you for the time that you have spent in this. I would again encourage and ask you to scrutinize what the actual evidence is. And if the state at some point suggests something or says something, or me, hold both tables to the same standard. We've said something that you can't look at the video, you don't see support, you don't remember Ponder saying it. Hold us to the same standard. But when it's not there, it's not evidence. I again encourage you to remember your duty. Your duty is to acquit. As to every count except battery, I encourage you to find my client not guilty. I don't think I ever spoke about the possession of firearm, but I think that goes, he never had a firearm. So if he was a party to someone who had the firearm, but that requires what? You have to find he's in agreement with the person with the firearm. So again, even that goes away. So not guilty on all counts, other than the battery. I leave that to your conscience and to your deliberations, but everything else is a not guilty. Thank you.
Does anyone in the jury need a break? All right, let's take 5. I will let everyone go back.
Allow the period.
This judge reminds me of Bernie, his voice and his way.
Fine, I understand the position.
Wow, he made that PowerPoint really fast. Let's hear the rebuttal before we do a poll. By Da Vinci. Did I say that right? What do you guys think of the next one I have lined up? It is about Jeremiah Monell, who is accused of killing his estranged wife, Tara. Do not Google. You will get a spoiler. Major. Okay, let's do rebuttal and then I'll do a poll. I am done for the day on work, so I'm here now. Finally, 5 hours, 23 minutes in.
Thank you, Deputy Scott. Mr. Lee, whenever you're ready.
Oh, no, go. So, everything I say from this moment on is not an attack on Mr. Wright. He's speaking on behalf of his client. I understand the position that puts him in.
Please speak up.
I've had criminal defense law myself in the past, okay? But some of what he said on behalf of his client is ridiculous. So I do want to address it. But I just want to be clear, I'm not attacking Mr. Wright. I'm attacking the defense, okay? So one thing Mr. Wright said was, well, we can't speculate, okay? What you can do, okay, is make reasonable inferences from the evidence that has been presented. Speculation is guessing without any evidence to support it. But you can draw reasonable inferences from what you have seen, okay? Mr. Wright has done that. When he said, the evidence is that they only knew each other for a month. That's not what the evidence was. The evidence was that's how long Ms. Ponder knew the both of them. Okay, we don't know how long Mr. Johnson and Mr. Spear knew each other. We don't know. Okay, but you can also infer that they knew each other longer than a month. Because what do we know about their relationship? Okay, they work together for a month. They hang out after work. Okay. They're all, these guys are friends. They hang out after work. Ms. Palmer told you, I didn't have work that day, so I gave I gave the defendant my car so he can get an oil change. Since we all didn't have to work, we all decided to go together. Remember that? Okay. We know that he's comfortable enough to push Spear out the way while he's pointing the gun at somebody. Okay. He knows him well enough. He's comfortable well enough to do that. Okay. And he's comfortable enough to curse him out after he shot somebody. Okay? He's comfortable enough to do that. These guys were friends, and he's comfortable enough to, after the fact, cover it up. Okay? They're hanging out afterwards. Remember how they were talking about the conversation about spray painting the car? Honda was with
Mr. Lee,
her.
there's an objection.
There's facts, not evidence. My client was specifically said, never encouraged or said anything about the painting of that car. And that was the only, quote, cover up.
All right, Mr. Wright, I think we can leave it there. I'll instruct the members of the jury that you're to remember the evidence that was presented to you during this trial, and you're to base your verdict solely on that evidence as you remember it. And nothing that any of the lawyers say in closing is evidence itself. Mr. Lee, you can proceed.
I'm referring to Taisha Ponder's testimony. Okay? Ask her how the discussion about spray painting the car come up. You all took notes. Okay, you all can go back and confirm each other around what you remember. She said, it was after the shooting. I was with my friend. I was on the phone with Spear. and Mr. Johnson was with him. Okay, that's what she said. And Mr. Spear and my friend who I was with suggested I spray paint the car. And remember I asked, well, did Mr. Johnson intervene and say not to do that? She said no. Okay, so so he's comfortable enough with him to hang out after work, push him while he's got somebody at gunpoint, curse him out after he shot somebody, participate in conversations about covering up the phone, covering up the spray paint the car. Okay, that's what we can infer, and from that you can make a reasonable inference that they had a close relationship, whether it was for a month or longer than that. They were close. Okay, close enough to do all that for somebody. And he made another inference that, well, you know, when the defendant saw that he had a gun, well, you know, once he realized it, he pushed him out the way, pacifying his fears. Okay, that's his inference from what the video shows. Okay, you're allowed to make a different one based on what you believe. Okay, this suggestion that he was somehow concerned for Mr. Antoine, you know, Mr. Lot, he's concerned, so he pushes him out the way once he sees a gun and then goes right back to beating his ass. You can conclude from that that's a unreasonable inference to make based on that conduct. That's up to you. You're the fact finder. Okay. So these were things that I heard throughout the trial that Mr. Wright said during the his opening statement and his closing argument. You know, he said, you know, this fire, remember my fire analogy, this fire wasn't lit by the defendant. It was the traffic. It was the traffic. And then he gets up here and says, you know, well, Mr. Antoine, you know, he was half the problem. That's a very colorful way of trying to put some blame on Mr. Antoine. And we're going to play this video a couple of times. I want you to look at what this perceived traffic infraction was. What was it that he did so bad that they had to get out the car and attack this man? Okay, he wanted to make a left turn. He realized, well, he was driving by, realized he missed the turn, wanted to go left, slowed down for a little bit. Okay, and he had to swerve to get out the way. Now as an aside, how fast was he going to where he has to swerve? You know, I mean, we've all been in that situation, okay, where someone stopped in front of us for whatever reason. Maybe the vehicle stalled out, okay, and we have to slow down. He has to swerve, and then he wants to blame Mr. Antoine for that. And the idea that it was the traffic incident that caused it is a bunch of crap, okay? Because he doesn't pull in front of him after he swerves. He pulls alongside of him and curses him out first. Why you do that? Why you do that? And Mr. Antoine smiled and apologized. That's what set them off. That's why he got out the car. What got Mr. Antoine killed was an act of kindness. That's why they got out the car. It had nothing to do with the fact that they had to swerve, because if that was the case, boom, I don't have to speak to you first. It was the fact that he waved and smiled. They felt like he wasn't taking it serious enough, so they wanted to inflict fear and pain. That's what this is all about. They wanted to scare him. And I'm going to talk about that a little more. Well, this is what 24-year-olds do. He did what 24-year-olds do. That's insulting. Okay. Now, I've been 24 almost 20 years ago, but that's insulting to young people. That this is just the behavior expected of 24-year-olds to beat somebody up for making a mistake on the road. That behavior is inexcusable no matter how old you are. Okay. Well, I didn't tell him to get out the car. And that kind of goes back to the efforts he's making. Well, he pushed him out the way to save him, to help him. You know, there's no evidence of that. They're wanting you to make that inference. Okay, you're allowed to make another. Well, he didn't hear the gunshot, and well, we can believe that because Ms. Ponder has no reason to lie. Yes, she does. Okay, she was helping them. Yes, we put her on the stand as a witness, but that doesn't mean you have to believe everything she said. But again, when you're assessing the credibility of a witness, you can believe some of what they said, none of what they said, or all of what they said. And I suggest that if you have reason to doubt Ms. Ponder's credibility, I ask you to consider what can be corroborated by the other evidence. Okay. She got up here and said, well, no, I didn't hear a gunshot. We didn't know he had a gun. You can choose to disbelieve that testimony because other evidence is we saw a gun. Other people heard a gunshot. Mr. Locke heard the gunshot. The 911 caller heard the gunshot. I'm going to play that for you because some of you may not have caught it I know we only played it once. This is just a person driving by. Called anonymously. That's the one who has no reason to lie. She's anonymous. She doesn't plan to be involved at this point. She saw something and did what reasonable people do. Called 911. But hey, don't tell her my name. And she heard the gunshot. She saw the gun. Before, during, and after. When you're deciding whether or not there was conspiracy and an agreement, consider before, during, and after. We talked about the background there, and you can also consider their companionship. Okay? The companionship between the parties. We talked about that. So the traffic lit the fire. Now, this is the only video I have. I have to use the split screen to show you what's going on down here on this bottom screen. I want you to focus on this bottom screen, okay? What did he do that was so wrong? They're coming up on the intersection. He's looking in his rearview mirror at something. He slows down, can't make the left. Looks like he pointed, oh, I was supposed to go there. You can make that inference based on what you see. And look. Mr. Johnson gets out. Mr. Spear gets out 1 second behind him. You can stop right there. And when you decided before, remember what Wayman Lot testified to, and it was undisputed. He wasn't challenged at all. He said he was making a left. They wanted to go left. They couldn't. Told him, hey, you might as well go straight. The people in the gray charger come up, which is corroborated by the video, because you see it happening right there. They pull up on the side of the road. What the fuck you stopping at the red light for? That's Johnson. And then Spear saying, oh, you think we playing? You think we playing? He pulls in front of them, stops, and they get out. That's your agreement. The two of them knew what time it was. Okay? He smiled at them. Oh, you think we playing? They get out. They knew they were going to fight. And it was because they didn't like Mr. Antoine's reaction. But Mr. Wright had to think, well, because he was 1 second behind, then no, they were doing that on their own. They had their own separate agendas. No, they were both mad at the reaction, and they wanted to show.
I'm object. There's no evidence of how Mr. Spears did not feel. He didn't testify, and no one was in a place to talk about that. I would just ask the jury be instructed to.
All right, I'm overruling that objection, Mr. Wright. The jury can make whatever inferences it wants to based on the evidence it received in the case. And I'll remind again, the closing arguments are not evidence. Mr. Lee.
So that's what happened before. They got out after saying, you think we playing? And they wanted to show Mr. Antoine and Mr. Lott that no, they weren't playing. And they always intended to have the upper hand. I submit you can make a reasonable inference that Mr. Johnson knew that Mr. Spear had that gun on him. Why? Why do I say that?
Overruled, Mr. Noted for the record, but I'll overrule that objection.
Okay. Why? Because when you start getting to the point where they're beating on them, they don't let them out the car. They always intended to have the upper hand. Okay? If this was, I mean, it was already dumb to stop in the first place and start fighting. But they don't even give them a fair fight. Okay? If all they wanted was for this to be a fight, let them get out the car. Let them square up and see what's what. No, that's not what Mr. Johnson wanted. He wanted to be able to scare them and beat them without repercussions. And Mr. Spear helps him do that. Okay. And Mr. Johnson, the defendant, is also helping Mr. Spear. Because while he got the gun on Mr. Antoine, well, both of them, but Mr. Lot as well, Mr. Antoine can't do anything because he's getting punched in the face. Every second that this defendant spent beating on that man was a second that Mr. Antoine and Mr. Lot didn't have to compose themselves and come up with a plan and leave. Okay? He took time away from Mr. Antoine. Every second he spent beating on him. Okay? That was a second that he could have used to compose his thoughts and drive off. Mr. Lot testified, he trying to figure it out. I don't know what I'm gonna do. I'm taking my seatbelt off, but I don't know what I'm gonna do. All this stuff is happening so fast. Seconds matter here. So yeah, we talked about that. Okay. That's agreement. That's encouraging. That's helping. So, during. He's apologizing multiple times. The gun is being pointed. It's being pointed. We're talking about a van window. Okay. He sees that gun. He pushes him out the way to beat him. Now look where his hands goes. Look where his hands goes. Right there on the steering wheel. And we're gonna play that back. I clipped it for you. And now, while he's shot, bleeding out from the neck, spitting out blood, they're in the car driving away, worried about what's going to happen to them. Okay? They had no regard for Mr. Antoine. No one called 911. Even if you was to believe the preposterousness of, well, we didn't know he was shot until Spirit told us we got back in the car. That would have been an opportunity. If he was really concerned, if you was pushing him out the way to pass, you was pushing Spirit out the way to pacify him out of some kind of concern, then once you realize it's real, that somebody got shot, that's when you call 911. That's when you go back to the scene. But that's not what they do. While he's bleeding out and Mr. Lott's left picking up pieces, they're talking about what's going to happen to them. How are we going to get away with this? Now, this is the second video with the short clip. I'm going to play this 3 times, okay? Now, when I play it now, I want you to look at, this is the part where Mr. Antoine Spear starts beating Mr. Antoine with the gun, okay? I want you to look at where Mr. Johnson's hand goes. Right about in here. Okay? I want you to keep an eye on that. Go ahead and play it. Right there. Okay? He's holding the wheel while Spear is beating him over the head with the gun. That's direct participation. Okay? That's help and direct participation. He did that. That's aggravated assault. Now, I'm gonna play it the second time. When the hand goes here, I want you to look at the steering wheel. It's gonna move ever so slightly. Look at the steering wheel. Play it again. Right there. Okay? He moved that steering wheel. He did that. But they want to say, oh, well, no, he was concerned for Mr. Antoine. And he's trying to pacify Spears. He's encouraging him. He's aiding him. That's what he's doing. Now, when I play it again, I want you to look at where Mr. Antoine's hands are when the steering wheel is getting moved. Just so you know, he's not moving. Mr. Antoine is blocking. Play it again. Go back to the first video. Play it all the way through. I want you now while we're playing this time, I want you to focus on how much time actually passes between when Mr. Johnson walks away and the shot is fired. You can count that out in your head. And if he could push him out the way to beat on him, he could push him to the car if he was really trying to dissuade him. How many seconds was that between the gunshot and when he walked away? About 1.5. And they want you to believe that because of that 1.5 second that he had his back turned, that he wasn't, he wasn't a part of this aggravated assault. He turned his back once already and came back. Okay. The crime wasn't over yet. Okay. The crime wasn't over until they left. All that was done. All that Spear did, shooting him and beating on him with the gun, that was to further their objective of causing pain and fear. That was the conspiracy. Okay. The game wasn't over when Johnson turned his back. So we talked about that. And if you notice, matter of fact, go back to that video one more time to show. I want you to see how hard Spears is getting hit while he's holding the steering wheel. You're actually going to see a piece of the gun fly off. Right there. That's how hard he's being hit. Enough to damage your gun. To lose a piece of it. And he wants to say, oh, I was concerned for Mr. Antoine. I was pushing up. I pushed Spear out the way to pacify the situation. Mr. Johnson had no problem with what was being done to Mr. Antoine or Mr. Lot because it furthered their objective. Caused pain and fear. That's what they wanted to do. He kept him there. Now, every witness said they saw the gun. You saw the gun. It's what kept Mr. Lot and Mr. Antoine inside the vehicle. It was that gun. We know he saw it. That's why he's able to turn his back to them after he just got through beating on them. Because he knows he doesn't have to worry because those two people are being held at gunpoint. So he can turn his back. Okay? Because Spear was handling that for him. For him. He started that. He was driving. He cut in front of him. Talk about it. You can go ahead. Never let him get out the car. I wanted to make sure I said it, but I think I did. If he could push him out the way to beat on him some more, if he was really concerned with Mr. Antoine, then he could push his friend to the car. Okay? If he's comfortable enough to push him out the way out of concern, then push him to the car and y'all going about your business if you were done. They weren't done.
Your Honor, can we approach?
Sorry. Is it too late? Do I need to go back? Vicky, could you ascend? Should I go back a bit? I was busy looking for a Simpson video. I don't mind going back a few seconds. Okay, I'm gonna go back. I'm gonna go back.
Play it again. And out of card when
And I'm gonna move myself out the way.
I know we only played it once. This is just a person driving by. Call anonymously. That's the one who has no reason to lie. She's anonymous. She doesn't plan to be involved at this point. She saw something and did what reasonable people do. Call 911. But hey, don't tell her my name. And she heard the gunshot. She saw the gun. Before, during, and after. When you're deciding whether or not there was conspiracy and an agreement, consider before, during, and after. We talked about the background there, and you can also consider their companionship, the companionship between parties. We talked about that. So the traffic lit the fire. Now, this is the only video I have. I have to use the split screen to show you what's going on down here on this bottom screen. I want you to focus on this bottom screen, okay? What did he do that was so wrong? They're coming up on the intersection. He's looking in his rearview mirror at something. He slows down, can't make the left. Looks like he pointed, oh, I was supposed to go there. You can make that inference based on what you see. And look. Mr. Johnson gets out. Mr. Spear gets out. 1 second behind him. You can stop right there. And when you decided before, remember what Wayman Lot testified to, and it was undisputed. He wasn't challenged at all. He said he was making a left. They wanted to go left. They couldn't. Told him, hey, you might as well go straight. The people in the great charge come up, which is corroborated by the video, because you see it happening right there. They pull up on the side of the road. What the fuck you stopping at the red light for? That's Johnson. And then Spears saying, oh, you think we playing? You think we playing? He pulls in front of them, stops, and they get out. That's your agreement. The two of them knew what time it was. Okay? He smiled at them. Oh, you think we playing? They get out. They knew they were going to fight. And it was because they didn't like Mr. Antoine's reaction. But Mr. Wright had to think, well, because he was 1 second behind, then no, they were doing that on their own. And, they had their own separate agendas. No, they were both mad at the reaction, and they wanted to show.
There's no evidence of how Mr. Spears did not feel. He didn't testify, and no one was in a place to talk about that. I would just ask the jury be instructed to.
All right, I'm overruling that objection, Mr. Wright. The jury can make whatever inferences it wants to based on the evidence that received in the case. And I'll remind again, the closing arguments are not evidence. Mr. Lee.
So that's what happened before. They got out after saying, you think we playing? And they wanted to show Mr. Antoine and Mr. Lott that no, they weren't playing. And they always intended to have the upper hand. I submit you can make a reasonable inference that Mr. Johnson knew that Mr. Spears had that gun on him. Why? Why do I say that?
Overruled, Mr. Noted for the record, but I'll overrule that objection.
Okay. Why? Because when you start getting to the point where they're beating on them, they don't let them out the car. They always intended to have the upper hand. Okay. If this was, I mean, it was already dumb to stop in the first place and start fighting. But they don't even give him a fair fight. Okay? If all they wanted if all they wanted was for this to be a fight, let them get out the car. Let them square up and see what's what. No, that's not what Mr. Johnson wanted. He wanted to be able to scare them and beat them without repercussions. And Mr. Spear helps him do that. Okay. And Mr. Johnson, the defendant, is also helping Mr. Spear. Because while he got the gun on Mr. Antoine, I mean, well, both of them, but Mr. Lot as well, Mr. Antoine can't do anything because he's getting punched in the face. Every second that this defendant spent beating on that man was a second that Mr. Antoine and Mr. Lot didn't have to compose themselves and come up with a plan and leave. Okay. He took time away from Mr. Antoine. Every second he spent beating on him. Okay. That was a second that he could have used to compose his thoughts and drive off. Mr. Lot testified, he trying to figure it out. I don't know what I'm gonna do. I'm taking my seatbelt off, but I don't know what I'm gonna do. All this stuff is happening so fast. Seconds matter here. So yeah, we talked about that. Okay. That's agreement. That's encouraging. That's helping. So during. He's apologizing multiple times. The gun is being pointed. It's being pointed. We're talking about a van window. Okay, he sees that gun. He pushes him out the way to beat him. Now look where his hands goes. Look where his hands goes. Right there on the steering wheel. And we're gonna play that back. I clipped it for you. And now, while he's shot, bleeding out from the neck, spitting out blood, they're in the car driving away, worried about what's gonna happen to them. Okay? They had no regard for Mr. Antoine. No one called 911. Even if you was to believe the preposterousness of, well, we didn't know he was shot until Spirit told us we got back in the car. That would have been an opportunity. If he was really concerned, if you was pushing him out the way you was pushing Spirit out the way to pacify him out with some kind of concern, then once you realize it's real, that somebody got shot, that's when you call 911. That's when you go back to the scene. But that's not what they do. While he's bleeding out and Mr. Lott's left picking up pieces, they're talking about what's going to happen to them. How are we going to get away with this? Now, this is the second video with a short clip. I'm going to play this 3 times, okay? Now, when I play it now, I want you to look at, this is the part where Mr. Antoine Spear starts beating Mr. Antoine with the gun, okay? I want you to look at where Mr. Johnson's hand goes. Right about in here, okay? I want you to keep an eye on that. Go ahead and play it. Right there. Okay, he's holding the wheel while Spirit is beating him over the head with the gun. That's direct participation. Okay, that's help and direct participation. He did that. That's aggravated assault. Now, I'm gonna play it the second time. When the hand goes here, I want you to look at the steering wheel. It's gonna move ever so slightly. Look at the steering wheel. Play it again. Right there. Okay? He moved that steering wheel. He did that. But they want to say, oh, well, no, he was concerned for Mr. Antoine. He's trying to pacify Spears. He's encouraging him. He's aiding him. That's what he's doing. Now, when I play it again, I want you to look at where Mr. Antoine's hands are when the steering wheel is getting moved. Just so you know, he's not moving. Mr. Antoine is blocking. Play it again. Go back to the first video. Play it all the way through. I want you now while we're playing this time, I want you to focus on how much time actually passes between when Mr. Johnson walks away and the shot is fired. You can count that out in your head. And if he could push him out the way to beat on him, he could push him to the car if he was really trying to dissuade him. How many seconds was that between the gunshot and when he walked away? About 1.5. And they want you to believe that because of that 1.5 second that he had his back turned, that he wasn't, he wasn't a part of this aggravated assault. He turned his back once already and came back. Okay. The crime wasn't over yet. Okay. The crime wasn't over until they left. All that was done. All that Spear did, shooting him and beating on him with the gun, that was to further their objective of causing pain and fear. That was the conspiracy. Okay. The game wasn't over when Johnson turned his back. So we talked about that. And if you notice, matter of fact, go back to that video one more time to show. I want you to see how hard Spears is getting hit while he's holding the steering wheel. You're actually going to see a piece of the gun fly off. Right there. That's how hard he's being hit. Enough to damage your gun. To lose a piece of it. And he wants to say, oh, I was concerned for Mr. Antoine. I was pushing him out. I pushed Spear out of the way to pacify the situation. Mr. Johnson had no problem with what was being done to Mr. Antoine or Mr. Lot because it furthered their objective, caused pain and fear. That's what they wanted to do. He kept him there. Now, every witness said they saw the gun. You saw the gun. It's what kept Mr. Lot and Mr. Antoine inside the vehicle. It was that gun. We know he saw it. That's why he's able to turn his back to them after he just got through beating on them. Because he knows he doesn't have to worry because those two people are being held at gunpoint. So he can turn his back. Okay? Because Fear was handling that for him. For him. He started that. He was driving. He cut in front of him. Talk about it. You can go ahead. Never let him get out the car. I wanted to make sure I said it, but I think I did. If he could push him out the way to beat on him some more, if he was really concerned with Mr. Antoine, then he could push his friend to the car. Okay? If he's comfortable enough to push him out the way out of concern, then push him to the car and y'all going about your business if you were done. They weren't done. Your Honor, can we approach?
So we're back where we started. Is he done? Is he changing pages? All right, there we go.
Where she said she heard gunshots.
Fulton County 911. What is the address of the emergency?
Right here on Flat Shows Road at Mallory Road, there was an incident. A car pulled over and got out. Two guys got out the car and started punching the man in the car. And then I heard one shot. Another car said that the guy got shot in the neck. They don't know if he okay. But I did get it on video, but it kind of just took me up. So yeah, the guy is right there on Flat Shows and Mallory Road. All I know is there's two gentlemen. We were all driving up the street. They cut the guy off, swerved so he couldn't move. Got out the car and started pushing the man, and then the man was just like holding his hands up. And that's all I seen. All I seen was this one guy pull out a gun, and I heard the shots. I was driving off, but the other guy was pushing him.
Okay. Are you still there? Or have you left?
I left. They ain't nothing to do with me. I'm just calling up.
So you left?
Yes, I left. I didn't have nothing to do with it. I was riding by.
I understand. I'm just asking you so we can give help to the person who got shot. What's the description of the subject? What type of vehicle were they in?
It's like a white. It's a white truck. It's like a work truck.
Okay. Did you see a tag number?
You're talking about for the suspect? They was in a Dodge Charger, a gray Dodge Charger.
Okay. The person who was shot was in a white work truck?
Yes, it was in a white work truck. Yeah.
Did you see the tag number of the Charger?
Hold on. I'm driving at the moment, but if you can get someone to call me back, I can get it. I just have the whole incident on video. I don't know if I can share the tag number, but I do have the whole incident on video.
Okay. What's your name?
I got to y'all gonna tell somebody who I am, right?
No, ma'am. This is for the officer. I have to call you back.
Oh, Danielle.
What's your callback number?
678-468-8635.
Okay. All right, man. We're getting help there.
All right.
All right. Bye-bye.
All I seen was this one guy pull out a gun. And I heard the shots. I was driving off, but the other guy was pushing him.
All right. I just played one. That was where she said it. I saw the guy with the gun. I heard the shots, and the other guy was punching him. I played 2 more times just to make sure you heard it. Okay. Play it again.
This one guy pulled out a gun, and I heard the shots. I was driving off, but the other guy was pushing him.
And she was driving off. She heard the gunshot from her car. She was driving off. I'll play it one more time.
This one guy pulled out a gun, and I heard the shots. I was driving off, but the other guy was pushing him.
One guy pulled out a gun. I heard the shots. I was driving off. The other guy was punching. She heard the gunshot. He did too. He just wants to say he did it. We talked about this. Every moment they spent punching at him, that was a second taken away from Mr. Antoine and Mr. Lott. And I wanted to focus on Mr. Lott for a minute because I know it's a murder case, but we do have 2 victims. And I put this slide up here to make sure I didn't forget. I prosecute strictly homicide, so it's rare that I have a victim who's survived. So I want to just make sure we covered his charge, the charge alleged against him as the victim sufficient. Okay? We have to prove that Mr. Lott was assaulted with a deadly weapon, and that placed him in reasonable apprehension of receiving an immediate injury. Okay? He testified, you saw in the video, the gun being pointed at him. Okay? And he said, you know, and he was scared. He was scared for his life. I didn't know what I was thinking when I took off the seatbelt. There was a lot going on. This was a scary, shocking, dramatic situation for him. Okay? He was in fear. He had a gun pointed at him. He's guilty of aggravated assault. And then he's left picking up the pieces while they're driving away, arguing about how this is going to affect them, how they're going to avoid the consequences. Mr. Lott is on 911, having to put 2 fingers against Mr. Antoine's neck as blood is pouring out of his neck. That's how they left Mr. Lott. What do you do with that? He has to live with that. Because of what they did, because of what he started. And didn't have the courage or the desire to stop. It was on him. And he just kept on going. None of this happens. But they want to put the blame all on Mr. Spears. No. Mm-mm. They're both responsible. Now, afterwards, after he heard the shot, they drive off. He's driving. They wait for the shooter to get back in the car. They didn't have no problem with what he did. It's just the consequences. And they drive away and leave him to die. Without any regard to what they did. No one calls 911. You heard that from Ms. Ponder. You can believe her on that point because that's corroborated. Because I played to you all the 911 calls that were taken from that center. You heard from Marcus Traylor, who keeps all the records of the 911 center. I checked twice. When you asked me to pull it, and last week when you asked me to double check. Those are the only two calls I got. Okay? The vehicle is spray painted, and they stay gone. Okay? And not been for that surveillance camera and the LPR camera that Detective Allen pulled, they probably still be gone. They were arrested on March 1st of last year. This happened February 21st. Only concern they had was for themselves. This all started because of how they felt about Mr. Antoine, what he did. Skip past that. Again, their problem is consequences. Okay, see, now the harm can be turned back on them by way of consequences. That's what he's concerned with. That's what they were concerned with, not the harm they caused on Mr. Antoine and Mr. Lot. Now, told you I was going to come back to implied malice. Okay, and I already mentioned it wasn't the traffic incident that caused them to stop and get out the car. It was Mr. Antoine's reaction to it. It's his kindness that got him killed. Yeah, if we're gonna call it a mistake, that was Mr. Antoine's. Some may think, why didn't he just run them over? Because he believed, you can infer that from the video, his demeanor. He believed he could reason with these young men, even after they curse on him. Why the fuck you got him out? You think we playing with you? He stayed there. His mistake was thinking that he could reason with Mr. Johnson. That's what got him killed. Kindness. Kindness got him killed. But you can infer from that, from the reason why they got out of the car, that they acted with an abandoned and malignant heart. Okay? If you're going to get out the car and beat on somebody because they smiled and apologized to you for something that probably wasn't all the way they fault. Again, how fast was he driving to where he had to swerve in the first place? If you can get out the car and beat on somebody for smiling and apologizing, watch this gun get pulled out, doing nothing, punching him again, knowing they're being held at gunpoint, holding the steering wheel while your friend is beating them with the gun. That shows implied malice, an abandoned and malignant heart. That's why you convict on count one. This was murder. This was murder. And they're both responsible. Today we just happened to have the trial of Mr. Kendall Johnson. So if you're wondering, well, you know, what about the other guy? You don't have to concern yourself with that. It's just today we're having his trial. They're both guilty of murder. So In my opening, I'd asked, gave you the campfire story. Man, camping in the woods, if he starts a fire, who's responsible for putting it out? I would, I'm sure you thought about that. The answer is, if you start a fire, you have to put it out. Okay? Outlaw recognizes that. Felony murder, party to a crime, conspiracy, those are all laws to address accountability and choice. Because we live in a society, okay? There are times when strangers are responsible for each other. If you cause an accident, you're required to stop, render aid. And that's as simple as calling 911. You have to, pull a person out, and do CPR. Because outlaws realize that there are times when we, as a society, have to be responsible for strangers. When you cause something, you have to do what is reasonable to redress that wrong. And if the fire gets out of control, and the tree starts to burn, the forest starts to burn, what's that person's responsibility then? I just said it. He has to do something to stop it. Now, I'm not saying he has to, put himself in danger and throw fires, but he has to do something reasonable to prevent this thing from spreading out of control, because the fire was his responsibility. Okay? And make no mistake, if you go back there, well, maybe he didn't do anything because he was scared of spirit. We already talked about that. He wasn't scared of him at all. Okay? He's pushing him out the way while he's pointing a gun at somebody. Then he's cursing him out after he just shot somebody. They were friends. If he wanted to stop it, he was in the best position to do it. But he did nothing. He turned his back. And whether he did that because he wanted Mr. Antoine to get shot, or he did that because he didn't care what happened to Mr. Antoine, is murder. So now the case is going to you. There's really not much more for me to say. What message are you going to send to him with your verdict? That you can do all that, start all this stuff, perpetuate, keep it going, seeing, knowing that this is getting out of hand, that these people got guns pointed at them, are getting beat with guns. Are you really going to say he wasn't a part of that? He wasn't a party to it? Or are you going to hold him accountable for starting something, seeing it escalate, participating in this escalation, and doing nothing about it? A guilty verdict will hold him accountable. And that's what we're asking you to do. Find him guilty of every single thing he's charged with. Thank you very much.
All right, members of the jury, that completes the closing arguments in this case. And just to repeat the general qualification on all those is that the important thing here is the evidence that you heard, and as you remember it, the personal opinions of counsel or the inferences that they are urging you to accept are just that and aren't binding on your evidence in any way. So with that, it is now my duty to charge you on the law that applies to this case. That process takes about 15 to 20 minutes. Does anyone need a break before I do that? All right. So seeing none, I'll read the charge to you, and I'll note also that you will have a copy of this during your deliberations. You are now considering the case of the state of Georgia versus McKinley Johnson. The grand.
Should we skip before we do anything? Thank you, Misty, for the super chat. Very kind of you. I'm glad that you saw the link. I think it most likely has disappeared. It has on my side. Where else did I stop? Hi, Tom. Didn't see you pop in. So basically, our guy in Judge Simpson's court, Steve managed to find some things, but the first day he appeared is the only day in June that I seemingly didn't record, didn't download, can't find it, no one's got it. Thank you, Elizabeth. As I said earlier, chat being a nice place is like the highest compliment. I really, really like it. Feeling like the safe space, because I just want to be strange and me and chill. And I do have great mods. They've been holding it down all freaking day. Hey, Greeners. Yes, I think this is by far my longest stream ever. 6 hours, 18 minutes. What's the normal time? 1300 hours Central African time. Normally I wrap up by this time, but since everybody else is off today, I might as well take one for the team. Down south. Don't be dirty about that, guys. That's just South Africa. Although to us, down south is Australia. Raymondo, I don't know why you are excluded from chat and why you can't get chat, because the only person I've blocked on YouTube at all is Dr. Todd Grande. Mostly because he's not a doctor. Okay, so we're gonna skip jury instructions.
All right, jurors 43 and 45, welcome back. As you may have guessed, a jury usually consists of 12 members, and you are our alternates. And so at this time, we would ask that you would stay under the requirements of your oath, but you are allowed to leave the building and to go home and resume your business. But the fact is that oftentimes we do still need to have an alternate come and sub in during deliberations. So we are still going to reach out to you by phone or email if we need you to come back. And we're also
okay. Before we do that, so the stream was, so the jury went out to deliberate at 2 hours, 50 minutes, 28 seconds.
The defendant testified. You lost it.
That's right.
You lost it.
That's right.
Hot mic.
Brother, you coming down?
Yeah.
Hey, man, I appreciate you. Whatever happens, man. Well done. It's been a pleasure working.
Yeah.
We didn't, we have to wrestle.
Anybody got too personal?
Well, sometimes that happens, and I've always said, why? I mean, hey, we got to do our jobs, but never personal, or it should have been. Now I always feel good when I sit down, and I don't feel good. I think that I tell people the biggest change in the law in my career was when the state got the right.
Yeah.
Because here, I didn't put any evidence in the old way. I could have closed it.
Yeah, the only way, if the defense puts in no evidence, then they get first and last. But if the defense puts in any little piece of evidence, then the state goes first and last. And it got changed because prosecution, PAC actually got legislation to change it so that now it's all. It was a big difference.
Yeah, no, I thought of all the changes, whether it was evidence code.
No, I did not hear that.
Biggest substantive change.
Yeah, you're right, because evidence.
Yeah, I did tell him he
They
did.
changed
No,
the
I saw it.
I didn't even, hear you. I had no
It's a
idea.
level playing field. First to last, that's hard to overcome sometimes.
And actually, I could have a defendant testify, but it went beyond the defendant testifying. You lost it.
That's right.
You lost it.
That's right.
So you had to be careful. I had a judge in one trial way back then, when I introduced a document, even though it was something simple, he's like, you've lost it. And I'm like, damn, I wouldn't have introduced it. But
I had a case years ago, Greg Harris.
I remember
Me and
that.
him, he and I were trying a case. This is when I was in the cops solicitor's office, a long time ago. And I had a video, it was a shoplifting. I had a video, but he wanted to play his copy of the video. And he put that thing in as a defense exhibit 1. And he started asking questions. And I was like, well, I just want to be clear. He just now lost, had 2 identical pieces of evidence, but he wanted his video because he thought it was clearer. Yeah. So, and he lost the ability to close at that point. So that's the way the law used to be.
Yeah, I mean, it's been some years now. Now, second to that, I might start saying there's some evidence thing. You used to also get what, 12-6? And also.
Yeah, that's true. That's true.
You know, so it was sort of the double whammy.
Oh, they were downstairs.
He said, oh,
Person
be like the
downstairs.
feds, 9-9 versus 12-6. And
Bring
feds
them up.
always get the cards. So.
Can you correct your number again?
Yeah.
I misplaced it.
Yes.
Good job.
Yes.
I know, I like the emotion. It's like council say it later, you know.
Mr. Talkers Council.
This was y'all, this is great, right?
Yeah, that's ready to go back.
Yeah, we collect their phones. How do y'all do that?
Yeah, he does. Thank you. She don't say my note about the hot mics.
Oh, no, one of the deputies, let me know.
Yeah, they were whisper to your client,
Yeah, yeah.
and it's on YouTube. We buy y'all a box.
Always, they always do this stuff. Freak out. They hear you. Yeah. You got food.
I was rehearsing it this morning. I did. So I kept crying when I was like, oh, kindness without a guilt. It kept making me cry. So I had to make sure I did it.
But when you come out and take it lunch.
You don't know much?
I haven't had lunch. Cause I gotta go to, I'm going to a different.
You waiting for this to get done so we can go get them?
I gotta go to so we get down there. Yeah. That's what Maddox told me. Maddox told me that. 5 years.
What you think, man?
Let's do it.
Yeah.
Oh, it's fine.
You saw me too, I'm not forgetting.
Front part. The front part it was. It wasn't shaky.
Still hoping he's down.
But no, that's what
Okay,
but that's what I'm telling you.
If they sell things, they sell.
You got two different versions. I don't know what.
Look at it.
Hey, two, I gotta leave. I want lunch.
Was talking to him.
It was real nice.
I'm saying he's having conversations today.
Yeah, no, and I've talked to him before when he was out. I've talked with him, I just, I'm not sure how much.
But he's one of the person.
I think it's like, you know.
Cause it is drug court for.
Whole part of it.
Probably had
Being involved.
drug court for a while. I just. But he, cause he.
It's a close case for that reason. You know, you can see, if you tried this case,
I can't go back.
you can see one or two.
No, he wasn't taking. Probably different.
It keeps falling up.
And we came back.
Yeah, and you know, but then out of that, 10 hypotheticals.
It was okay in court. But then once he was terminated.
Cobb County, this would be an easy conviction. They commit his ass.
Then he showed out a couple of times at here.
Oh, PPA.
But he never showed out in accountability.
Well, and it's not like he.
But yeah, he asked me, he was like, I see it, but then we saw it. I was watching.
He was a little agitated, or had like a drink or something. Deputy's kind of told him, but he didn't respond well to that. And go out way outside. So.
Oh, I wish that these two would just talk softer so we can keep overhearing these two that have forgotten within 5 seconds this is on YouTube, because they're busy talking about what they think the verdict is and why they think it is.
They cut to them because I see them, they were like,
I just don't, the other thing I don't want to say, if we start getting back on probation violation.
Playing the video, because it happens so fast. I mean, it's not like.
Send them back.
I know, but you still gotta wait a while for those calendars to come up, and if it's something where it's already.
Well,
to see that part.
I couldn't get them when the bands was up and we moved. It was like, oh.
that right there. That right there. You can see that.
I skipped breakfast because I was looking at my app, like, I figured out the tax us.
It's a tough case, even though you got a great video. It's easy against the shooter. It's tougher against this guy. But I think you've done everything good with it. And I want to have a big show.
Because I didn't see it. It was a magazine. So it was.
He gave a statement.
Because some guns can't fire.
It was some kind of 22. Actually,
And then police never covered it. Because some guns can't fire.
I think it was that bottom plate.
Yeah,
On the magazine.
That was
Came off.
false. So the magazine didn't come out.
No,
The plate,
just the
that's
little,
okay.
I think that's what it was. It
Okay.
came off. I don't know if they collected it from.
They did, and I didn't, put that in, so that's why I had, they did collect it. And I wasn't around, well, not wanting to overdo it, so I wasn't gonna put it in browsing for them, so I was like, well, everything's on video. Then, but when I made that decision, I forgot about the piece of the gun.
Yeah.
And you had that
But you did show it during closing, and he didn't have a chance to respond to it, which is good. I mean, you have to crack somebody pretty hard for, that metal piece to come off like that. And the thing is if you look at still, I mean, you do see this defendant's back turned while the gun.
Okay, wait. I forgot to do a poll, and now we're hearing all of the gossip. Why is poll grayed out? Oh no. Why on earth is the... Oh, I didn't end the last poll, sorry. I forgot it existed. Were there lessers? I think they were all balanced the same. I'll add lesser as an option. And say, if any. Okay. Polls up. Back to the gossip.
You do see that. And and you do see like a few seconds later, his back is turned. But then when you play the whole thing, I mean, it's just like, it happened this right here. I mean, it was turned.
Yeah, he messed
One
up,
second
too.
he turned around.
But see, he messed up too. He was like, he came back and he pulled him, and it Jure kind of looked. But then
Yeah, I meant to say something like that. Did that look like a pull? Because I didn't see it.
No, it was
It
difficult
But they should be able to see that.
because the altar, both of them looked like cool.
Yeah.
Then he came back. He pushed him after.
Well, the thing is that I think Strong's point is that none of this would have happened if he had just kept driving forward.
You said that.
That's what you said.
When you said that.
They're like, I mean,
Yeah.
just none of this would have happened. And the whole thing about, getting, oh, you think we're playing with you? And I thought that was a good thing. But when they flicked me,
I didn't hear, but I thought.
oh, yeah. I mean, that to me, that to me is everything.
It's the point that both of y'all walking insane order. Trying to come through.
I thought that was a great thing. And that's, I mean, that is what they're trying to do. I mean, oh, you think we're playing? And then I think he said it twice. And it's like when they get out, well, I mean, you're stuck.
Yeah,
Those
you
poor
see,
guys, they were
You
stuck.
think we playing? We. That was nice. It was nice. That was very nice.
So, yeah.
Yeah, we definitely can't have Charlies. We got to this got marinate.
All right. So,
Yeah.
This is prosecution, right?
Was it for?
I'm gonna run down to my office.
Yeah, 692.
And
Oh, she rescheduled.
Just a sec while he goes out his number.
What am I gonna do? Y'all going back to your office?
I'm gonna go down and eat some lunch. I can come back up and,
No, I can do the same. I need,
you know,
I didn't bring my office. I need to get some.
do they have, they got your phone number? I know I gave the court reporter my phone number.
So
In case
we
there's a
just talked
question.
about Troy Williams. She moved to the next family. So. Right. Jason Tom. Yes, it is.
Yeah, they're done. Those captions are such a joke.
So we get down there, you think easily saying we got questions.
Yeah. I know.
It always happens like that. As soon as I walk out.
Sometimes I stay in the
Otherwise, I
courtroom.
leave mine just.
Usually I like stay for the first 20 minutes, because that's usually like questions always come.
It's already 20 minutes.
Yeah, within that time. That's
But you wanna, they have your phone number and that.
yeah, she has my phone.
You gonna take the card? You just gonna walk?
You probably have to leave the card. Oh, you know, APC, I need to bring this, but to make sure that we got Jason out in this, because we can't get on, online for that. So if we do something, but I may not have to come to this, I'm gonna find out if I can see on the net. Yep. Okay, so.
But I got the flash drive too, just in case.
Okay. Do you think they've left? I just want to see. Something happens here.
And just to play that one.
Okay, so the lady did come in and say, just so you know, the mics are live, going out on YouTube. And they stopped for like a millisecond and then carried on talking. What is happening here? Oh, I need to turn off the thingy majiggy, that thing that.
They see it.
Also, if you want to look at a note, they want to watch the video.
They didn't see it enough times because it was played about 85. I've seen it enough times, and I wasn't even watching today. Means I have to move again. Nope, not there.
Yeah.
What was that for? Oh, okay, I'll go grab it. All right, ready to go on the record? All right, we are back on the record, and after about an hour of deliberations, we've received a note which I've marked and will tender for the record as Court's Exhibit 3, which reads, "We'd like to see the clip of MK grabbing the steering wheel." And I've shown that to counsel for both parties, and my proposal would be to bring in the jury to replay that part of State's Exhibit 3, which was just a 1-minute video of the incident, and just to play that once. And before I do that, I'll tell them that all communications, our only communication that we can have with the jury has to be in writing. They can, and that as we interpret this note, they've requested to view it one time. And so we'll view it and then we'll send them back.
So, we're gonna play the entire minute or just the clip?
Well, I guess since they say they want to focus on the steering wheel, how about we'll stop it once the alleged victim begins driving away. We'll just stop it there.
Okay. Okay, so, I understand.
Mr. Wright, anything to add?
No objection. I think ultimately that's almost immediately when that clip ends, I think it ends as he starts. So no objection.
Okay.
One time towards.
Okay. Okay, and I'm just playing, making sure it's not the clip that, yeah, see, that's the clip. So you want us to play the entire minute, like the entire,
Oh, so you have a clip where it's just this interaction of the grabbing of the steering wheel?
yeah, have a clip to where it's just that interaction.
Then let's play that one. And for the record, can you tell me more about this clip? Is it part of the exhibit?
It's part of State's Exhibit 3, Interior 1. And what I did was, when I put it on the PowerPoint, I just flipped it to show.
But to be clear, this clip is not part of the I mean, I know it is part of the tenant exhibit, but this clip isn't its own standalone exhibit, right?
No, it is not.
Okay. But it is, so just to describe it for the record, this is a clip from State's Exhibit 3 lasting how many seconds?
I think it's about 2 or 3 seconds. Let's play it. 5 seconds.
Okay, we'll start with that. And I see the light has come back on, so we'll just hold in place and the deputy can go check on that to see if there's another note that they have for us. I haven't found it yet. I don't know if council can direct me to it. I'm trying to find the part. Essentially, it says that the state is required to prove each element or count beyond a reasonable doubt, and essentially that they have to consider each count separately. I haven't found it yet. I don't know if council can direct me to it, and I'm going to double check to see if that may be found in another charge that we didn't make it. That didn't make it into the charge.
So it's gone to
The
jury
pattern charge, that is.
instructions, but they're not sure about the standard.
There's a material allegation of the indictment, every essential element of the crime charge beyond a reasonable doubt language. Page 1, paragraph 1, 2, 3, 4, 5. Oh, okay.
All right, so here's a thought, open to suggestions from council though. Looking to the first page of the charge as given and beginning with the 4th and 5th paragraphs. We could recharge the jury on no person shall be convicted of any crime unless and until each element of the crime is proven beyond a reasonable doubt. The burden of proof rests upon the state to prove every material allegation of the indictment and every essential element of, and I could say instead of the crime, a crime charged beyond a reasonable doubt. I don't know if that would suffice, but that's something to consider.
And there, I don't have doing that. I just know, I believe there is the find it in the charge, but there is, just as there's a charge that talks about convicting one defendant doesn't necessarily mean convicting another. I want to say there's a charge.
I thought so too, and I'm trying to find it, and I'm not, but I agree with you that I thought that existed.
I mean, the part about each defendant being.
Yeah, so there's one about multiple defendants, but there's also one about multiple counts in the indictment is my understanding.
Call that red, and that's.
But I know it didn't go in here, but I want to say there's.
Well, the only thing I'm seeing is referring to the pattern charge 1.60.10, which is verdict generally. There's a parenthesis that says make appropriate adjustments for multiple counts and multiple defendants. And this is the charge where it really lays it out and says, if after considering the testimony and evidence presented to you, together with the charge of the court, you should find and believe beyond a reasonable doubt that the defendant in Fulton County did on or about the date commit the offense of, and then it just says, as alleged in the indictment, you'd be authorized to find the defendant guilty. If you do not believe the defendant is guilty of either of these offenses, which is in parentheses, and then I think is theoretically tailored to emphasize that they consider each count separately. I don't think we want to read that 7 times in a row, saying for each offense. So we can craft language to that effect, or
What? They said something about
maybe let's
camera
just hang
again.
Those are the charges. That's fine. Well,
Oh,
counsel want to look at it.
Oh, well, I'm not clear on the question. So there's a split screen, did they want split screen or just the inside?
So the notice reads, we'd like to replay the full clip of when the car pulls in front. So they don't really reference what frame of view. We can send a note back and clarify if we'd like, or we can play the one of the driver angle.
Yeah, so I think we need.
Has to be the switch screen, and that way, that's the only way you're gonna know when the car pulls in front. So if it's split
Okay.
screen, you can.
Okay, well, we can play the split screen slow.
Oh, there's a split screen version.
There's the split screen version.
Let's do that.
Okay.
So if there's a split screen version at half speed, Mr. Wright?
If ultimately that's the way to get it played at half speed, then I would not have an objection. Because they haven't specifically asked for split screen, I would almost ask that of them, but if ultimately the state's saying that the only real way to play it is.
No, that's not what I'm saying. I'm saying I can play both versions at half speed.
Right, we don't know which camera angle they've requested.
I would ask, I'm not trying to belabor it, maybe we could get that clarification.
We'll put this in writing. Can I get a comparable notepad, Deputy, if you got one back there?
You want a different?
Do they have an extra notepad back there, a blank one, or if not, just a couple pieces of paper?
I get you.
Sure.
Does anybody else still
Yeah,
use
go through the stickers
paper
today.
and pen for notes, despite there being 1,000 million apps that could do the same? Because I'm never without this.
All right, so I'm going to Marcus Courts Exhibit 6. Can you specify which camera angle you would like to review?
And I even have, like, you'll see I write court stuff in here, because once I write it down, it's like it's added to the vault. If I don't write it down, it's not added to the vault. And I can't type it, I need to write it. It's got to be like.
Everyone wants to see it? They can.
No, I trust the judge.
Yeah.
Feel like we've been doing this for a while now, you know?
Yep. Yep. Evie, it's gotta be like, so while they do this, I'm just gonna mute them. And I'll put the closed captions on the screen so that we can see them a bit bigger. Hello, where did they go? Somebody speak. Okay. So this is a serious conversation. I need to be like this rather. Serious conversation. Here are my prerequisites for the ultimate note-taking system. 1, the notebook must be ugly, because if it's pretty, I'm going to want to write pretty all the time. And if I can't write pretty, I'm going to land up abandoning it and be upset. Alternatively, it can be pretty, but it shouldn't be expensive. I'll show you now. Classic example. Can you read that? Is it too small? It says, focus, my second favorite F word. Third thing, you need a pen that you love writing with, that makes your writing, that writing is just like super nice. I use these retro ones. They are cheap. I'm the kind of person that uses pens until they're done. And if I find a pen I like, I'm gonna try to get 1 million of them. So that's the main things. And then this has to, I've got to like keep it in the exact same spot, no matter what. It has to be on my desk, because if I move it from my desk, then I forget. What was the other thing I just thought of? Oh, if you guys have typo where you live, which I don't know if you do, they've got in this, like this is the F word thing, they've got these little, this. So then you can throw all your lost notes in and keep it in the same book as the other one, like as the rest of your notes. And if all else fails, what do you call this? I think it's blue tack in the UK, but I don't know what it is in the US. I stick things everywhere. Yes, they should be as cheap as possible and nice paper to write on. That's the thing. Like guys, I'm not even joking. I have a box in the garage of notebooks. But on top of that, hold one sec. On top of that, I have this cat one, which is currently a mouse pad. I showed you the focus one. Then I've got this lemon one. The pages don't write nicely, so it's like a substitute. Oh my gosh, I can't find my notebook. And then I just, whatever. Then I've got a small one. And another small one. And another small one. And another. And one without any cover. Why? I don't know. Maybe it'll come in handy one day. Then I've got Shake Your Pom Poms because it was cute. Never written anything in it. Girls Can because it was pretty. Never written anything in it. This, I think, was going to be a novel. I think this has to do with my novel. But I don't remember. So I guess I'll never know. Then I've got full page ones. I don't like the size of these, and I don't like the paper. This one apparently has poems in, though. And then I have this one that says, I was crafting before it was cool. No back page. Also has me explaining probably some kind of TikTok gossip drama thing to Vaughn. Anyone know who Kenna, Scotty, Ledger, who they are? Somebody has boobies, 2 boobies on them. And then I have a January to-do list that was from 2019. I've got a meeting from 2023. I've got passion projects I forgot about. No idea what this is about. And then I got bored of this one. So these are just the ones that are easily accessible. The others were too pretty and I gave up. I just knew I wasn't going to use them. They were too pretty. So now they can be too pretty in the garage. For what reason? I don't know. Just tack. Sticky tack. We call it press stick. Also Notepad++ when I use PC. It's not available for Mac. Oh, but you see, I can't do that. I use Toby, which is great. It's a plugin. I think I shared it before. But I can't. If I use a note-taking thing on my phone, I will reiterate it in handwriting. Yeah. The amount of things that may come in handy. I've got another one right here. A USB fan. I mean, oh, guess what's in this drawer as well? More notebooks. Don't even remember what's in them. Just close the drawer and pretend it doesn't exist. Oh, whoopsie. We'll just do that. Yes, it's a thing. I've had enough fans for a whole year. Well, it's winter here, so thankfully. Ah! Wait, guys, I never saw that part of the video. How many times did you see that? How many times did I show that? Now the mids are wearing off. Yeah. I think they wore off when I potentially came back on the first time. No. So you saw the over and over? No, I did not. I saw a lot of the back and forth. Wow. Okay. Let's see what's cracking there then. We have no audio on their side.
Of this, I'm trying to get.
Oh, miniatures. I've got a whole miniature thing that I started. You know, those like, you could buy the little rooms and it's like a puzzle and you can glue it together and whatever. I started it, but alas, it is in the cupboard with my puzzle phase, my activity book phase.
Because you are in fact guilty.
That's rude. I am not guilty.
In indictment number 23 SC 190439, how do you plead?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Judge, could I just have a moment?
I can clarify the counts if you want me to. Okay. Without me having the facts in front of me, no. Okay, I'm sorry.
I'm sorry, Judge.
I'm sorry, I'll ask this again because I can't remember if you answered. Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes,
Do you understand that you may have only a limited right to appeal this guilty plea conviction?
yes,
I
Do you
don't think-
understand that unless counsel is substituted or permitted to withdraw? I'm sorry.
I don't think this is related, right? I think this is them carrying on with things. That was weird.
Last one, Judge.
I'm waiting to hear, do you have a verdict? And then I'll do the things.
All right, thank you, Deputy Scott. Members of the jury, we received your question, which was, what is the legal definition of an abandoned and malignant heart? To that end, I will charge you with the following, with some additions. The killing must have been done with malice to be murder. Malice, as the term is used here, is not necessarily ill will or hatred. Rather, it is the unlawful intent to kill without justification. You may find express malice when the circumstances show that the defendant.
I'm pretty sure this is the exact same thing we've been watching the whole time, guys. You're confusing me. Yes, there it is. State v. McKinley. State v. McKinley. I think it's the same thing. You're confusing me.
The defendant acted with the deliberate intention to unlawfully take the life of another. You may also find implied malice when there does not appear to be significant provocation and all the circumstances of the killing show an abandoned and malignant heart. Implied malice is a term which has been defined to mean conduct exhibiting a reckless disregard for human life. Extremely negligent conduct, which creates what a reasonable man would realize to be not only an unjustifiable, but also a very high degree of risk of death or serious bodily injury to another or to others, though unaccompanied by any intent to kill or to do serious bodily injury, and which actually causes the death of another, may constitute murder. Reckless disregard for human life may be the equivalent of a specific intent to kill. Any objections to the charge from the state?
No, Your Honor.
Mr. Wright?
No, Your Honor.
All right, with that, members of the jury, I'll ask that you resume your deliberations.
Right for the judge.
Okay.
That would disrupt the proceedings.
I'm going to put the time that they went out in chat so that maths people can maths. in the meantime, if so, I want to. Oh, wait. What I was going to say is I can put on, after this, I can put on Judge Fleischer, but I will not be here. Here. I can keep an eye, but I won't be active. And if you're all heading out, then I won't, and I won't be offended. It's 8, so 2-ish hours. And also, if my mods are dunsies, then you guys can message me on Instagram if you're dunsies, and I will act accordingly. Why is this taking so long?
Whenever you go back there, there's an extra one.
Wow, it's close up.
You ready, Ms. Smith? All right, let's go back on the record with State versus McKinley Johnson. I've been informed that the jury has reached a verdict. And before we bring the jury out to publish that verdict, I do need to advise everyone in the courtroom today that while we recognize that there are emotions involved in every criminal case, we can't have an emotional reaction that would disrupt the proceedings. And so for anyone here today who thinks that they may not be able to receive this verdict without such a reaction, I would ask you to step out now. And if there is any kind of reaction, we would have to have you escorted out. And so with that advisement, I would thank you all in advance for your cooperation on that. So we can bring in the jury.
Okay. So first things first, end the poll. And after, somebody do the maths, please. 7 7 0 0 7 dot dot 0 0 dot dot 31. So 2 hours, 50 minutes, 28 seconds to 7 hours and 51 seconds. This is when you see the lag time on what is happening on my side and your side. 4 hours and 10 minutes. After 4 hours and 4-ish hours, the jury is back. None of us can do maths, but that's okay. We don't have to.
Judge President,
Thank you, Deputy Scott. Members of the jury, I've been informed that you have reached a verdict. And so I would ask if the foreperson could hand that verdict form to Deputy Scott so that I can make sure it's in order.
Our verdict was not unanimous. 82% guilty, 11%
All right. And if
lessers.
the foreperson could identify
5
themselves.
not
All right. And ma'am, can you remind me of your jury number? All right. So juror 34, were you able to reach a verdict? And was it unanimous? And is the verdict form that I was just handed filled in, signed, and dated by you? All right. I'm going to hand this verdict form back to Deputy Scott, and I would ask you to stand and publish this verdict to the courtroom by reading it in its entirety.
As to count 1 murder, we the jury find the defendant guilty. As to count 2 felony murder, we the jury find the defendant guilty. As to count 3 aggravated assault, we the jury find the defendant guilty. As to count 4 aggravated assault, we the jury find the defendant guilty. As to count 5 aggravated assault, we the jury find the defendant guilty. As to count 6 battery, we the jury find the defendant guilty of battery. As to count 7 possession of a firearm during commission of a felony, we the jury find the defendant guilty.
All right, ma'am, if you could hand that verdict form back to me. Counsel, if anyone would like to inspect the verdict form, I have it available here. Starting with the state, I would ask if there is any objection to the form of the verdict, or if there's any reason this jury cannot be excused.
No, Your Honor, it's both.
All right, Mr. Wright.
No objection, but we would ask to poll the jury.
All right. So members of the jury, what we're going to do now is we poll the jury, which means that I'm going to ask each of you one by one 3 questions, which is if that was your verdict in the jury room, if it was freely and voluntarily made, and if it is still your verdict. So beginning with juror number 1, you can just raise your hand. Thank you. Ma'am, was that your verdict in the jury room? And was it freely and voluntarily made by you? And is it still your verdict? Juror number 2, was that your verdict in the jury room? And was it freely and voluntarily made by you? Is it still your verdict? Juror number 6, sir, was that your verdict in the jury room? Was it freely and voluntarily made by you? And is it still your verdict? Juror number 8, ma'am, was that your verdict in the jury room? Was it freely and voluntarily made by you? And is it still your verdict? Juror number 13, was that your verdict in the jury room? Was it freely and voluntarily made by you? And is it still your verdict? Juror number 15, was that your verdict in the jury room? Was it freely and voluntarily made by you? And is it still your verdict? Juror number 17, was that your verdict in the jury room? Was it freely and voluntarily made by you? And is it still your verdict? Juror number 21, was that your verdict in the jury room? Was it freely and voluntarily made by you? And is it still your verdict? Juror 23, was that your verdict in the jury room? And was it freely and voluntarily made by you? And is it still your verdict? Juror 25, was that your verdict in the jury room? Was it freely and voluntarily made by you? And is it still your verdict? Juror 34, was that your verdict in the jury room? Was it freely and voluntarily made by you? And is it still your verdict? Juror 38, 38. Was that your verdict in the jury room?
Yes.
Was it freely and voluntarily made by you? And is it still your verdict? All right. Members of the jury, at this time, I again want to thank you for your service. If anyone wants to speak with you now about your deliberations, that's completely up to each of you. There is no requirement going forward that you do so, but there's also no prohibition against you doing that. Once you're released from your service, you're certainly free to talk about this case with anyone, including counsel. And oftentimes, counsel will want to come back in the jury room after a trial to speak with you, to know if there were particular aspects about the case that played a part in your deliberations, just to learn more about the process that you all went through. And so in just a moment, when I excuse you, I'm going to take a step back just to thank you very quickly for your time. And then I'm also going to see if anyone would be willing to speak to counsel, since they usually want to take advantage of that opportunity. So with that, with the thanks of this court for your service, you can be dismissed.
Last one, yours.
Okay, I'm going to end in 1 sec. I'm just getting a thingy-majiggy.
All right, before we go off the record briefly, I would ask the parties if there's, I know that there are a lot of members and interested parties in the gallery here today. Is there any reason we should not proceed to sentencing in this case?
No, you know.
All right, Mr. Wright.
Whoa.
Yeah, I think there are mandatory, it's mandatory sentence that the court's gonna have to impose. So I'm not sure if there would be any reason to delay sentencing. And I was just reasoning through it in my mind, but I believe we can proceed today. So I don't think delaying is gonna change ultimately the court's ability during sentencing.
All right, and did either counsel want the opportunity to speak with the jury before we proceeded into sentencing? Okay, Mr. Wright.
Yeah, I would like.
Okay, I will go back there briefly and ask them if they want to take advantage of that. And I would imagine we'd break for no more than 15 to 20 minutes, just so I answer the questions. Mr. Lee?
I'm open. If they have questions for me, I'm open.
Sure, I'll let them know. All right.
To dismiss that count, we are not.
I just want to skip to a sentence.
And also ask for mercy so that her son can earn parole when it's appropriate, according to corrections.
Mr. Wright he's not required to in any way, but would Mr. Johnson be interested in making any kind of a statement for the record as well?
Yes, Your Honor.
Oh.
You want to podium? You want to take that?
My name is McKinley Johnson. First and foremost, I want to apologize to the family. I want to apologize to Richard Antoine for the way that he left this world. I just don't even know what to say. This guy, he got, it's two separate minds. You know what I'm saying? I'm sorry that I wasn't paying attention to him. I'm very sorry from the bottom of my heart that any of this happened. Like I said, I could have kept going, but at the same time, I didn't know that that would lead to anybody dying. A traffic situation is never that serious for anybody to lose their life. I just asked the family that y'all forgive me. I asked my mom, everybody that I let down with this situation to forgive me. And my lawyer said, it ain't no win for nobody. Everybody lose. His family, me, my family. The guy that shot this man, his family, everybody lose. Ain't nobody win. Don't nobody win. I just want the family to know that that's not the type of person that I am. I don't kill people. That's not me. You know what I'm saying? That was the first time anything happened like that in my life. You know what I'm saying? I just asked y'all take into consideration that I didn't shoot him. I didn't advise this man to shoot him. And I wasn't paying attention to him. I just asked the family again and again and again to forgive me. I put myself in y'all's shoes every day. I could have been one of my people out there. You know what I'm saying? What if I would have died? What if he probably would have had every right to do what he would have done if it would have happened that way? You know what I'm saying? In that situation, everything happened fast. I didn't know what this guy was capable of. I didn't know he would do that on a public road. You know what I'm saying? Just shoot somebody on a public road. I just asked that again that everybody forgive me in this situation. My family, his family, even the guy who killed him, his family. You know what I'm saying? It should never happen like that. That man shouldn't have lost his life in the way he did. You know what I'm saying? I again ask the family that y'all forgive me. Punching them is one thing, but shooting them is a whole different. It's different. That's not what I do. I go to work, I come home, and play the game, or you know what I'm saying? Like that shouldn't happen. I shouldn't even been involved in a situation like that. But it could have been avoided if I would have kept going. You know what I'm saying? I didn't want to bring it this far. I just know I didn't kill him. I didn't kill him. I punched him. I threw some punches. I didn't kill him though. But I just know that when it comes to your loved ones, there's no understanding. You know what I'm saying? So I just ask that y'all forgive me. I asked y'all, my mom, everybody in here, in this courtroom that's watching anywhere to forgive me. You know, That's all I'm asking for is forgiveness. I apologize to everybody in this situation that lost. To everybody.
Anything further, Mr. Wright?
No, Your Honor.
The state has a right to rebuttal. Mr. Lee, anything that you would add?
No. Yeah.
Well, thank you, counsel. I believe this case, although brief, has been capably tried by all sides, and that the jury was able to get to the core of it and to decide it on its merits. For the family members here in support of Mr. Antoine, I would say that just two thoughts, which is there's no question, as you've said, that this grief will continue for a long time if it ever ends. But I hope that this process has allowed you to get one step closer to that day where maybe it's not so overwhelming. And by that same token, that now that this process has reached a conclusion, that instead of being forced to watch that video and over and again, that you can remember him not in his last moments, but in all those moments you highlighted for us at the hearing today, because those are the things that you want to keep in your mind's eye, because those are who he really was. And Mr. Johnson, I think you've started down the path of acknowledging the role you played in this and accepting that responsibility. And I hate that it took a jury to get to that point. I think that our purpose throughout this process was to make sure that your right to a jury trial was offered and that you were able to take advantage of that. And like I said, though, I think that leading up to this point, again, it might not have needed to take 12 strangers to tell you the level of culpability you had in this case. Maybe not the same as Mr. Spears because you didn't hold the gun, but all too often in life, it's a series of chain reactions. And I know that you're now going to have a lot of time to think about that. Just on a practical level, I'll point out that in my conversations with members with the Department of Corrections, that a life sentence, unless it's a consecutive life sentence, life followed by life, the Department of Corrections interprets life with any number of years tacked onto the end of it to be the equivalent. So whether we tack life plus 60 or life plus 5 or life by itself, my understanding is the parole board will consider it for parole after 30 years, that life is life. And regardless of that, I don't see in this case the need to send the message to the parole board that this court is trying to place its finger on the scales in any respect. I think that I leave it to the decision of the parole board of whether Mr. Johnson has turned himself around by the conclusion of his sentence, whether he has expressed the right remorse, and whether the members of the victim's family, what they have to say when that time comes. And so on that point, I believe the appropriate sentence in this case would be, as partly recommended by the state, on count 1 of malice murder, the sentence will be life. Counts 2, the felony murder, will vacate by operation of law. Count 3, also at the request of the state, would vacate by operation of law. Count 4 will be 20 years to serve concurrent to count 1. Count 5 will be 20 years to serve concurrent to count 1. Count 6 on the battery misdemeanor, the sentence would be 12 months to serve concurrent to count 1. And count 5 would be 5 years to serve consecutive to count 1, but that would be suspended. The defendant will receive credit for all time he's already served in pretrial detention. And for the suspended portion of the sentence, I would add the special condition that he's not to possess any weapons or have any contact with Mr. Spear. Are there any further special conditions, Mr. Lee, you would ask for this sentence?
No contact with his family.
I agree, and we'll have that on there as well. Mr. Johnson, I have a few things I have to advise you of. You have the right to seek post-judgment relief from your conviction of these crimes by either making a motion for new trial in this court or filing an appeal to a higher appellate court. If you want to file a motion for new trial or an appeal, you'll need to file that motion or notice of appeal.
Okay, I think we're done there. Yeah, life with parole because it's life and then concurrent and consecutive. It's like life with a bunch stacked on top. Yes, I think it's parole after 30 years, but he's 24. So he could turn it around. Oh, I've got to try licking on my lips. Okay, so here's the deal. I'm going to portal you over to Judge Fleischer. The mods have been working really hard for 7 hours, 23 minutes. I'm going to be watching chat on my phone. I'm not going to be listening to Fleischer, but behaving would go so far because I'm less tech savvy than the two of them. I might accidentally delete you, block you. I don't know. Anyway, if you're heading out, thank you so much for hanging out. If you're in the US and you're heading out, happy Independence Day. I nearly said something so rude. My brain, I nearly said, I hope you one day find freedom. But that's just my brain. It's just a joke. I'm sorry. Okay, let's head over to Fleischer. I will see you there in 1 minute.